Check 1, 2.
Yes, sir. I was gonna say, it didn't say what room, but this is the one I'm usually in, so. Jill Blesky. Blesky, yeah.
During the hearing, you can't hear anything, you just slow down, anything, you'll just let us know.
The Judge Park? Okay. Just make sure you got the right name and the right spot.
I did this one. Morning, how's Nancy?
Oh, right.
Now, these transcripts were expedited to the church.
24?
Check 1, 2.
Does that sound right?
I believe so.
Check. Check 1, 2.
Have a list of witnesses, is that what?
Like, have a list of witnesses?
Yeah, I didn't look into it.
I have a list of witnesses. And here, we'll go through this real quick. This is, we added one witness out of order on the 12th, starting here, the 15th. You'll see, witnesses listed starting here
go on the record. Today is April 15th of 2024, and the current time is 9 a.m. This proceeding before the Missouri Public Service Commission today is being held in room 310 of the Governor Office Building, which is the Commission's headquarters. The Commission has set aside this time today for an evidentiary hearing in the matter of the petition of Union Electric Company doing business as Ameren, Missouri, for a financing order authorizing the issuance of securitized utility tariff bonds for energy transition costs related to the Rush Island Energy Center. And that is file number EF 2024-0021. My name is John Clark. I'm the regulatory law judge who is presiding over this hearing today. The Missouri Public Service Commission is composed of 5 commissioners. Our current chairman is Chair Kayla Hahn. We also have Commissioners Maida Coleman, Commissioner Jason Holzman, Commissioner Glenn Kolkmeyer, and we just had a new commissioner appointed, and I don't off the top of my head know what his name is. So, John Mitchell, Mr. Keevil is telling me. So we have a new commissioner that I have not met yet. The commissioners, I saw Chair Hahn this morning. The other commissioners will either come and go as they please or join by WebEx.
I'm here, Judge, Commissioner Holzman, and I'm on my way in.
Okay, thank you very much, Commissioner Holzman. And Commissioner Holzman, as you heard, is on his way into the building, but is currently joining us online. At this time, I'm going to ask counsel for the parties to enter their appearance for the record, starting with Ameren, Missouri.
Wendy Tatro, 1901 Choteau Avenue, St. Louis, Missouri, 63103.
In your honor, Jim Lowry, also for Ameren, Missouri. I entered my appearance on Friday.
Ms. Tatro, Mr. Lowry, thank you very much. And just so everyone is aware, well, this was slated to be the first day of the hearing. We did take one witness out of order on the 12th of April, and that is what Mr. Lowry is referring to. For the staff of the commission.
Yes, Judge, appearing on behalf of the staff of the commission, Jeff Keevil, Nicole Mers, and Travis Pringle. Our address is Governor Office Building, Suite 800, 200 Madison Street, P.O. Box 360, Jefferson City, Missouri, 65102.
Thank you, Mr. Keevil. On behalf of the Office of the Public Counsel.
Thank you. Nathan Williams, Chief Deputy Public Counsel, appearing on behalf of the Office of Public Counsel and the public. Our address is Governor Office Building, Suite 650, 200 Madison Street, P.O. Box 2230, Jefferson City, Missouri, 65102.
Thank you, Mr. Williams. On behalf of Midwest Energy Consumers Group, or MECG.
Good morning, Your Honor. Tim Opitz on behalf of MECG.
Thank you, Mr. Obitz. On behalf of Missouri Industrial Energy Consumers.
Diana Plesha on behalf of MIEC.
Thank you, Ms. Plesha. On behalf of, well, Natural Resources Defense Council is asked to be excused from proceedings, and that was granted. On behalf of AARP.
Good morning, Your Honor. I'm John B. Kaufman. I'm appearing on behalf of AARP as well as the Consumers Council of Missouri.
And thank you, Mr. Kaufman. And Sierra Club had also requested to be excused from today's proceedings, and that was granted. Now I want to briefly discuss preliminary matters. As the first preliminary matter today, it's my understanding from Mr. Lowry that there were witnesses that were inadvertently left off issue 3. Is that correct?
That's correct, Your Honor. Issue 3A.
And what witnesses are those?
That's Mr. Reed, who we would suggest go after Mr. Moore on behalf of the company. The other witness is Mr. Michaels, who also appears on 3B. Mr. Michaels' testimony doesn't really deal with the substance of the NSR permitting issues per se, and the suggestion that I had made was he takes the witness stand first on 3B, maybe for efficiency, that We just have him come up on that issue, and any questions that would hang over on the harm issue from 3A could just be asked then, just to make the hearings a little bit more efficient.
Okay, let me ask, were the other parties, at what point did they come to be aware that there were witnesses inadvertently left off?
It was last week when we had email correspondence among the council about this topic.
Was that on Friday?
I think it was before Friday, but I can't swear. I believe it was either Wednesday or Thursday we had correspondence about it.
Okay, are there any objections to adding these extra witnesses?
Judge, certainly not, and it was clear to public counsel from the time of the filing of the testimony or thereabouts that Mr. Reed would be testifying on this topic.
Judge, I just have, may I inquire of Mr. Lowry regarding this?
You may. Is your microphone on, or?
Yes, but I'm not sitting close enough to it for it to work. You know me, I'm very soft-spoken and quiet. So. Jim, on Michael's, are you moving him off one issue into another issue? What was the thing about he doesn't testify on this issue?
I'm not moving him off. There's a sub-issue on 3A that says if there was any imprudence, was there any harm? And then 3B really gets into the was there any harm on the retirement versus retrofit decision. He doesn't really have any testimony on 3A about, should we got insert NSR permits, all of the technical issues. I just thought it might be more efficient to just have him take the witness stand once. It can be done twice, but I just thought it might be more efficient. And then questions about harm related to any hypothetical, from our perspective, hypothetical imprudence can be asked altogether at that time. That was just the suggestion.
I have no problem with that. Are there any objections from council? I hear none.
Just for completeness, Judge, OPC also has a witness that needs to be added to an issue. That's Ms. Shaben on issue 9. And I, like Mr. Williams, knew probably from the beginning that she should be on issue 9, but we just didn't get it done when we were doing the word processing, essentially.
And Mr. Williams, is that after majors, or is that at a different order in that issue?
I believe after majors.
Okay, thank you. As another matter, MIEC's attorney emailed and requested that MIEC be permitted to make its opening statement as a mini opening when issue 17 is heard, because that is MIEC's only issue in this case. Are there any objections to that? Okay, then we will do that at that time.
Judge, I don't know if this might still be on your list, but just to bring it up, I had emailed you and the other parties, and we had correspondence with the other parties about this probably mid last week about issue 15, the DOE loan issue last week. Yeah.
That is on my list
Okay.
to get to.
Sorry.
In regard to
Jumped the gun
Renew
on you.
Missouri. No. That is fine. I mean, I do not claim to be perfect in any way, shape, or form. So if I forget something, please bring it to my attention. But that is on my list of things to deal with. Now, Mr. Kaufman, you had a preliminary matter you wanted to bring up as well?
None other than just that I may need to leave the proceeding at certain points. I may not have an interest in some of the issues as the week progresses, and wondered if there was, if Your Honor would desire me to make a motion to be excused, or otherwise, I'm willing just to accept the fact if I'm not here, I'm waiving cross or any rights I have for not being here at any point during the week.
And that is fine with me. I know that your interests are somewhat more limited from the larger. So if you wish to be excused for any portion of this, you may be. If you are not here, then you will, of course, waive your right to ask questions in regard to that. So,
Understood.
all right.
Thank you very much.
And Mr. Linares, you had a similar request, I believe, on behalf of Renew Missouri?
Yes, thank you, Judge. Yeah, I would make the same request as counsel for Consumers Counsel. I plan to make an opening today and be absent for the rest of the hearing if that's permitted.
Okay, is that for Consumer Counsel or for Renew or for both?
That's on behalf of Renew Missouri.
Not on Consumers Counsel?
No, I was just making reference to Mr.
I follow. I'm
Kaufman's motion.
sorry. momentarily got confused. That will be granted under the same circumstances.
Thank you.
And then finally, well, let's go ahead, since I've got Renew up, and address the Department of Energy loan issue, which I believe is a Renew-specific issue. And Mr. Linares, I had a
Yes.
difficult time understanding from that. And there was nothing about the way it was worded. It's my understanding that the parties have agreed to waive cross on Mr. Owens. Is that correct?
Well, I believe most of the parties have. There's a couple of parties that have not weighed in there, or at least not to my knowledge. And there were a couple other witnesses, Murray and Robinette, that were also in that camp on that issue. I believe this is issue 15.
Mm-hmm. Is there anybody who wants to address that?
I mean, any party that had testimony in the issue did, in fact, affirmatively indicate amongst counsel that none of us had any questions and cross could be waived. And I believe that under Mr. Linares' position statement, they raised the issue. They basically said, look, based on what we now know, we don't recommend any further that you even pursue the DOE option. So there really isn't an issue, I don't think, anymore, but certainly the parties don't have cross. And so we thought, we can skip the issue and, save a little hearing time. We have 21 issues and we're probably going to need it.
Judge Nathan Williams for Public Counsel.
Go ahead, Mr. Williams.
Our position was that we would waive cross if the commission has no questions. So we view that it would just stand on the pre-filed testimony unless the commissioner has questions of these witnesses about this issue.
I don't believe there are any questions contemplated at this time. Are there any parties who are unwilling to waive cross as to the issues for issue 15, which again, the issue is, should Ameren, Missouri issue securitized utility tariff bonds to the U.S. Department of Energy under the Energy Infrastructure Reinvestment Program or issue the bonds in the customary matter to public investors? So is there anybody who is not waiving cross on that? Obviously under the conditions you indicated. All right, I see no one. And that brings me to the second portion, which Mr. Lowry had mentioned. Is this still a live issue for Renew Missouri? Because are you asking to stand on the testimony, or is this an issue that's being withdrawn? And the reason I'm asking is because the email I received, it was difficult for me to understand in that regard.
I'm happy to clarify my position here, Judge, and the company or anyone else can weigh in. I plan to address this issue in my opening to add some clarification to this issue. I think it can be a issue for consideration when we're dealing with securitization in the future, in future cases. We do not intend to press this issue here in this case, but I do want to address it at least in my opening and entertain any questions at that time. But we do not have any cross around this issue and no further issue to press there.
Okay, and I can certainly understand wanting to keep it for future securitizations. Is it something you want the commission to consider in this case? I mean, if it's a live issue, it's a live issue.
I believe we should keep it as a live issue, but I'll have a recommendation around it.
Okay, so it'll be a live issue that basically stands on the pre-filed testimony.
Yes, correct.
All right, thank you. There were some motions to strike back and forth that were done before this hearing. It is my intent to take those motions with the case. Are there any other preliminary matters that need to be addressed by the commission at this time?
Judge, I do have a question, given what you said about the motions to strike, because there was certiorari rebuttal associated with one or more of those motions?
That is correct.
So your intention is not to rule on the admissibility of the certiorari rebuttal until the end of the case? I'm unclear.
I am going to allow the parties to talk about the things in the testimony that is being questioned, but that is going to be subject to the objections that have been filed. So ultimately, if that testimony is struck, it is struck. And I know that may seem like a rather unusual way of doing it, but that is the way we're going to be doing it for this.
Okay, I just find it a little awkward on cross-examination of certiorari rebuttal.
I understand. We're just going to have to deal with these bumps in the road as we approach them.
Well, Judge, if I might, honestly, I thought this is probably what you would do, so I didn't find it unusual. But I think what you're saying is the testimony can be offered. It's going to be maybe provisionally accepted, subject to ultimate ruling on the motions to strike and on the objections. And if you were to sustain the objections to the certiorari rebuttal, then it wouldn't actually come in at the end of the day. If you sustain the motions to strike, that testimony will be stricken, and those items actually wouldn't form the basis of any commission decision. But in the interim, we're going to have testimony and full cross-examination on those issues. Is that correct?
That is correct. And you used the term that I generally like to use. I did not use it here, which is provisionally admit, and that's because some parties sometimes take issue with that. But that is correct.
Okay, just want to make sure I understood. Thank you for that clarification. I had one other, I don't know that this is really a motion, but I guess I just wanted to advise the commission of what I intended to do. There will be some exhibits in cross-examination that are not part of the record that, we will mark and show the witness and lay whatever proper foundation and, kill a lot of trees and have the copies for everybody. There may be others where the exhibit is a schedule to somebody's testimony or otherwise in. I did not make copies of those. I didn't intend to kill any trees on those because they should be available to the commissioners and yourself through EFS. Is that okay?
That is absolutely correct, and that is kind of the direction that we've been shifting, is if these things have already been filed in the case and just have not been admitted or addressed, then yes.
Thank you.
Are there any other preliminary matters that need to be taken up at this time?
Judge, I don't know that you need to take it up at this point, but I just want to raise it in case, I believe Friday, Ms. Mers requested that official notice be taken of the transcript that has been filed in the record in several places, but not as an exhibit and not as evidence. And I was just going to say, when she said take as official notice, I don't think staff would have an objection if you want to take it as a, if you want a hard copy of it or something, but since it's already in the record, that was basically why we said official notice of it. It would be, I was wondering if you were going to rule on that today or hold that for the hearing on exhibit, or excuse me, issue 3 or 5 or whatever issue that prudence issue is.
I'm honestly not sure. I am unsure. You were talking about the district court transcript, correct?
Yeah, I believe it was the transcript of the hearing on March 28th that the judge ordered Ameren to file with the PSC.
I'm going to defer on that for the moment. I am not sure of a mechanism by which the commission could take official notice of a transcript that is not ours, that is another court. It has been filed in the case, but I don't believe it's not part of the record, certainly in that it hasn't been admitted. So I've been kind of struggling with that.
Judge, public counsel has no objection to its admission.
I think it's certainly admissible, Judge, whether you want to call it.
Well,
official.
admissible and taking notice are two different things.
I was going to say, if that's your hang-up, don't let that be your hang-up. We'll go however way you want to admit it. We'll be fine with it. We just want it admitted as part of the evidentiary record.
Okay, well, then I would prefer it be offered at some point. All right, are there any other preliminary matters that the commission needs to take up at this time? And thank you for reminding me of that, Mr. Keevil. That had slipped my memory momentarily. All right, I'm going to issue 2 reminders right now. One is, if you have a cell phone, please be sure it is on silent or vibrate so it doesn't disturb these proceedings. And the second one is, there's a fair amount of confidential information, and I expect some of it to come up almost every day of the hearing. I'm not going to be aware of what all that is. The attorneys will have a better awareness of me, and the witnesses will have a better awareness of what that is than I do. So So if we look like we need to go in camera to address something, or we're approaching an area where it's beginning to look like we might, if somebody could bring that to my attention, then we can address that and proceed in camera, okay?
Judge, if I might, in that vein, it's come to my attention that Ameren, Missouri apparently filed some materials that it had were part of the federal court proceeding that have been marked confidential in that proceeding, but are not confidential in this one. And I believe staff has marked some of its testimony as being, I believe, probably schedules and maybe testimony too is confidential, thinking that it was confidential because it was marked confidential in the federal court proceeding, but Ameren, Missouri is not treating it as confidential in this proceeding. Just want to bring that to the commission's attention.
Okay, when that evidence comes up, why don't we address that then? Now, as I indicated before, we took one issue out of order on the 12th, and we had some many openings that were given in regard to that, but today is the first day of the full hearing, and the parties have requested to do kind of an overall opening statement, is my understanding. And with that in mind, I'm going to go ahead and proceed with opening statements. And I believe the first opening statement is from Ameren, Missouri.
Good morning, and may it please the commission. My name is Jim Lowry. If I can get this, I can actually pick up my voice. Jim Lowry, and along with my colleagues Wendy Tatro and Nash Long, I will be representing Ameren, Missouri in this securitization docket related to the Rush Island plant. Before discussing the issues and evidence, some of them at least, I'm not going to hit all of them, I want to briefly touch on the securitization statute and a couple of the provisions that apply specifically to this case. The General Assembly enacted the securitization statute, Section 393-1700, in 2001. The statute was enacted to expressly provide to the securitization of costs associated with either a retired or a to-be-retired electric generating plant. Asbury was a retired plant when you decided that case, and Rush Island is a to-be-retired plant to retire by October of this year. As also contemplated by the statute, there are three buckets of costs at issue in a case like this. The first bucket is energy transition costs. That's generally the largest bucket. It holds the undepreciated investment in Rush Island, for example. The second is upfront financing cost, and the third are ongoing financing cost. What falls within each of these buckets is defined with some specificity by the statute. Only the first two buckets actually affect the principal amount of the bonds that the company is asking you to issue. As between the staff and the company, there is, in relative terms, not much daylight between the amounts that are recommended to include in the principal of the bonds. The company recommends $514.9 million. The staff recommends $497.5 million, about $17 million less. And that difference arises from three issues. Issue 4B on the issues list, issue 13 on the issues list, and the last one, issue 9, is worth about $4 million. And on that one, there's not a dispute about whether those costs should ultimately be recovered. The question is, should they be included in the principal amount of the bonds in this case, or should they just be recovered in a rate case? So about $17 million out of around $500 million. So pretty close from a staff and company perspective on that. OPC, by taking a variety of positions, argues variously that less than $325 million should be securitized, or alternatively, that none should be securitized at all. OPC's none at all should be securitized position, if taken to its logical extension, would mean that the General Assembly completely wasted its time in 2001 enacting a securitization statute to apply to retired generating plants, because no utility could ever meet the requirements of the statute. Such a result would violate basic principles of statutory interpretation. To conclude that the General Assembly wasted its time when it enacted this statute would lead to unreasonable, absurd, and illogical results, and I think that alone lays bare the fallacy of OPC's position on this. Now, as discussed when the hearings began virtually on Friday, there is another matter of controversy in the case, that is relating to Ameren, Missouri's NSR permitting decisions 15 or 20 years ago, and arising from claims that have been made around its 2021 decision to retire the plant instead of retrofitting it with hundreds of millions of dollars and perhaps $1 billion of pollution control equipment, in other words, scrubbers. I submit to you that the totality of the record in this case will demonstrate that Ameren, Missouri acted prudently when it made its NSR permitting decisions, that it acted prudently, when it made its decision to retire the plant instead of retrofitting the plant, and that in both cases, its decisions have been in the best interests of its customers. Now, as for the NSR permitting issues, it's no secret that in August 2021, the company lost a lengthy battle with the US EPA over whether the company should have sought NSR permits for certain boiler component replacement projects done during maintenance outages at Rush Island in 2007 and 2010. I'll omit discussion of the technical aspects of NSR permitting. You heard quite a bit about that Friday. You're certainly going to hear more about it, I'm sure, later today or tomorrow. But I want to say now a few things about the evidence in this case, which I think is largely undisputed and that I would contend overwhelmingly shows a few things. First, that Ameren, Missouri, its then Illinois affiliates, and the industry as a whole, prior to and at the time of the 2007 and 2010 outages, routinely undertook the same kind of boiler component replacement projects, and they did so without first obtaining NSR permits. That's the context at the time. Second, that none of the projects changed the unit's maximum hourly rate of emissions at maximum load. In other words, did not increase potential emissions. Third, that the Missouri Department of Natural Resources and the experts advising Ameren, Missouri at the time on NSR matters all believed that under the Missouri State Implementation Plan, which is MDNR's regulation governing NSR permitting, approved by the EPA and that governs the permitting, that because of the undisputed fact that potential emissions would not increase, an NSR permit was not needed regardless of any other aspect of the rules. That alone would have exempted the projects. And the evidence shows that when the federal court later ruled that Ameren, Missouri, and MDNR and the experts were all wrong about the law, the court relied on facts, data, and case law that arose after the Rush Island projects were done, meaning necessarily that the court relied on hindsight, which we all know is a fundamental premise, cannot be a part of a prudence determination. And last but certainly not least, the evidence shows that while the federal court found that the company was, quote, unreasonable, end quote, for not concluding that the project's increase in unit availability would thus increase actual emissions, the court never found in any way that the company's interpretation of the NSR requirements with respect to potential emissions or with respect to the question of routine maintenance and repair, RMRR for short, were unreasonable. And remember, as discussed in the hearing on Friday, an NSR permit is not required if either there won't be an increase in potential emissions or the projects were routine or they won't result in an actual emissions increase. If the company's understanding of the law back then was reasonable on any one of those 3 points, even if the company turned out to be wrong, and it did, the court said the company was wrong, then its decisions not to obtain permits were reasonable. And since the district court did not find or even consider the question of whether the company's understandings were, knowing what it knew or should have known at the time, wrong, it didn't decide the prudence question. Keep in mind that even on the actual emissions question, what the district court found when it was talking about the company's unreasonableness on that question was that the company's actual calculations of annual emissions were unreasonable. Those calculations were performed after the fact in response to the NOV, not before the projects were conducted. And the court found the company's calculations were unreasonable because the court found that those calculations did not comport with the tests the court adopted 7 to 10 years later in terms of how the calculations had to be done. In short, the district court had to decide and did decide the only question that was before it. Was the company right or wrong about the law? And decided, when it decided it didn't need the permits. If the company was wrong, and it was, it doesn't matter how reasonable the company was 10 years earlier. NSR requirements are a strict liability set of requirements. If the company was wrong, it's liable under the NSR provisions of the Clean Air Act, but that says nothing about whether it was reasonable to hold the understandings it did at the time, which is the question for this commission. So yes, the district court used the word unreasonableness in one sentence of the remedy order with respect to one aspect of the NSR exceptions, actual emissions. OPC and staff want you to abdicate your responsibility to independently decide the reasonableness of the company's actions based on that one word in that one sentence, which even as the actual emissions question doesn't settle the issue, and it certainly doesn't settle the issue on the potential emissions and on the RMRR question. Now, to decide the prudence questions that only you can decide, you must apply long-standing principles governing prudence, just like you did in the Asbury case. And if I could put up on the screen, I don't know if you can see that very well, but this is an excerpt from your Asbury decision. And it's basically your statement of what the prudence standard is, that you, I hate to say you adopted it in the case, because it's really just a summary of what the standard has been, I think, for decades. But I think it is a good statement of it. Under the standard, how things turned out doesn't matter. Under the standard, what we may know in hindsight doesn't matter, and you can't consider it in making a prudence determination. Under the standard, you must ask, what did the utility know, or what was reasonably knowable by the utility at the time? Under the standard, the utility's decision-making did not have to be perfect, and as you summed up the requirements, if the decision-making was within the bounds, there's a range of reasonable behavior. It's not a point estimate, so to speak. If it was within the bounds of what a reasonable decision maker would have done at the time, then the decisions are prudent under the applicable standard. Now, in outlining the prudence standard that I just talked about, you cited some case law as well. And you can't see it very well, but it's at the bottom of that quote. That case law does confirm and validate the prudence standard that you use, but it also discusses about another aspect that flows if imprudence were found, and that is the question of, even if imprudence is found, is there a remedy for that? Should there be a remedy? And what the standard says is, what the law says is, if there's no harm to customers, there is no remedy. And I want to talk about that a little bit now. Until rebuttal testimony was filed in this case, while others, I guess maybe only staff, had made noise about prudence questions in other cases, and I'm referring primarily to the Rush Island investigatory docket that staff asked you to open and the company's last rate case, especially around the NSR permits issue. No party had actually put a stake in the ground and claimed that the company had acted imprudently in any way on those issues. And the evidence will also show that no party had uttered a peep about the well-publicized and well-known decision the company made in late 2021 to retire the plant instead of to scrub the plant. That changed when rebuttal testimony was filed in this case just a few weeks ago. At that point, OPC was urging the commission to permanently force a $34 million write-off based on claimed imprudence on those issues, and staff was firing shots across the company's bow about harm to customers arising from at least one and perhaps both of those decisions. And staff's testimony arguably is a little inconsistent on this, but if you look at Mr. Major's testimony, what Mr. Major says is the company was per se imprudent because they were found to violate the law. Now, that's not the law, I would contend, but that's what staff's position was. But the evidence shows that even if, hypothetically, there was some imprudence, and I certainly don't concede that there was, but hypothetically, if there was, the evidence shows that there is no harm to customers. Probably can't see that very well either, but it's on page 26 of Mr. Michael's rebuttal testimony, and it's table 3 from page 26. What that table is showing you, that is, even if, hypothetically, the retirement versus retrofit decision was imprudent, any such imprudence didn't harm customers. If you take just, and it's shown by the 24 positive data points on the chart, the 24 positive data points represent lower net present value revenue requirement, not higher net present value revenue requirement. And if you take just 2 of them, if one assumes the base, I will call it the middle estimated cost for what scrubbers would have cost had we decided to scrub instead of close the plant, and assumes a loss of the NSR case, and then applies the probability weighted values for carbon to the other planning assumptions, what the analysis tells you is that the company's decision to retire the plant and not retrofit it lowers revenue requirements in that case by $1.452 billion on a net present value revenue requirement basis. And even if you assume the lowest estimated scrubber costs that are in the record, that figure is still $1.147 billion. I also want to point out that these figures do account for planned additional supply-side generation that the company intends to install and ask the commission permission to install to cover capacity that would have existed if Rush Island wasn't retired. And these figures also account for the transmission upgrades that are needed to make sure the transmission system is reliable in the absence of Rush Island. Now, what about the NSR permitting decision? Mr. Michaels didn't provide a table for this one, but what his testimony shows that if, again, you assume hypothetically that the company was imprudent when it didn't get the permits back then, and that it should have got the permits and scrubbed the plant back at that time, even if that's so, what the testimony shows is that the company not getting the permits and not scrubbing the plant at that time on an NPV of revenue requirement basis actually has reduced customer revenue requirements by between $531 million and $770 million. And if, let's say the company decided to get the permits and scrub the plant, and so it was going to stay open, as the record reflects, there are two different pending EPA regulations, the Good Neighbor Rule, which I think deals primarily with mercury and emissions that travel from one state to another. I apologize, but I don't know the details real well. And then there's a greenhouse gas rule that's been proposed as well. And if the company had made a different decision and the plant was going to stay open, there is a real risk that we might have had to invest even more money on pollution control equipment. And if we had to do that, the reduced revenue requirement based on the decision we did make is reduced by more than $1.1 billion on a net present value basis. As simply and succinctly as I can put it, the company has been making decisions all along that it believed to be in customers' best interest, not to incur unnecessary costs and risk of building scrubbers at Rush Island. As it turned out, from an economic standpoint, the company was 100% right. Customer revenue requirements have been, are, and will be lower because of both of the decisions that the company's made over the last 15 years or so. Before I wrap up, I'd like to touch on just two of the other 21 issues in the case. I'm not going to touch on all 21 or we would be here obviously all morning. Starting with the company's planning. Staff's testimony indicates, or at least it implies, that there was a lack of planning for a possible loss of the NSR case, and speculates that had the company planned earlier or differently and somehow, the, quote, current situation the company is in, and what they mean by that is the company is going to be tight or somewhat short on winter capacity in the near term, that current system, staff says, might not exist. They say it might not exist. They don't say it would not exist. To put a blunt point on the issue, the evidence will show that staff's planning-related claims are completely unsupported. The evidence will show that first, in the 2020 IRP, the company did plan for exactly what happened. The company planned for an NSR loss. The company assumed the plant would retire in 2024 at that time. The company examined what its capacity needs would be if that happened, and what the planning showed is that the company would not need additional dispatchable resources, even with Rush Island gone in after 2024, until the early 2040s. Staff didn't criticize the planning. Staff didn't criticize the conclusions at all. In its 2007 and 2014 IRPs, the company similarly also specifically examined scenarios where Rush Island were to retire in 2024, which is what's happening. Specifically considered, if that happened, would we need additional dispatchable capacity? The answer was no, we wouldn't need additional capacity until the late 2030s or the early 2040s. And keep in mind that Rush Island was expected, for planning purposes, to live to 2039 at that time. Again, staff didn't claim at that time the company didn't consider the right planning. Staff didn't take issue with the conclusions that the company reached at all. Staff also seems to criticize the company about NSR loss planning around the transmission upgrades, but this criticism too falls flat. Ameren, Missouri has, since as far back as 2011, consistently accounted for the potential to need to make transmission upgrades to the system if Rush Island retires. Once again, not once over that entire, I guess it'd be 13-year period that I'm talking about, did staff once express a concern about either the planning that was done or planning that wasn't done at all. Nor did staff, but it does now, suggest that the company should have performed transmission upgrades at an earlier point in time. They're being performed right now, but an earlier point in time when staff, I would contend, speculates that the upgrades might have cost less. In effect, what staff is saying is, company, if you'd planned differently, you might have thrown in the towel on the Rush Island litigation a few years ago. You might have closed the plant sooner, because you'd have to close the plant. You'd have to announce that you're closing the plant in order to actually do the upgrades. You might have done the upgrades sooner, and we've had all this inflation in the last few years, and they might have cost less money. I mean, that's the basic position that they're taking. The problem with that position is that that would have been a very bad decision for customers. Rush Island, when it was operating normally, produced fairly significant positive margins for the company and for customers. Basically, all those margins end up flowing back to customers when you have fairly frequent rate cases and you have a fuel adjustment clause. The evidence in this case shows that closing the plant earlier and doing the transmission upgrades earlier, even if theoretically it might have been cheaper, and we don't concede that it would have, but even if it would have been, that the savings that might have existed are about 7 times less than the lost margins that customers would have experienced had we done that. Staff's supposition, frankly, would have been a very bad idea for customers. And that brings me to a discussion of staff's related hold harmless proposal in this case, which is related to the transmission upgrade issues. And Ms. Mers mentioned this at least 2, if not 3 times on Friday. With all due respect, the Commission has absolutely no authority in this case to issue what would amount to a prejudgment of how investments not in rates today should be handled in a future rate case. These transmission investments aren't among the costs that are sought to be securitized. They have nothing to do with this case. They aren't in rates today. When the projects are done and we have a rate case, then like all rate-based investments, they'll be at issue in a future rate case, and that's when the Commission can consider whatever argument staff wants to make. But the Commission can't prejudge it, make an advisory decision about that in this case now. One more issue I want to touch on before I wrap up. Many of you on the Commission, Chair Hahn, perhaps not unless you've been reading old cases, and you might have, are well aware that the confusion and controversy that surrounded the determination of the net present value of tax benefits in the Liberty securitization case. And I know Judge Clark remembers this because he lived it, I'm sure. And I'm sure that you remember that a lot of that figuring out the NPV of tax benefits in a securitization case turns on how you deal with accumulated deferred income taxes, ADIT. In that case, the Commission made a decision on how ADIT should be handled. It was appealed, and the Western District did affirm that decision. That led to a different treatment of ADIT in that case than both the staff and the company are recommending you follow in this case. And it also led to a further complication, that is the need to account for future income tax liabilities in ongoing financing costs over the entire term of the Liberty bonds. The evidence in this case, however, the record in this case is different than the record in Liberty. And based on that different record, the Commission should find that the net present value of tax benefits is as recommended by company witness Lansford and confirmed by staff witness Majors. Doing so will completely keep customers whole. It'll keep the company whole too, but it will keep customers whole as well. And it will obviate the administratively complex need to deal with future income taxes through ongoing financing costs over the entire term of the bonds. In closing, I submit to you that when you consider the record evidence in this case, you will first conclude that the sums the company seeks to securitize should be securitized. Second, you will conclude that the company has consistently made prudent decisions in the best interest of its customers. And this is true even though some of those decisions, as a matter of law, the district court said were incorrect. And you will conclude that customers were not harmed by those decisions, and in fact, their revenue requirements are lower given the decisions the company has made. Thank you for your time and your patience this morning. If there are questions I can answer, I'll try to answer them. And if I can't answer them, you could probably ask them of our witnesses.
Thank you, Mr. Lowry. Just for the record, I wanted to note, I've already noted that Commissioner Holzman is attending this hearing via WebEx. It's my understanding that Commissioner Kolkmar is here as well, and we have Chair Hahn in person. Are there any commissioner questions at this time for Mr. Lowry?
Thank you, Judge. Good morning, Mr. Lowry.
Good morning.
I'm going to go back to Friday, if you don't mind. We spent a lot of time discussing the prudency of the decision to not pursue NSR. And the judge asked you if you thought legally that the commission had to make a determination on the prudency of not seeking an NSR. And what I think your response was is that the commission had to make a determination because of a $34 million disallowance that OPC had suggested. Am I recalling that correctly?
You are. I think that you either have to determine that OPC's adjustment is not supported in a way that you just disregard it. I mean, essentially, it's wrong, it's not supported, and therefore it's no longer an issue. And then I think probably you could not decide the underlying NSR prudence issue because, and this all, I'm hedging only because staff's position's been a little opaque about what they're asking for in this case, and particularly this transmission upgrade hold harmless argument. You know, it all gets tied up into these prudence questions also. But if you agree with me that you can't rule on this hold harmless argument in this case, it's not appropriate for a securitization case, and if you were to agree with the company that you find the OPC's analysis lacking, then perhaps you wouldn't have to decide the underlying case. But if those are live issues, since they're premised on a claim that we were imprudent, you're going to have to deal with the underlying claim in order to conclude that we shouldn't suffer, for example, a $34 million permanent disallowance.
Yeah, I can ask OPC in a moment, but what I thought I recalled them saying on their position was they think there should be a $34 million disallowance, but they were not sure if there would be enough evidence in the case to make that prudence determination. So I can recall that again later.
That might be an instance where Mr. Williams and I might somewhat be aligned that might be the case.
Which does get me to why Ameren had a witness file direct testimony on that specific issue if it was only in response to a disallowance that hadn't been recommended yet.
Well, I think I can explain that because I agree we probably wouldn't have normally done that. So let me give you a little bit of history, all of which happened before you were on the commission. After we made the decision to retire the plant, staff almost immediately asked the commission to open an investigatory docket and made some recommendations, one of which is that we should basically put on sworn testimony about why we were prudent. And we didn't object to that recommendation, but what we said to the commission was, we're about to file a rate case, and so it probably makes most sense for us to put on that evidence in that rate case. And we did so a couple months later, 2-3 months later. And then, and so it appeared to us at that time that staff was absolutely taking issue with the prudence of those decisions. And we get into the case, and we have testimony back and forth, and then staff says, you know what, and I'm characterizing it, Mr. Keevil might say my characterization's unfair, but our interpretation of what was happening at the time is staff then says, you know what, commission, you don't need to decide the prudence issues in this case. The time to decide those is in the securitization case that the company is going to file, because everybody knew, our testimony, I think it reflected we would seek to securitize the Rush Island cost. So from our perspective, staff is telling us in that case, we're going to take on these issues in your securitization case. The testimony, a lot of the testimony we filed on direct in this case, frankly, is just very similar to the testimony we filed in that rate case. I'm sure we elaborated and refined it in some respects, but it's very similar. And so having essentially staff give us the word, so to speak, we're going to take these issues up in the securitization case, we thought it just wouldn't make any sense to sort of act like the elephant's not in the room, so to speak, and not file that testimony on direct. And so that's why we did it. We wouldn't have had to, but we thought we should.
Okay, thank you for the clarification. So I'm going to ask another clarification question. In your opinion, what do you think the commission has to decide in this particular case as it relates to prudence and securitizing bonds for Rush Island?
With the caveats I gave before, you might not have to decide the underlying NSR permitting issue. Again, if you find the evidence insufficient, you agree there's no authority on the hold harmless to make that, so you wouldn't have to decide that. But you have to decide that the company decision to retire instead of retrofit was just, that's what led to the retirement. That's the last decision that led to the retirement. You need to find that was a prudent decision.
Thank you. One other question. You mentioned this morning, capacity issues. Who would be the relevant witness for the commission to ask regarding potential capacity projections?
Matt Michaels.
Thank you.
He knows way more about it than I do. Any other questions I can answer? Commissioners Holzman or Kolkmeyer or Judge?
No questions at this time, Judge. Thank you.
No questions, Judge. Thank you.
Thank you, Commissioners Holzman and Kolkmeyer. I do have a few questions for you. I'll try not to be repetitive.
That's okay.
Let's start with, you had said at the very beginning of your opening that if you followed public counsel's recommendation to not securitize as opposed to, I believe you said, a reduced amount of $325 million. You didn't really explain why securitization couldn't occur there. Now, I do remember from Murray's testimony that there was something about that in regards to carrying costs. Is carrying costs the only issue there that would make it? I guess what I'm getting is what about OPC's position would render the statute ineffective?
OPC's position, as I understand it, is that traditional financing and recovery means that you would amortize the balance of the plan. The commission always and every time would amortize and recover the undepreciated balance of the plant through base rates, but there would be no financing costs associated with that at all. And if that's the case, it is impossible to show MPV benefits of securitization. That is not how you ruled in Liberty. That's not the approach. That's not the method that was taken, the method that you sanctioned. But if OPC's right about that, it's impossible to meet the NPV benefits, requirements of the statute. And if that's the case, then there wasn't any point in having a statute that allowed securitization of undepreciated cost in generating plants because you could never use it. That's the basis.
Thank you. The parties seem to use the words terminate and retirement interchangeably. And I noticed that the district court decision used the term terminate. Is there a difference there? Are those actually interchangeable?
I don't know what terminate means, to be honest with you. I hope we haven't used that term.
Terminate operations?
Okay. I don't think there's a difference, not for this purpose.
Okay. Which witnesses should I ask about Ameren's proposed financing order?
You should ask Daryl Sagal and you should ask Katrina Niehaus. And they are both appearing today.
Thank you. Now, I remember reading in testimony there's some discussion on trackers, but there's been no stipulation and agreement filed in this case. Was there any further discussion of trackers in this case?
I've got to admit, you've caught me flat-footed. I'm not really sure what you're talking about. Maybe it was our witnesses, but I'm not sure. My apologies. Now I do remember. Mitch Lansford does discuss, it's a deferral mechanism tracker. Basically, when Rush Island retires and stops operations, if we haven't concluded a rate case by then, and since it's already April and a rate case takes 11 months and it's going to retire in October, that seems almost a certainty, right? We proposed, for the benefit of customers, that we take the revenue requirement associated with Rush Island that's in our base rates today, that's impacting our rates today, and that we defer those amounts to a regulatory liability so that we can give them back to customers when our rates are reset. Otherwise, we would get, and I'm just going to use a round figure here, otherwise we would get the $500 million for retiring Rush Island. Say we issue the bonds this fall, we'd get that money, and the O&M associated with the plant would stop because it's not operating, right? But our rates would still reflect both that return on and of the investment that's in rates and the O&M. I mean, really, we would sort of be I think we would be double dipping at that point. It would be unfair to customers. And so I think that's what you're referring to as a tracker, I believe.
But there's no agreement at this time between the parties in regard to a tracker and?
I don't think anybody rebutted it at all. I guess I'll go out on a limb and say I think there is agreement that there should be a tracker. If there's, what I don't know for sure is if the parties are completely aligned on exactly what the amount should be. That may not be completely resolved, but the concept that we should defer to a regulatory liability these amounts, whatever the right amount is, I don't think there's any dispute about that. Unless
Well-
I'm missing something. Sorry.
Well, there's the deferral mechanism, and then there's the, was there any discussion of a tracker to track how much was actually spent for energy transition costs?
Okay. I'm sorry if I got off on the completely wrong issue. The statute requires, Judge, that estimated costs that are included in the principal amount of the bonds, not just energy transition costs, but upfront financing costs, those are both affected. The statute requires that differences between the amount included in the bonds, to the extent they're estimated, and some of these are estimated, requires that in a future rate case, those differences be reconciled, and we would either collect a little bit more money or we would give back money if it's different. So if that's what we're talking about, yes. I don't think there's any disagreement whatsoever about the fact that the statute requires that. Maybe if you're talking about a disagreement, OPC in particular, I think staff only on one issue. Some of the issues that we contend should be included in energy transition cost in the principal amount of the bonds, OPC says, we're not saying you shouldn't recover them, but we don't think they ought to be in the principal of the bonds. We think they ought to just be handled in a rate case as if there was no securitization. So there is a dispute about some of those items. But to the extent that you include an estimated item in the principal amount of the bonds, I think everybody agrees that in a future rate case, we need to reconcile actuals to estimates at that time. I think everybody agrees with that.
Thank you for clarifying it on the trackers. It was you're right, the second time.
Okay.
The difference in actual cost versus approved cost. So you're right. If you said there's agreement generally on that principle amongst the parties, I think that's what the judge was getting at. We spent a lot of time talking about NSR and the prudency of that. What we haven't spent a lot of time on yet, and I assume that we will, is the 2021 prudency decision to either retrofit or retire the plant. I'm assuming then witness Michaels might be the person to.
For us.
Okay.
Yes, that's right.
All right. And we can discuss that then. Thank you.
Mm-hmm.
Thank you, Commissioner. I've just got one last thing I want to kind of clear up with you. Now, this $34 million you were discussing as a disallowance, is that staff's or OPC's?
OPC,
Okay, that's what I was thinking.
Mr. Seaver.
Now, you've thrown out that number, and that number is related to another confidential number. Is that number still confidential? Because I believe when you're talking about that, you're talking about amounts above a certain amount. Is that correct?
Well, that's the transmission upgrade issue,
Mm-hmm.
and that number is still confidential.
Okay.
But I don't recall there being a confidentiality issue relating to the $34 million. But the transmission issue, staff recommends, and I won't use figures, staff basically says, look, when you did the 2021 analysis, you had a base amount of transmission upgrade costs that you assumed. It was X, and it looks like the actual upgrade costs are going to be X plus Y. It's Y that's, it's the total, the actual total. It's confidential because we're going to do other transmission upgrade. We don't have a contractor that might bid to have an idea what those cost, right? That's why it's confidential. So that's the issue there. So that actual cost of the transmission upgrade numbers is still confidential.
Okay, and you went kind of where I wanted to go with the transmission upgrades. When you're talking about the transmission upgrades, I guess, as you said, there's an assumed amount, and then there's a potential overrun of that amount, correct?
I wouldn't characterize this as an overrun, but we actually, when we analyzed it, we had a range, but I wouldn't characterize it as an overrun.
It might
but it is.
exceed that range, correct?
Exceeds that base planning assumption that was made. I agree.
And there were a variety of reasons offered for that. I think one of the reasons was conflating or confusing the dismantling of the plant with the transmission upgrades that are occurring at the same spot where there may be materials. I believe toilets were discussed.
That's on the materials and supplies issue.
Okay,
What you're
so
thinking
that's
of. Yep.
all right. Well, let's get me off of that and go back to this. I don't understand how it's an advisory opinion if you're saying this amount of costs we believe is going to be known, but we could overrun it here. How is it an advisory opinion for the commission to say that amounts that aren't at this time knowable will be addressed in the next rate case?
Oh, that's not. That's certainly not. That's not what staff is asking you to do. Staff is asking you to I guess, impose some kind of condition on your financing order, which I don't think the securitization statute even gives you the authority to do that, unlike the CCN statute, for example, that specifically gives you authority to condition your CCN order. Staff is asking you to condition the financing order on an order that says the company assumed the upgrades were going to cost X. If they cost $1 over X, when a rate case happens later, you cannot give them $1 over X. You will not, in a rate case, give them what they actually cost, even if it was prudent, even if there's a good reason, et cetera. That's what staff's asking you to do. They're asking you to prejudge a rate case issue on costs that aren't even in rates yet and that aren't at issue in this case. Maybe prejudgment is a better word than an advisory opinion.
Okay, I understand what you said there, and I thank you for delineating that difference for me. I do see in the statute where it says that no later than 215 days after the date the petition is filed, the commission shall issue a financing order approving the petition, an order approving the petition subject to conditions or rejecting the petition. And it doesn't seem to lay out any limitation on the conditions.
Well, I would suggest that when you're deciding what rate base should or should not be included, putting aside that statute, you have to consider all relevant factors. You have to come to just and reasonable rates. And if you're prejudging a particular expense before you even get to the rate case, I don't see how you, and then when you get to the rate case, you don't consider it, right? Because you're not considering that factor because you already prejudged it. Then you're not considering all relevant factors. So I don't think you can impose that kind of condition, even if the statute may allow you to impose certain conditions that are germane to the securitization itself.
But you didn't have, just to clarify, you didn't see any issue with what I proposed, correct? In terms of you believe that the commission could say, well, this part's known, we'll do this, and we'll address the rest in a rate case.
Absolutely not. I think that's actually what you should say on the issue.
Okay.
It's not an issue for this case. We'll deal with that in a rate case. That is what you should say.
Those are all the questions I have at this time.
Thank you. Or did you have another one?
I do not. Thank you.
Thank you.
Next opening is from the staff of the commission.
Judge, if I could beg your indulgence, given my walking condition, I would prefer to just sit here and deliver this. I don't plan to take nearly as long as Mr. Lowry did unless we're in response to questions from the bench.
You're welcome to conduct your opening from where you're seated. I do know that the microphone has had a hard time picking. I can hear you. Everybody else can hear you, but I know that you're not picking up as well on the stream when you don't speak directly into the microphone.
All right. Let me try, get a little closer. Good morning. May it please the commission and RLJ. As you know, my name is Jeff Keevil. I am one of the attorneys representing commission staff in this proceeding, along with Nicole Mers and Travis Pringle. When I last appeared before this commission in a securitized utility tariff bond case, it was only the second time the commission had conducted such a hearing, and the previous hearing had actually been a consolidation of two cases, I believe. And I also believe the other case was on appeal or was just on the verge of appeal. In other words, the commission had very little in the way of experience with cases such as this securitization case, and no real court-sanctioned roadmap to follow. Now, even though this is only the third, to my knowledge, securitized utility tariff bond hearing in Missouri, the commission has worked its way through both of those prior cases and hearings, and both of which were upheld on appeal, and both of which have worked their way through the post-financing order / issuance advice letter process. In other words, the commission has experience with these cases. You will recall that the financing statute, Section 393.1700 RSMO, requires that the financing order contain certain matters. You will also see from the list of issues and position statements that many of the issues in this case, although having a securitized financing impact, are very similar to the types of standard rate case issues with which the commission has lots of experience. Now, that's not to say those issues are not important, just that they should not be viewed as super unique in some way, since they are being raised in a securitization case. The list of issues set forth 21 issues, many of which contain subparts. In the interest of time, I'm not going to laboriously go through each of these 21 issues. Opening statements by attorneys do not constitute evidence anyway. However, I will just point out a few issues which I believe may warrant your particular attention. You already heard one witness in this case last Friday on the prudence issue, issue number 3. Closely related to that issue are issues 4 and 5. And these numbers that I'm referring to are as they are listed on the list of issues. I believe these issues warrant particular attention. Mr. Lowry spent virtually his entire opening statement addressing those issues, and even though quite a bit of time was spent on Friday addressing them. Also, issues 1 and 2 involving net present value benefits and the post-financing order process and procedure. Those are issues that I believe you should pay particular attention to. And I should probably mention that many of the other issues that I'm not specifically pointing out here this morning may touch upon prudence or touch upon net present value. And as I mentioned earlier, I did not mean to imply that those other issues are not important. However, in many ways, they are just more similar to standard rate case issues. Another group of issues to which I would draw your attention are issues 16, 17, and 20, which you could think of as, if in relation to a more standard rate case, you could think of those as your rate design and tariff issues. Now, you heard Mr. Lowry talk almost exclusively about the prudence and related issues 4 and 5. And suffice it to say that staff has significant disagreement with what you heard him say. However, I have to apologize not being as versed in those issues as I would like to be, and would whatever I say, please take with a grain of salt, and be prepared to ask staff's prudence witnesses questions on those issues. Now, you will hear testimony from several witnesses representing several parties in this case, some of whom testify on multiple issues. I would refer you to staff's filed statement of positions and encourage you to ask questions of the staff witnesses when they take the stand on various issues. And I could attempt to make a poor attempt at responding to questions. If you have any, I'd be glad to address them. As I said, I don't plan to go on forever, so I'm going to leave it at that for now. And more will be addressed, I'm sure, during the specific issue mini openings. Thank you.
Thank you, Mr. Keeble. Are there any questions from the commission? I have one for you, Mr. Keeble. As Mr. Lowry had pointed out, there's about $17 million difference between staff's position currently and the companies. And while to me that's a phenomenal amount of money in the world of utility regulation, as I believe Mr. Lowry pointed out, that's just enough to see daylight through. One of the, as you pointed out, Mr. Lowry spent a lot of his time for Ameren on the NSR, the new source review prudence issue, as has been put out, that a lot of the parties are interested in. I guess my question at this time is, it appears that there's still at least remedy proceedings going on in the district court. So with that in mind, if there is harm, I'm wondering how it's quantified at this point, such that the commission should be considering it in this case. So can you kind of give me your overview on that as to why we should be, if it hasn't been quantified?
Well, I think that oftentimes that harm element of the prudence standard or prudence evaluation gets lumped. If you noticed on that slide, not slide, but that overhead Mr. Lowry had up there that talked about prudence, the associated case, or whatever case that was he was projecting for us, talked about the prudence and then the harm. Said you can have prudence, or excuse me, imprudence, but you have to also have harm. And so, and in fact, if you look at the statute here that we're dealing with, 393.1700, definition of energy transition costs itself, requires that let me just read the first part of it here. It says 7A, pre-tax costs with respect to a retired or abandoned or to be retired or abandoned electric generating facility that is the subject of a petition for a financing order filed under this section, where such early retirement or abandonment is deemed reasonable and prudent by the commission through a final order issued by the commission. Include but are not limited to, and then it goes on with several examples of costs. I think the problem that you have in this situation is that in order to securitize them, the costs need to have been reasonable in the first place. And I agree with you that we do not know the full extent of the harm to which ratepayers will be exposed due to Ameren's decision-making in regard to the decisions that's made here. So I think you need to address you can find that they acted imprudently without deciding the harm, the amount of the harm. And that's basically what staff's, I'm probably doing a poor job of paraphrasing this, but I would encourage you to ask Ms. Eubanks when she takes the stand. But that's basically a big part of her recommendation to, I don't want to say push them off to the rate case, but to defer them to the following rate cases, because that the harm element will be hopefully better known at that time. Did any of that make any sense at all?
It did, and it is essentially what I'm getting at too, is you actually cited the section of the statute, and I'm looking at that, and I'm trying to figure out how narrow or how expansive that is. And it appears that, at least given the reading you just gave of it, that where such early retirement or abandonment is deemed reasonable and prudent by the commission, it appears that staff is deeming as part of that retirement decision the decision to seek the choice to not seek the new source review permitting. Is that correct?
Yes. In fact, Judge, if you go back and look at it, there were numerous decisions that Ameren made going all the way back to the early 2000s, basically, up until just recently, that have, well, actually it's still going on, as you pointed out. The remedy phase is still going. Any one of which of those decisions they could have been prudent or imprudent on. So, personally, I'm not speaking for staff right now. Personally speaking, just for me, I think they got several of them wrong. They got several of them right. I mean, it was a series of decisions and actions that they took on the basis of those decisions. The full extent to which the harm, we don't know yet, as you just pointed out, because the court could impose, I'm not sure what the proper terminology here is, I'm going to call them fines or penalties, beyond the rate making, or beyond the costs of retiring or putting scrubbers up. The court could just fine them, basically. Probably the wrong term again, but and I think that's one of the reasons that the court, you know, I mentioned earlier during the preliminary matters portion of this, Harry, we've asked that the commission take official notice, and it doesn't matter to me whether you take official notice or just receive it as an exhibit in the record. But somehow or another, you need to get that transcript from the court's remedy hearing in the record. Because, I mean, I think it indicates the extent to which the court believes that what Ameren is telling the court and what Ameren is telling this commission do not sync. And it's an ongoing pattern or problem that we've experienced since 2000 and early 2000s.
And I'm wanting to listen to all of the arguments of the parties, because I'm just trying to figure out how we get there, because I'm looking at this and I can certainly, I agree with you. On any given day, any utility plant or any utility and decisions regarding any utility plant are going to be along a scale with a perfect decision at the top and a terribly imprudent decision at the bottom, and that any given day that these decisions are going to run up and down that scale to a degree with a very low likelihood of extremely imprudent decisions and a very low likelihood of absolutely perfect decisions. But are those all retirement decisions? And that's kind of where I'm thinking, because it says where such early retirement or abandoned is deemed reasonable and prudent. And it doesn't really talk about the other decisions. And so I'm having a hard time getting there. And by way of example, and I'm not meaning to pick on Ameren, for this, but it's just the one that comes to mind. If you're talking about something like Tomsock, where all of a sudden everything washes down the mountainside, there may have been a lot of decisions that took you down the road to get there, but then you have the decision as to whether to rebuild or to retire. And that seems to be, at least the way I'm looking at the statute, that seems to be what's being looked on. Now, I certainly think, obviously, there's reasonable arguments to be made for why it should be more expansive than that. And I want to hear those arguments.
Part of on that point, Judge, I think, again, I would refer you to Ms. Eubanks and Ms. Mers, but part of staff's concern, I believe, is that if you wind up making whatever decision you make, we don't want to, in the next rate case or whenever, we don't want it to come back and say, Ameren, you heard Mr. Lowry this morning say, well, they didn't complain about this in 2014. Well, they didn't complain about this in 2007. We don't want them to come back in the rate case or whenever and say, well, you decided at commission in the securitization case that we weren't we were not subject to any disallowance and that it was prudent enough to securitize. So therefore, you've decided this, and staff can't bring this up now. And that's part of our. We hear that, and not just from Ameren. We hear that from all utilities. Well, you didn't bring this up, 18 years ago when you had an opportunity to do so, even though you didn't know as much about it and you weren't a part of the litigation in federal court and on and on and on. You had an opportunity to raise it, you didn't, you lost it. We don't want to run into that again.
Go ahead, Chairman.
Thank you. I think, from the prior opening statement and the discussion on Friday and staff's pre-filed position statements, staff didn't have a position on the prudency or reasonableness of the NSR permitting, only other than to preserve it for a future rate case. The statute only requires us to look at the retirement or abandonment of the plant and its prudency and reasonableness in 2021. If it was prudent and reasonable to retire it, to issue securitized utility tariff bonds to retire, if that decision was reasonable and prudent, then we could retire. That's the decision I think we're largely focusing on today. I do think it is a broader scope to talk about, NSR permitting, harm that we're not totally sure about, still being assessed by the federal courts. So at least staff bringing it up might be a great way to preserve it again, like you're preserving NSR permitting for that future rate case so that we have all of that information to look at one time, because the decision before us, to me, it seems fairly narrow.
I'm going to have to defer that because that's actually to like as I said earlier, either Ms. Eubanks or Ms. Mers, because I haven't been as closely involved in that issue as I wish I would have been up to this.
Thank you.
Thank you. Are there any further commission questions? I hear none. Thank you, Mr. Keevil. MIEC was next, and my understanding is that they have, and I have granted, that they want to do a mini opening on issue 17 when that comes up, correct?
Your Honor, I would like to do that still, but I would just like to make a brief statement to put our issue into context, if I could, without getting into detail.
That would be fine. Please go ahead.
Sure.
MIEC.
Sure. Thank you, Judge Clark and Chair Hahn and Commissioners. The reason the MIEC has narrowed this to one issue is that the MIEC supports Ameren's proposal to do the securitization. We think that's a cost-effective decision and makes sense. There's really one issue that's outstanding, but it's of great material importance to the large employers that are included in the MIEC, and that is that staff has proposed that the securitized cost be allocated to customers on a kilowatt-hour energy basis. This is a very dramatic decision in terms of what that would do to industrial rates, not only in this case, but in future securitization cases, which we fully expect will occur. The evidence that we have will show that this case is distinguishable from the two other cases for Liberty and Evergy regarding this issue. It will show how this proposal by staff really departs completely from the way that rates have been set for Ameren and rates should be set, and that it would cause discrimination against large customers and would not be a reasonable or fair method. And we will present that evidence on Thursday, or if the issue comes up sooner, whenever it comes up. Thank you.
Thank you. And to clarify, I misspoke there. That's issue 16, not 17.
My apologies, issue 16.
Any commission questions for MIEC? I have no questions. Thank you. Any opening statement from the Sierra Club? I excused them, didn't I? Any opening statement from Natural Resources Defense Council? I hear none. I believe I also excused them, actually. AARP?
Good morning, Your Honor. Judge Hahn, may it please the commission. I'm John Kaufman. This is an opening, just a brief overview, opening statement on behalf of AARP and the Consumers Council of Missouri. And I would just like to start by reminding the commission that the Public Service Commission's guiding star, as the courts say, is the protection of the public. And there are a few things about the framework of the securitization statute that have been vexing, and I think we're all struggling with how you address prudence and reasonableness in this case, and part of it is because the securitization statute sets up a system whereby the commission can approve this surcharge, and it's basically locked in, and the commission loses control over what happens over the next few years. It's locked in, and consumers are going to pay whatever the commission says they have to pay if they do approve this, and we cannot trust, as we normally do, the commission's ability to come in and protect the public if something is then discovered later, if circumstances change, and for instance, if harm then becomes very apparent, whereas it's kind of unclear right now. And so that's why I think this is a very important moment and one that the commission should take very seriously. And whereas I take sort of the flip side of the that Ameren, Missouri does in this case, of the particular statute, in our opinion, is if ratepayers are not going to be better off than they would be with traditional rate making, we don't see the purpose of the statute. The statute was sold as a way to treat consumers better. In fact, if they're in a situation such as this where a coal plant is going to be shut down. And it's important to understand the framework in Missouri, and for electric utility plant in Missouri, if it's not being used and useful, if it is not serving customers, if it's not fully operational, then the utility is not entitled to return on that plant. And that would be the traditional rate making method. So with absent securitization, all that the utility would be allowed is to take the remaining balance, depreciation, and recover it through an amortization with no return on that unamortized balance. So if, in fact, as public counsel testimony has proven, that shows that even if the commission is allowed Ameren to recover a debt return of a little over 4% on the asset, securitization would be more costly than established rate-making principles in Missouri. And so in that case, we think that the commission should be approving securitization only if it can be shown that ratepayers are going to be better off with securitization. And in this particular case, there are numerous issues as to the prudence and reasonableness of the utility's actions that led up to this particular case. And, Your Honor, to analogize to the Tom Sock situation, there you had something I don't think anyone argued was prudent at all, but the question about whether to rebuild that Tom Sock, and the commission wrestled with this, would not have been in front of the commission but for the imprudent actions that came before it. So I think you have to look at the prudence and reasonableness of decisions that led up to this decision to shut down the coal plant, as well as projecting forward what that may be. The issue of whether harm is necessary for prudence, I think you have to look at. I think guidance can be found in the capital city water cases. There were two of them in particular in the 1990s that looked at prudence and reasonableness separately, and involving a contract with public water supply district found that a contract was at one point prudent, but then in another case imprudent, and depending on the facts of each particular rate case that water company had, the disallowance was allowed or not. In one case, an imprudent contract resulted in no disallowance, and in another case, a contract that had been prudent was not reasonable. And this is the kind of ongoing regulation, ongoing oversight that we expect the commission to do. But in this particular case, when you're looking at securitization and locking in a decision for a long period of time where the commission won't be able to go back in and reconsider its decision, I think you have to look at it in a broader context. But all I'm saying today is that I hope that you look at this decision and realize that if the public is going to be protected and the public is going to be treated fairly, that all those considerations have to be made in this case. Because if the public is going to be protected, it's only the commission that's going to be able to do it. So we are adopting the position of the public counsel in this case, and asking that you not approve securitization in this particular case. Yes. Any questions?
Chair?
Thank you, Mr. Kaufman. For clarification, you said that the commission needs to take the decisions, for example, of, you didn't use these exact words, but prudency of, the past decisions to how we got here into account. What if it's not known? We've heard harm several times.
Right.
Unknown.
Right.
So are you, if these things are unknown that you're suggesting that we take into account, would you disagree then with staff's position, or how do you feel about staff's position to preserve those for future rate cases?
Well, I would say there is an initial prudence, reasonableness and prudence determination the commission makes to whether the utility even has access to the securitization remedy, right? And the utility does bear the burden of proof, even though under the law, other parties need to raise the issue. There needs to be a serious question raised, and those issues have been raised, or at least the issues that have been raised in this case. I think you have to put the burden on the utility to prove those, and it is tricky because we don't know. We don't even know what the bonds will be yet when you make the determination. But I would just say that you have to look at the burden of proof, and the burden of proof is on the utility. And if you don't know, I think you have to err on the side of consumers.
Any other commission questions? I have no questions. Thank you very much, Mr. Kaufman.
I don't envy your decision here. It's complicated.
I guess I'm just wrestling with what you said last. You have to err on the side of consumers. And in this case, I don't know what that means, because I can see the analysis, of cost of scrubbers and retrofitting versus cost of retirement. So I'm struggling to understand your position of what's best for consumers. So
You're forced to be in a position where you have to estimate a hypothetical situation in the future.
thank
I
you.
don't think there's any way around that. Thank you.
Thank you, AARP and Consumer Councils of Missouri. Any opening from Midwest Energy Consumer Group?
Good morning, and may it please the commission. My name is Tim Opitz on behalf of the Midwest Energy Consumers Group, and just very briefly, I want to touch on the allocation of revenue requirement, which was mentioned by MIEC's counsel, and briefly by the staff. So our position is that the allocation should be based on the nature of the costs that are being securitized. And here, these costs are related to a fixed plant. And so, in my view and in the view of MECG, this would be, in a normal rate case, recovered differently than through a straight kilowatt hour charge. So I think drawing that distinction between this securitization case and prior securitization case recovery mechanisms that have been approved is an important distinction to point out. And MECG supports the proposed method that is contained within Morris Brubaker's testimony. I believe he's got rebuttal and surrebuttal. And my understanding is that the company witness, Mr. Wills, in his surrebuttal testimony, says this is an acceptable alternative. And I think the opponent who's taken a position is the commission staff, which is advocating for the kilowatt hour charge that's been approved related to primarily the Storm Uri securitizations. So with that, I would ask the commission to adopt the allocation proposal contained within the testimony of Morris Brubaker. Happy to answer any questions.
Any questions from the commission? And this is, and am I wrong? Is this primarily a demand allocation?
That's being proposed
Yes.
by Mr. Brubaker. So Mr. Brubaker's proposal is a specific percentage adjustment that's based on, I believe, the combination of the customer demand and energy charges. I think it's page 10 of his rebuttal testimony that talks about those details. And what the staff is proposing is that it would be a voltage adjusted kilowatt hour charge. So that would be energy charge. It's MECG's view that a production plant wouldn't be, in a normal rate case, recovered through a kilowatt hour charge. So,
Okay, thank you.
thank you.
Renew Missouri?
Thank you, Judge, and may it please the commission. My name is Andrew Linares. I'm representing Renew Missouri Advocates in this case, and I'm here to support the company's application to facilitate the retirement of Rush Island using securitization as enabled by 393.1700. In addition, I want to bring some clarity to our position in this case with respect to what we discussed earlier, the Energy Infrastructure Reinvestment Program through federal DOE. Our primary interest in this case is to ensure that Missouri's securitization framework continues to be used in a way that allows retirement of antiquated and expensive fossil fuel generation and to invest in new, cheaper, cleaner generation. In the coming decades, we are going to need to confront the reality that our utilities have many coal and gas plants on their books that are either in non-attainment of emissions requirements, or they require upgrades that are too costly to justify, or they are too costly to continue to run when compared to new generation, or perhaps all of these together. The commission will need every tool in its toolbox in order to deal with this coming energy transition, and the securitization framework is an essential tool. This is the second major case before the commission considering a securitization application. In the Asbury case, the commission determined that about $80 million in energy transition costs could be financed using securitized bonds, and that recovery of such costs was just and reasonable, and that the decision to retire the plant was reasonable and prudent and in the public interest. The appellate court later upheld this decision. This case, obviously, it involves more stakes, it involves more money, but at bottom, it presents the commission with the same task, which is to determine whether customers will be better off if an antiquated, expensive power plant is allowed to retire and its remaining debt financed through securitized bonds. So I also want to address this EIR issue. Renew Missouri submitted one piece of testimony in this case, the rebuttal testimony of Mr. James Owen. Mr. Owen introduced the concept of using the Federal Energy Infrastructure Reinvestment Program as an alternative way to finance the retirement of Rush Island. The EIR program was created as part of the 2022 Inflation Reduction Act, or the IRA. It's administered through federal DOE, and it's been allocated $5 billion to guarantee loans for projects to replace old energy infrastructure with renewables, batteries, other new infrastructure. The DOE's LPO, or Loan Programs Office, has stated that the program can accommodate financing structures, including securitizations, provided that certain reinvestment requirements are met. Mr. Owen relied on an analysis from the Rocky Mountain Institute that explained how EIR funds would take the place of the bond market in a normal securitization proceeding. And Rocky Mountain Institute's analysis showed that using EIR funds to retire Rush Island and reinvest in new generation would save ratepayers over $400 million at the end of the day. And Renew Missouri shared this proposal with the company and with all the other parties in the case. And to the company's credit, they gave full consideration to this proposal. However, Ameren, Missouri did return an answer to us after they analyzed it themselves. They came to the conclusion that application of EIR program funds in this particular case would not end up benefiting ratepayers. And the reason is, as the company explained, there's a limit functionally to the amount of EIR funds that the company can use between now and 2026 when the program runs out. It appears Ameren has enough planned renewable generation projects that it is better to use those limited funds for that purpose rather than for the securitization purpose, for which there is already this state funding mechanism. As Mr. Darrell Sagal stated in his rebuttal, the DOE will not incrementally fund both the securitized costs and the costs of eligible renewable energy projects to which the proceeds of the bonds are required to be allocated. Funding securitization costs via a DOE loan program means we effectively forego the ability to finance investments we will be making using all available sources of lower cost debt. I hope I've explained that clearly enough. There's functionally there's a limit in funds. If those funds are all put to new renewable generation, then the company is free to use the state securitization process to retire the project, which would not be you have to make a tough decision there, and we have no reason to doubt the contention of the company there, and we appreciate their consideration of the proposal. However, I do just want to note that we stand behind the Rocky Mountain Institute's general analysis and framework that they came up with about how to use EIR funds to enable securitization. And in certain narrow circumstances, it definitely should be considered over the next couple of years between now and 2026 for other utilities that come in with a securitization application. So I do want to leave the commission with that impression that we should be considering this program in the future for future applications. Renew Missouri takes no position on many of the other issues in this case with respect to disallowances or the company's previous decisions around Rush Island, with the exception that we do see Ameren's decision not to retrofit the plant as a reasonable and prudent one. And We do, I suppose I have concerns that failing to approve this application in this case, or over scrutinizing the utility's past decisions, or stacking up disallowances may have the effect of dissuading utilities from seeking timely applications for securitization in the future. We believe utilities should have a clear expectation and confidence around the securitization process to encourage old plant closures and investment in new generation that'll benefit ratepayers and the grid. So with that, I'm happy to conclude and take any questions around that EIR issue or any other of our positions in this case.
Any commission questions? I don't really have a question. I just want to ask, just to be sure I've got this right, because when I read your position statement, essentially, I was going over it. It seems like the position of Renew Missouri was use this program for this as long as it doesn't displace dollars that would be used for renewables elsewhere. Is that correct?
I think that's correct, Judge. I think it is, at the end of the day, is a function of how much money is available through the EIR program and what you could potentially use it on. So I don't disagree with the framework that we proposed generally in Mr. Owen's testimony, or the analysis that the Rocky Mountain Institute performed, even with respect to Ameren, Missouri. But it's just simply a question of how much funding through DOE could Ameren, Missouri qualify for and theoretically get, and how many projects do they have planned to use that for. And obviously, if there's a limit there, you want to put it all towards new generation, because you still have the securitization framework at the state level to use for retirement. So in this case, I do think the company's explanation there is correct. Is that clear? I'm happy to restate that.
It does. I'm going to restate your position again,
Yeah.
not in regard to that. So is Renew's position now is this is an option we like, and we think this option would be good in certain securitization cases, but Ameren, but maybe not this case?
That's correct. Yeah, I think you've stated it just fine. Yes.
Okay. Thank you very much.
Thank you.
And I believe my last party is the Office of the Public Counsel.
Thank you, guys. May it please,
If you're participating via the WebEx, you may want to mute yourself. We're picking you up here in the courtroom.
may it please the commission, Nathan Williams, appearing on behalf of the Office of the Public Counsel and the public in general. There's been quite a bit of focus on the statutory requirement of reasonableness and prudency in the decision to retire the plant. It's public counsel's position that that should not be construed narrowly, and prudency is an ongoing activity. It's not just a point-in-time decision. And what occurred back in 2007 and 2010 bears on the prudency, because it affected the position that the utility put itself in at the time it made the decision to retire Rush Island in December of 2021. Basically, it had different options. It chose one apparently either intentionally, unknowingly, or what I mean is it didn't seek an EPA determination that it did not need to comply with the Clean Air Act in terms of emissions whenever it made the major improvements that it made to Unit 1 in 2007 and the major improvements that it made to Unit 2 in 2010. There were, as I see it, at least three different things that could have been done at that point in time, and I don't know that all of them would have been prudent. One was to do what Ameren, Missouri did do, which was to make the improvements and take their chances on EPA enforcement action. Another one was to have made those improvements and also added scrubbers to the plant. And the third one was to engage in what the EPA considered to be routine maintenance, repairs, and replacements, which would not have triggered the prevention of significant deterioration under the new source rules. So that's our position about prudency for getting access to the securitization statute. We're not saying that Ameren, Missouri should not have any opportunity to recover costs. It always has those opportunities to seek them in a general rate case. And it's our view that securitization should be at least, if not more, beneficial than, in terms of cost impacts, what would occur during a general rate case. If you're using weighted average cost of capital as your touchstone versus the bond rate as your touchstone, we believe that's going to give you phantom savings. We believe the commission has sufficient discretion in a rate case that there might be a circumstance where it would use something greater than the utilities embedded cost of long-term debt or cost of debt, or perhaps even weighted average cost of capital. But this is not that case. And our basis for saying that securitization has to be beneficial to customers as opposed to traditional rate making is section 393.1700.2 sub 3 sub c b, which requires that a financing order find that imposition and collection of a securitized utility tariff charge are just and reasonable and in the public interest and are expected to provide quantifiable net present value benefits to customers as compared to recovery of the components of securitized utility tariff costs that would have been incurred absent the issuance of securitized utility tariff bonds. Now, as to the amount that's securitized, Public Counsel is not suggesting that there need not be a showing of harm if a prudency disallowance is being made to those costs. We agree that that would be the case, just as you would do it in a rate case.
Can you say that again? I didn't really understand that.
We're agreeing that there must be a showing of harm in order to do a disallowance, a financial disallowance to the amounts that are allowed to be securitized.
Thank you.
We're not agreeing there needs to be a showing of harm in order to, it's on the utility. The utility has a burden of showing prudence, and that does not include anything to do with harm in terms of access to the securitization route. Remember, the incentive for the utility for securitization in this case is about $500 million in cash up front. And it's locked in. There are going to be charges for 15 years if Ameren, Missouri gets what it's asking for here. In a rate case, there will be a series of rate cases, and the commission would consider all of the factors that it's looking at whenever it's deciding securitization. In the context of a rate case, those would just be factors it would consider for making its determination of just and reasonable rates. Now, those are I think the two biggest issues. There's also, of course, the accumulated deferred income tax. It's our position the courts have found that the statute, whenever it talks about tax benefits, is talking about the accumulated deferred income tax balance. And then what the commission did in the Liberty securitization case is the appropriate way to handle accumulated deferred income taxes in this case as well, which of course is in contrast to what staff and Ameren, Missouri are advocating in this case. We don't believe their claimed distinction is significant enough to warrant any kind of a different result. We do have a number of proposed, I guess I'll use the word disallowances, reductions to the amount that Ameren, Missouri has sought. Some of those are based on the uncertainty of them currently, and that if they were addressed in a rate case, they would be more certain. And also, we would anticipate that the commission would allow, the amount that the commission would allow would be lower than what it would allow, than that would be under securitization, because it's an upfront cost. Basically, the bond rate would be higher than what we expect carrying costs would be for an amortization of those costs in a future rate case. Because normally what the commission does is if there's some amount it wants to flow to the utility over time, it's takes that amount, spreads it over a term of years, does an amortization to come out with an annual amount, and then sometimes it will allow carrying costs, sometimes it will not. But I've never seen carrying costs that were at the weighted average cost of capital. David Murray's our witness who addresses that. We also take issue with some other matters that we don't view to be just tied to the retirement of the plant. For example, the water monitoring and treatment that's ongoing currently, and it's necessary to go on past the retirement of the plant, but it's currently being done. It's not something new that is triggered by the retirement of the plant. Also, Public Counsel witness John Robinette has net book values at different points in time, including December of 2021, when Ameren, Missouri says it made the decision to retire Rush Island. And the value net book value at that point in time, I believe, is about $27 million lower than the projected net book value at the time of the retirement, if it occurs in September or October of this year, roughly $27 million. Kind of question why the utility spent $27 million on a plant after it elected to retire it. You were asking some things about the federal court litigation. My understanding is that the remedy is directed towards, and it's equitable, the fact that the plant exceeded the permissible emissions for a long period of time. And the original remedy order was to require Labadie to treat its emissions to compensate comparably to the excess emissions that Rush Island did over the past decade or so, 10 to 15 years. Court of Appeal said that was not permissible, so the parties are now trying to come up with another remedy, but I believe it's directed at something to do with compensating for emissions, and at least at this stage it's in equitable relief as opposed to financial relief. I don't know if it'll come down to financial relief or not, or how that'll actually play out, but that's my understanding of where the federal court is at this point. I'd be happy to try to answer any questions.
Any commission questions? Chair Hunt.
Good morning. I was trying to recall from Friday, so I do just want to be clear from the position statements. OPC doesn't have a position on whether or not it is reasonable and prudent for Ameren to retire or abandon the plant as they decided in 2021. Is that right?
Not at this point in time, we do not. We think it depends on the evidence in the case.
Okay. And then the one position that you have asserted on prudency and reasonableness is about NSR, but you said that and I wanted to recap this to make sure that I have it in my mind correct, is that there's potentially not enough evidence in their record or in this case to make this determination. Is that correct from what you said on Friday?
Yes.
Okay. Also regarding prudency, issue 3B states that OPC would estimate the harm to customers as $34 million. How is that amount estimated, or will you have a witness that can talk about that?
Jordan Seaver is our witness on that matter.
Thank you.
Are there any other commission questions? I hear none. I have one question, and just because as you said it, it struck me, and I kind of wanted to know what the difference was. You said sometimes the commission, in a rate case, and I'm assuming you were talking about plant retirement, that sometimes the commission allows carrying costs and sometimes it does not. Is that correct?
Yes, but I wasn't limiting it to plant retirement. There are many times where there's some large cost, and because rates are ongoing, there's a spread over time. In fact, it's been about 10 years ago, I think, staff started tracking all of those regulatory liabilities and regulatory assets, and then each rate case will reset them. I know there's been one for OPEBs and pensions for as long as I've been doing this, which is over 20 years, so, for example.
Okay, well, given that it doesn't just include plant retirements, but as you said, larger costs, is there a defining characteristic that you have noticed where the commission determines that carrying costs should or should not attach?
Commission discretion is the best I can give with it. I mean, a lot of times, I think sometimes when it's a larger amount, the commission's more inclined to allow some kind of carrying cost because of the amount of time it takes. For example, in this case, if there was an amortization for the net plant balance for Rush Island, starting from the date it's retired, let's assume it's retired in October of this year, October 15th. It would start, I would expect the staff would treat it as an amortization starting from that point in time because it's no longer used and useful. It should not remain in rate base. And typically since the plant life's 15 years, which is the number we've been using in this case, you take that plant balance, so if it's $500 million, spread it over 15 years, and then if you want to say, because it's going to take 15 years for the utility to recover that amount through rates, we're going to allow some carrying costs for that. It's kind of like an accounting authority order, except it's done in the context of a rate case and actually has rate impacts.
All right, thank you.
Anything else?
I have no further questions. Thank you.
Thank you.
All right, that is our last opening, and we ran a little further beyond when I intended to take a break. Sorry, Mr. Lowry, you look like you want to say something.
I was just wondering if maybe I could clear, you asked some questions of Mr. Keevil that were a little different than the questions I think both you and the chair did about this issue of what do we need to decide, and something occurred to me that I think might help crystallize in your mind, and I think I can, in just a minute, if you'd like to hear it, try to crystallize that for you. I mean, really, we've been talking about a legal issue, a lot of these questions, and I don't think anybody's really hit the nail on the head yet, and I think maybe I can help you with that.
Mr. Keevil, I see you shaking your head. Do you have an objection?
Yeah, I think I do, Judge, because I've just once again, Ameren attempting just to get the final bite at the apple. I've never heard of responding, opening statements to in commission proceedings. I mean, once again, Ameren is using the process to benefit itself and taking advantage of everything and then some that's offered to them. I mean, I don't know what he's going to say. He might say something I like. He might not say something I like. Chances are he will say something I don't like. But, you know, he might get lucky and get something that I like. But it's just improper, and they shouldn't be allowed to do things like this, Judge.
Judge, if I may, I'm not going to respond to what Mr. Keevil said or didn't say. I'm responding to questions that you asked them that you didn't ask me, that were different questions. And I think it would be helpful to the commission. And my arguments are you either find them to be right or compelling or you don't. They're not evidence. So it's up to you, but I think I could probably clear something up.
Judge, I would think if you had wanted to ask Mr. Lowry those questions, you were fully capable and able to do so when he was up there, rather than letting Mr. Lowry choose which questions he now gets to respond to.
I'm going to agree. I'm going to agree that each party had an opportunity to make their opening, and the questions they got from the commission and myself are the questions they got. There will be plenty of opportunities later for Mr. Lowry to clarify these points with his witness and through his witnesses. So I agree with you, Mr. Keevil. It's not appropriate in this instance. As long as I've got you talking, however, there was a question I did forget to ask you, and it's just a very brief one, which is, which witness do I need to ask about staff's proposed finance order? Who would be the witness that I would ask questions about that?
Depends on what you mean by about the proposed finance order. Because there's different provisions in the finance order. You know, some of them talk about the finance team process. Some of them talk about the, you know, there's lots of things in that finance order. So it depends. Now,
Who drafted the finance order?
an attorney.
Okay. So if I wanted to ask questions about provisions of the order, not subjects of the order, but provisions of the order, who would I ask those to?
Again, it depends. I mean, because some people would know certain things about it, and other people, it would be the people whose issue, I guess, is implicated by whatever it is you're asking.
Okay. Hold on just a second. You said an attorney drafted it. Is it a single attorney that drafted it?
No.
That answers my question sufficiently. Thank you, Mr. Keevil. All right, I am sorry. I've delayed.
You may notice there's some place in there where I put this particular provision in there. There's a note to the commission because of the way in which that proposed order came about. There's a note in there that in the event of a conflict between staff's testimony or brief or whatever, other evidence, and that order, then what is stated in the staff's testimony or evidence should control over whatever is stated in that order.
Okay, thank you for that clarification.
Thanks.
I intended to take a recess around 10:30, but I wanted to get through openings. Openings ran a little bit long. Why don't we take about a 15-minute recess now? And it's 11:07, and I would like to try and get at least a witness out of the way before we break for lunch. Is that agreeable to everyone?
Can I ask a question? Because of some of the footnotes in the issue list, how do you plan to take the issues and the witnesses? Are you taking like 1A, all the witnesses, 1B, or are you going to take like 1 and 2 together? You know, what
I understand your question exactly. I've been pondering it that myself. What you're asking is, do I want to have the same witness up for 1A, have that witness sit down, get up for 1B, get up for 1C? Unless there's an objection, it would be my preference to have a witness for an issue up once, whether it be 1A, B, C, D, E, or so on, and just address them that way, and only change witnesses with numbers.
That makes sense to me. I just was curious.
Are there any objections to the commission handling it that way? I believe that would be more expedient. And I believe we're fairly cramped for time anyway. All right, it's now 11:09. I'll round it to 11:10. Why don't we come back at 11:25? We are off the record and we are in recess. This is going to be a fairly packed day. I would like to go ahead and proceed with the witnesses for issue 1. As I indicated, I believe Lansford is going to be the first witness for Ameren. As I've said before, when Mr. Keevil asked me about it, what I'd like to do is do witnesses by number and not letter. So if I've got a witness up, let's just assume that witness is up there for the question and all its various subparts. MIEC has requested to be excused from the remainder of today's hearing. I will grant that request, so MIEC is excused from the remainder of today's hearing. I'd like to get through at least one witness before we take a lunch break. Because we got so much, I'm probably going to stick primarily to about 10-minute breaks moving forward, and for lunch, I'm thinking we'll probably only do 30 minutes, at least till I get a handle on how tight the schedule is running. So with that in mind, Ameren, go ahead and call your witness. Are we doing mini openings? If you'd like to, that would be fine. So, okay, we will do mini openings.
You okay? I just thought I heard, I was just asking if you were okay. Okay.
Well, let me ask real quick, had the parties contemplated mini openings for each? Because it seemed like Friday, that's what was contemplated.
That's what I thought too.
Well, I'm asking what the other parties thought as well.
Okay.
That's my understanding, although often there's not a many right after the main, for the first issue, but I don't know.
Your Honor, my understanding was parties would have the opportunity for a mini opening if they so chose.
All right, then that's what we will do.
Thank you. I'll try not to take long. I know we need to keep moving. So good morning. My name is Wendy Tatro. I represent Ameren, Missouri, and we're starting our issues off here with issue 1. I think of it as kind of containing 2 different aspects, although there's multiple questions. You have the question of, is securitization in the public interest and expected to provide quantifiable net present value benefits to customers as compared to traditional financing and recovery of those costs? I see that as A, E, F, and G. And then the second area is questions around how the bond process works with the designated staff representative and financial advisor, and I see that as 1B, C, and D, if that helps how we're thinking about it. So starting with the first, and I would point out that you've answered this question back in the Liberty case, who also securitized remaining costs of a retired plant. Theirs was already retired, ours is to be retired. And in that order, this commission said the traditional method of rate making would occur through a general rate case and would entail amortization of costs to be recovered over a period of years, with the company being allowed to recover its carrying costs during the period of amortization. And that amount is the amount that's appropriate to compare to the cost of the securitized utility tariff bonds. And Mr. Lansford has done that comparison. The final numbers can be found in his schedule MJLS for rebuttal 4. The results of that calculation is that the customer pays $125 million less over 15 years, the net present value of which is $78 million less by using securitization instead of using traditional financing and recovery. Now, the Office of Public Counsel defines traditional financing differently. He defines it to include no carrying costs, no return. And that means no other method of financing that includes a return could compete. And that's why, as Mr. Lowry talked about in his opening, it means that the securitization statute could never be used because it could never meet that burden. And as a former legislator, as commissioners, as attorneys in the room, we know that that violates the basic principle of statutory construction, and that is to avoid an absurd result. The statute should be read in a way that allows the statute to make sense and to be used. Otherwise, you'd have to conclude that the General Assembly wasted its time in passing this statute because on its face it's absurd, illogical, and unreasonable. So that lays bare the fallacy of the OPC argument. Now, in rebuttal, Mr. Murray pivots a little bit and includes an argument that even if you look at it slightly differently, in a rising interest rate environment, which is where we are today, you still couldn't meet this standard. I mean, it's probably not as bad as his rebuttal position, but it renders the statute useless. Now I contend, is still an absurd result and should not be accepted. The second topic that we'll be talking about today is the bond process and interactions with the commission staff representative and financial advisor and the role they play post-financing order. The statute sets out very clearly what that is, and that is 393.1700.2, paren 3, paren little h. It says you appoint a staff member as a representative. You hire a financial advisor to advise the representative. The representative is to provide input to Ameren, Missouri, and to collaborate with Ameren, Missouri on all facets of the process undertaken by Ameren, Missouri to place the securitized utility tariff bonds to market, so that the representative can provide the commission with an opinion on the reasonableness of pricing, terms, and conditions on an expedited basis. The other thing the statute says is that the representative cannot direct Ameren, Missouri on how to place the bonds. Now, the issue for you to decide is the language that should be used in the financing order that you're going to issue. It's Ameren, Missouri's position that your order needs to use the language of the statute and not use language that implies authority that isn't granted by the statute. So specifically for 1B, if you look at Ameren, Missouri's proposed financial order, which was attached to our application in this case, engagement with the finance team begins when there's a final and unappealable order. Staff wants it to begin earlier. I think Ameren, Missouri is generally okay with making that change as long as it's not a requirement that any particular meetings have to occur during the time of an appeal, if there is one. But maybe something will be needed. We don't mind bringing the financing team on it. That makes sense. 1C is the issue of the phrase right to review, which Mr. Davis uses in his testimony and is in staff's proposed financing order multiple times. I don't know what review means. Is it something more or less than the right to provide input and the right to collaborate? If it's more, then it goes beyond the statutory authority. If it means the same, then why do we need it? Because the statute says what it says. So I think that's important to figure out and define, and why it's always safest, of course, to stick with the statutory language. Finally, I will note that Mr. Davis uses the phrase lowest cost as the standard for what's being securitized, and I will take it that this was a passing reference, but the language of the statute is actually a bit different. It says lowest securitized tariff charges consistent with market conditions at the time the bonds are priced. And consistent with the financing order. So it's lowest price at lowest cost to customers at the time that the bond, the circumstances that exist when the bond is issued. We're not trying to beat the timing here. The financial order submitted by staff has a few other concerns, and we'll deal with those in cross-examination. But that is the end of my opening statement. Thank you. And I will call Mitch Lansford to the stand.
Thank you. Mr. Lansford, please come up to take the stand. Would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth? Yes. Please be seated. Ameren, please go ahead.
Good morning. Can you state your name and employer for the commission?
Mitch Lansford and Ameren Services Company.
And are you the same Mitch Lansford who pre-filed direct surrebuttal and surrebuttal in this case?
Yes, I am.
Judge, can I ask a question, clarifying question? Do you want me to offer all of his testimony or wait to, because let me try that again. He testifies on multiple topics. Do we want to wait and add it to the record after he's been on the stand for all the multiple issues? I just don't know whether to offer it now or offer it later.
Judge, to the extent that it helps at all, I think that's a valid question on Ms. Tatro's part. several of the witnesses, Mr. Lansford, Mr. Michaels, Mr. Majors for staff, have lots of issues. And I would certainly, I cannot not object to, I would object to the admission of his entire testimony at this time, because I'm not versed in a lot of his issues. So I think each of the people who, familiar with that issue needs to be present when his entire testimony is received into the record. So I think her suggestion that you wait until he's testified on everything that he testifies on to receive it into the record.
So just to be clear, the last time he testifies, we would move all of his testimony into record.
That makes sense to me. I mean, usually we've done it at the time the witness initially takes the stand, but I think there's good reasons to do it differently. So I think that's probably the way to do it.
Judge, I'd add for public counsel an objection to admitting the Sursa rebuttal because of the pending ruling on the Ameren, Missouri's motion.
And any time anybody offers something and it's pointed out to me, like you just did, if it's provisional, subject to objections, or in this case, subject to the filings that were made, that's fine. So we will address it that way. Go ahead.
All right, so I won't offer, but I would like to ask you, Mr. Lansford, if you have any corrections or additions to make to your testimony.
I do have a couple corrections.
Okay, go ahead.
In my surrebuttal testimony on page 1, I used an older template. My position and title changed recently. So on lines 6 and 7, that should be replaced, deleted and replaced with I'm employed by Ameren Services Company as Director of Financial Reporting and Regulatory Accounting. And then one other spot in my surrebuttal, page 6. Mr. Murray corrected some of his schedules, which resulted in necessary corrections to my testimony here. And they're short, but on line 8, reference to Mr. Murray's schedule DSM-S2 should be changed to DM-S-4. And then on line 10, the figure 70 million should be changed to 59 million. And then on line 12, the figure 6 million should be changed to 17 million. Those are the corrections I have.
Okay, I will tender the witness for cross.
Okay. First cross-examination of an Ameren witness is by Renew Missouri, and they are not currently here. MECG?
No cross, Your Honor.
MIEC is excused for the day. I will add them to my... AARP is excused. Staff?
No questions on this issue, Judge.
And is that on issue 1 or any of the 1 issues?
One.
Just 1, not the subs?
Oh, issue 1. I'm sorry.
Everything. Any cross-examination from the Office of the Public Counsel?
Not at this time, thank you.
Any questions from the Commission?
Yes, thank you, Judge. Good morning.
Morning.
I'm going to ask you a little bit about interest rates and your experience. In Mr. Murray's rebuttal, he suggested a 4.05% interest rate for traditional rate making for the net present value calculation, and which he stated was Ameren, Missouri's embedded cost of debt as of December of last year. Do you know what is the oldest and most recent debt issuance included this embedded cost of debt?
What the rate would be?
Mm-hmm.
I do not know off the top of my head. I pointed out, and I do know, that 4.05%, embedded cost of debt is the accumulation of issuances that occurred over the course of 30 years, and approximately 20 different issuances, but I'm not sure what that most recent issuance is. I can actually tell you, Chair Hahn, that Mr. Sagal, who will be testifying later today, likely does know that answer.
Okay, thank you. Included in Ameren's proposed financing order is for bonds to be issued in multiple series and tranches. I do have some experience from bond issuances in multiple series and tranches from my last life, but how would multiple series impact the bond issuance process?
I'm sorry, Chair Hahn. That's a little bit outside of the scope of what I'm, an expert on, and either Ameren Missouri witness Katrina Niehaus or Daryl Sagal would be better to address that question.
Thank you. No.
Thank you, Chair. Just a moment, please. Thank you. I apologize for the delay. Are there any other commission questions at this time? I hear none. The filings of your work papers and supporting schedules in your direct and rebuttal testimony indicates that there were some corrections to the direct testimony schedules made in the rebuttal work papers. Would you identify those changes, please?
Those changes are changes in amounts. Apologies, bear with me here. So specifically, as we look at energy transition costs, that's where I made a couple changes here, and I'll describe them. One change was our estimation or our projection of the capital costs that would need to be incurred from a historical date through the retirement of the plant. We revised that estimation as we were working through discovery with the parties, reduced that down, and that had an effect of reducing net plant in service on line 3 of Schedule D1 in my testimony from $475 million down to $473 million on line 3 of my S1 schedule in rebuttal. So that's one change, reduction in the amount of additional capital costs we were expecting to need to incur to keep the plant safely operating. That effect of of reducing the net plant balance has a minor effect on accumulated deferred income taxes. So keeping with the same schedules, D1 line 7, that the $49,798,000 on line 7 from Schedule D1 reduced down slightly to $49,634,000 on Schedule S1. And then one final change. In my direct testimony, we had two separate line items, one for asset retirement obligations, ash ponds on line 10, and a line item in line 11, water treatment and monitoring, and those are separate amounts. again, through the discovery process, we learned that we have better estimates of those amounts, and really what we were doing is talking about the same thing. So in my surrebuttal testimony, we collapsed that into a single line item, accounted for as asset retirement obligations for the ash ponds, and that revised amount reduced from 2.6 million and 4.6 million in direct, the summation of that, to $4.7 million in surrebuttal on asphalt.
So should any references or any questions about your direct testimony work papers, should those instead be directed to your surrebuttal schedule work papers for at least S5 through S8?
Yes, that would be appropriate.
Now, in your surrebuttal testimony schedule, MJL-D8, line 12, the weighted average cost of capital of 6.88% is applied to both columns B and C. Now, applying the same discount rate to calculate the net present value of the total payments under securitization and the amortization scenarios, that doesn't change whether there's a benefit or not, does it?
That's correct.
It just changes the magnitude of that benefit, is that correct?
Well, let me clarify, if you would, Judge Clark. You're talking about line 12, which is the weighted average cost of capital, and it's being applied as the discount rate. And are you asking that if you changed that discount rate to a different number, would it change the benefits?
Essentially, yes.
It would change the quantification of those benefits. It wouldn't change whether there is or is not a benefit.
Which is ultimately what I was getting to. Do you know what the annual estimated income tax amount is?
The annual estimated income tax, in what context is that, Judge Clark?
I have misread my question. Hold on. Okay, I'm sorry. So essentially, the selection of a discount rate is not as important to the net present value in terms of there being one, correct?
I agree with that.
Okay. In the same schedule, can you explain how line 5 incremental income taxes were calculated for column C?
I can. When you're looking at row 4, the carrying costs, the financing costs, and focused on column C, like you mentioned, the traditional financing and recovery scenario, that 6.88% weighted average cost of capital includes an equity component and a return on equity. And that equity component, that return on equity, would result in income for the company, taxable income for the company, and a tax burden, which is what necessitates incremental income taxes, the authorization of a return on equity as part of line 4 there.
Why is the total from, and I'm looking at cells, I'm assuming that corresponds to cell F15 in your work paper, correct?
Judge Clark, I do have a computer that I could bring up and look at the executable version. Otherwise, I don't have cell references in front of me. Would that be okay?
That would be absolutely acceptable to me.
May I approach?
Please. Yes.
I can see from here there's something on the monitor at the witness stand. On the screen, I don't know what it is, but I do.
Thank you, Brian.
I have that called up.
Okay. And in what we just talked about in regard to line 5 and incremental taxes, calculate column C, that corresponds to cell 15, F15 in your work papers, correct?
That's correct.
Why is the total from cell F12 multiplied by 0.01862?
That's to reverse out the debt component of the weighted average cost of capital. So and isolate the incremental income taxes to just the equity component.
And are the incremental taxes the result of the bond principal being recovered in revenues?
The incremental taxes are a result of recovery of the financing costs, the carrying costs in this traditional financing and recovery scenario. That's represented by column C here.
Okay, so more than just the principal.
That's correct.
Why is it only appropriate to include incremental income taxes in column C, amortization?
If comparing to column C to column B, column C includes financing costs through a means of traditional financing and recovery. That includes that equity component. It's that equity component that contributes to taxable income and necessitates income tax costs. A debt-only scenario, which is what we're evaluating in column B, has no contribution to taxable income and therefore no need for incremental income taxes. The interest expense, coming from the debt is a deduction on your tax return.
Now, do you have your schedule MJL-S8 in front of you?
I do.
Okay. Line 5 description is carrying cost, and this is the interest rate to be applied to the total on line 3 in monthly payments over 50 years, except column C also includes the incremental income taxes. Is that correct?
I think you said line 5 includes the carrying cost, but it's line 4, but otherwise, yes.
Oh, thank you. Now, in that same schedule, say cells D17 and F17 show the Excel formula to calculate what's described as the monthly payments. Is that correct?
That is correct.
And a lot of these are just to kind of clarify so that I can.
Sure, absolutely.
And D27 and F27 calculates the net present value of an investment based on the discount rate in a series of future payments. And here that's 15 years times 12 or 180 payments. Is that correct?
That is correct.
And line 25, the income, and this, I'm sorry, this is a different schedule. MJLS 7.
Okay, I'm flipping to that now. I'm there.
And what I'm trying to do is try to clarify amounts in your surrebuttal schedule. The income tax qualified here on line 25 in column B is only related to the capital subaccount and not the income tax on the bond principal, right?
That's correct. The capital subaccount only.
Now, in the Empire, are you familiar with the Empire securitization case to an extent?
To an extent.
Okay. If this is beyond you, let me know. Empire included income taxes as an ongoing financing cost in the final issuance advice letter that was submitted to the Commission. Will Ameren or the special purpose entity be required to pay similar income taxes?
It depends on how the Commission orders as it relates to another issue I think we have reserved for Wednesday around accumulated deferred income taxes, but it could.
If the Commission were to decide, and are you familiar with how the, and I'll just call it ADIT, are you familiar with how the ADIT was resolved in Empire?
I am fairly familiar.
Okay, if it was resolved the same way, would Empire, or would Ameren be required to pay those taxes?
Yes, we would have incremental income taxes to add to the ongoing financing costs here.
Okay, do you know the estimated value of that amount?
I've quantified that. It's approximately $3.7 million on an annual basis over the 15-year period.
did you include those estimated, I'm sorry, were those income taxes included in your estimated and ongoing financing cost, and ultimately the net present value calculation for the securitization scenario?
The, my Schedule S8 reflects the company and staff's position as it relates to ADIT, which does not require any sort of incremental ongoing financing costs. Therefore, it does, therefore those incremental income tax costs as ongoing financing costs are not reflected in
Okay,
Schedule
so,
S8.
so, and just to clarify, you didn't look at the scenario where the commission might determine ADIT the same way as Empire, correct?
I don't have any testimony, on that. You'll get roughly the same net present value. It's similar to your question as it relates to the discount rate. You could change the discount rate and you could change the NPV of benefits, slightly, but you won't get a different decision or a different conclusion whether there are or are not net present value of benefits. If you pivoted to the Empire method, I'll call it, for ADIT and income taxes ongoing financing costs, you'll similarly not change your conclusion. You won't get a different conclusion whether there are or are not net present value of benefits.
Okay, so even if you did the tax calculation the way Empire, the way the commission ordered Empire to handle ADIT, you would still have a net present value.
That's correct.
Thank you.
Judge, can I ask, when you stated that last follow-up, did you mean the net present value benefit?
Yes. Bear with me just a moment. What happens if Fresh Island doesn't retire on October 15th? What changes then?
Well, a lot of the costs that we have here as energy transition costs, and which ultimately impact the net present value of benefits calculation here, could change, would change, slightly. Maybe I'm not getting to the right.
No, I think you are. I think I haven't been as clear. Let's say that the commission grants securitization, and let's say that the plant doesn't close on October 15th, but for whatever reason, MISO petitions the court, whatever, it stays open. Has Ameren looked at that scenario?
That would be sort of outside of my scope, unfortunately, Judge Clark.
No, nothing unfortunate about that. If I'm asking a question that doesn't apply to you, then that's the correct answer.
I'm trying to think if I could point you to the right witness to answer that question, and I'm honestly not sure who might answer that question.
And this you may not be able to answer this question either, but I'm also going to ask it also for the benefit of your attorney. Now I'm going to hold on that one. Those are all the questions I have. Any recross?
I do if no one else does.
Well, hold on. I'm just going to kind of go through my list.
Okay.
MECG?
No, thank you, Your Honor.
Staff?
No, thank you.
Mr. Williams, it is your turn.
Thank you. Well, looks like it's afternoon now. Good afternoon, Mr. Lansford.
Good afternoon.
Do you remember the questions you got from Judge Clark about ADIT, and you talked about you calculated a $3.7 million per year income tax impact if the commission treated the ADIT the same as it did in the Liberty case? Do you recall that?
I do.
When you did that $3.7 million per year income tax impact, did you give any credit beyond, well, let's back up. How much is the balance anticipated to be for ADIT as of October 15th of 2024?
Approximately $136 million. That reflects the total balance of ADIT, including excess deferred income taxes, which is often, which is one component of ADIT.
Thank you, that's what I was looking for. And if you follow the Liberty approach, what would be the net present value of ADIT for purposes of the offset to what would otherwise be the securitization amount?
The Liberty approach, as I understand it, would result in approximately $88 million offset to energy transition costs. I think that's Mr. Riley's position in this case.
And what's the difference between the $136 million and the $87 million in terms of dollars?
It's $49 million, which is the offset that the company recommends to energy transition costs in this case.
And that $49 million, is that dollars that Ameren, Missouri anticipates the benefit of which would flow to customers?
The benefit of the $49 million would flow to customers as a reduction of energy transition costs in this case.
Under the Liberty scenario of calculating ADIT?
I'm sorry, I'm not following that question. Could you please?
Well, if I'm trying to find out if your answer was predicated on Ameren, Missouri's approach or if it's predicated on the Liberty approach. Because the net present value is the $87 million, but the difference between the $136 million and the $87 million is $49 million, which is going to be an amount that Ameren, Missouri will be retaining currently, correct?
Could you restate that question, please?
Okay. The total ADIT balance as of October 15th is $136 million, anticipated to be, correct?
That's correct.
Under the Liberty approach, $87 million of that would be used as an offset to the amount that's securitized, correct?
That's correct.
And the $49 million would still be on Ameren, Missouri's books, would it not?
The entirety of the $136 million deferred tax liability will be on Ameren's books regardless of any offset to energy transition costs as part of this case.
Well, if the plant's retired, why would it show up on, why would ADIT for Rush Island show up on Ameren, Missouri's books post-retirement?
Because we owe those tax liabilities to the taxing authority in future periods. You must retain that balance on your books until you satisfy the obligation.
Do you have any IRS authority for your position?
No. Yeah, I don't think the IRS would be the authority for that, necessarily for that. We're talking about financial accounting, books and records. So it is, in conformity with GAAP, but I don't have a citation for you on that.
Whenever you're calculating the income tax impact at $3.7 million per year, did you take into account the $49 million at all?
Absolutely.
And how did you do that?
If you were going to go with the Liberty approach, which is, I'll simplify it to that, as I understand it, reduce energy transition costs by $87 or $88 million. That's instead of reducing energy transition costs by $49 million. The difference between the $87 or $88 million and $49 million is approximately $38 million, and that's the exact stream of costs of future obligations that you'd have to solve for if you were developing or determining the income tax related ongoing financing cost that would be necessary to calculate. So you're trying to produce, so that calculation, the $3.7 million on an annual basis over 15 years, produces a net present value of the difference of 37 or $38 million, the difference between OPC's position and the company and its staff's position as it relates to offsets to ADIT in this case.
Does it include any carrying costs?
It does not.
But under the statute, ADIT would not be an offset against rate base, correct?
If you're asking whether in the next general rate proceeding, sort of outside of the securitization case, whether ADIT relating to Rush Island would offset rate base in that proceeding, it's my understanding the statute calls for that to be excluded from rate base offset going forward.
And then Judge Clark asked you some questions about what if Rush Island didn't close on October 15th of 2024, what kind of impact it would have. Do you recall those?
I do.
Didn't Ameren, Missouri do essentially a comparison between September 1 and October 15th in its direct case?
Both our direct case and our surrebuttal case, but I'm not aware of any analysis that goes beyond October 15th like Judge Clark was contemplating.
But you can look at a month and a half of impact between September 1st and October 15th to get a sense of the magnitude of the impact.
I believe that'd be appropriate.
No further questions at this time, thank you.
Any redirect?
Yes, thank you. So, Mr. Lansford, I want to go back to this idea of Rush Island not closing on October 15th that you talked about both with the judge and Mr. Williams. Do you remember those conversations?
I do.
First of all, what is your understanding of whether there's any real likelihood of Rush Island operating beyond October 15th?
I'm not aware of any likelihood of that occurring. I thought we were ordered to close it no later than October 15th. But again, that's my understanding.
And who would have placed that order?
That order came from Judge Sippel in the NSR case, as far as I'm aware.
So presuming for a moment, let's say Rush Island stayed open for another month. I think the scenario that the judge said was, perhaps MISO says we need them and petitions the judge and he agrees. So let's assume that happened. Is there a process in the securitization that would reconcile the difference?
Absolutely. Any difference between actual costs and estimated costs are required per the statute to be reconciled in those future general rate proceedings to make sure that customers ultimately just pay the exact actual cost that occurs.
And when I use the word reconciled, do you understand that to mean giving back to customers?
Yes, either recovering from or giving back, both ways. I think I think the statute contemplates getting the numbers correct.
I don't have any further questions. Thank you.
Thank you, Mr. Lansford. You can step down.
Judge, may I ask a question? I know we were planning on going to lunch. I know everybody wants to go to lunch. Ms. Niehaus has a flight this evening, so I was curious if there weren't very many questions, could we put her on so that she can head back to St. Louis to catch her flight?
Are there any objections to going ahead and putting on witness Niehaus prior to taking a lunch break, or is everybody just wanting a lunch break now?
I don't anticipate extensive examination.
Mr. Keevil, do you have an extensive examination for for Niehaus?
No, not extensive.
Okay, let's go ahead and take the next witness.
Thank you. Ameren, Missouri calls Katrina Niehaus. I bet somebody has questions.
Ms. Niehaus, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Please be seated. Ameren?
Good afternoon. Can you please state your name and place of employment for the commission?
Katrina Niehaus and Goldman Sachs.
And are you the same Katrina Niehaus that filed direct testimony in this case?
I am.
Do you have any corrections or additions to make to your testimony?
I do not.
And if I were to ask you the questions that are contained in your written testimony, would your answers be substantially similar?
They would.
I move, I don't know what this exhibit number is, probably 2, 4, sorry, exhibit 4, into the record and tender the witness for cross-examination.
Any objections to admitting Exhibit 4 onto the hearing record? I hear and see none. Exhibit 4 is admitted onto the hearing record. Please proceed. All right. Any cross-examination from, well, Renew Missouri's not back. MECG?
No, thank you, Your Honor.
Any cross-examination from the commission staff?
Very briefly, Judge. Good afternoon, Ms. Niehaus. Have you had an opportunity, or did you, I know you had an opportunity, did you review the, well, let me ask a stupid question here, Judge. Is she up here on just point 1, issue 1, or is she also up here on issue 2?
On issue 2, hold on.
I believe she was listed as an Ameren witness on issue 2, but I don't know what you know.
Are you going to be calling Ms. Niehaus for issue 2?
Am I? No, I'm not. But
No, not
Yeah.
you. I'm asking
She is listed on issue 2, so,
if we're trying to catch a flight.
yeah.
right, that's why.
Our,
That's why I
our
was
people,
wondering.
yeah, that's a good, I apologize for not mentioning that when I made my request. So are our people able to do their cross-examination on issue 2 of her now or not?
I have no objection with that.
Does MECG have any objection? And no other parties are here right now. So we will go ahead and take up both issue 1 and 2 with Ms. Niehaus for expediency's sake.
Thank you very much. And thank you for catching that, Joe.
Yeah, no problem. Ms. Niehaus, back to my question I was going to ask. Did you read the list of issues in this case?
Do you have a copy of it I can review?
Actually, what I have here is Public Counsel's statement of position. Pass that over to her. Where it says 2. Yeah, give it to her.
Thank you.
Do you have a copy for me?
No, that was my only copy. Sorry.
Do you want to share it with me? Can you ask your questions without it?
Oh, yeah, well,
Okay.
I need it back before we answer.
Is this OPC's position statement?
Yeah.
Is there a particular position you'd like me to focus on for the purpose of the
No,
question?
not honestly. I just wonder if you've seen these before. Have you read these?
I have not.
Okay. Well, then if you hadn't, it's a good thing I gave it to you because you're going to have to be able to,
Do you need your copy back?
yeah, it would be nice.
May I approach?
Please.
Oh, I can read it off this computer, Wendy. That's,
Well, she's already got it.
okay, there she is.
All right.
Thanks. Ms. Niehaus, one of the questions here under 2A1 says, should the issuance advice letter include a comparable securities pricing analysis as recommended by OPC witness Murray? Have you read Mr. Murray's testimony regarding the issuance advice letter and whether it should include a comparable securities pricing analysis?
It would be relatively unusual to include such an analysis, given there are not a significant number of comparable securities for the purpose of comparing utility securitizations or rate reduction bonds to other securities in the market. And so it is not something that would be done as part of the issuance advice letter in general for these types of transactions.
Okay. 2B issue states, should the certification letters provided by the underwriters and staff's financial advisor be redacted rather than classified as confidential in their entirety? Do you have well, first of all, let me ask you, the underwriter certification letters being classified as confidential in their entirety, are you familiar with that?
I am.
And why are they classified as confidential in their entirety?
As far as I'm aware, all underwriter certifications have been classified as confidential. They are provided to Ameren, who is the underwriter's client in this case, and are made available for their use. The certifications contain things like confidential sort of trade secrets process as far as how bonds are marketed and other information that a underwriter would be unlikely to want to share with the market more broadly. It's their secret sauce for how they do deals, and that is part of why you would hire Goldman Sachs as opposed to another bank, for example. Additionally, from a liability perspective, in general, I believe most underwriters would require that the certification be held confidential. And, you know, without holding it confidential, you may even have certain underwriters who are unable to participate in a transaction because of the additional liability you'd be asking them to take on.
So do you believe requiring public counsel's, or adopting, I should say, public counsel's recommendation would reduce the number of responses that a utility company would receive in response to solicitation for underwriters in future securitization proceedings?
It would be a deviation from market standard, and I suspect would require careful analysis by all of the underwriters and potentially additional costs to compensate them for the additional liability they would be taking.
Okay. Let me, excuse me, I'm going to skip C and go to 2D, which asks, should the commission order Ameren, Missouri to provide the issuance advice letter and supporting work papers to other interested parties at the same time it provides information to staff's finance team? Do you have an opinion on that?
What other parties are you referencing?
Well, I'm assuming it would be, well, let's limit it to parties to this case.
I think the way that the process has run in Missouri is the market standard, and deviating from that would require an analysis by Ameren and underwriters and other participants. I'm not clear on what is trying to be achieved through this, and so maybe if you can give me some guidance on, what other parties and what direction you're going in, I can be more helpful.
These are my positions or issues, so I'm not exactly sure myself. But did I hear you say that what has been done in the Empire and the Liberty, Empire is Liberty, the Empire and the Evergy cases in Missouri is consistent with industry practice?
I was not involved in Evergy. I was only involved in Empire, so I can only speak to that. And Empire was in line with other transactions I've worked on in the market.
Okay. What other states have you worked transactions?
So quite a long list, starting from west to east.
Let
Hawaii,
me go this way.
California.
How many? Can I just ask how many instead of?
I have it somewhere in my testimony. It
Okay.
would be I would have to go back and look, but we are one of the primary underwriters of these transactions, and I've been involved in quite a number of states. Hawaii, California, Florida, Texas, New Hampshire, Missouri, Michigan, South Carolina, Kentucky. Probably I'm missing a few.
Did you read Mr. Murray's rebuttal testimony in the section specifically on post-financing order process and procedure?
I would have to refresh on that. I don't recall what it says.
Okay. I think that's all I have, Judge. Thank you.
Any cross-examination from the Office of the Public Counsel?
Yes, thank you. Good afternoon, Ms. Niehaus. You were involved in the Liberty securitization transaction in Missouri, correct?
Was, sir.
Do you know what bond yields were achieved for that transaction?
The shorter class priced at 90 basis points over treasuries. I'd have to look at the exact bond yield. I'd need to pull some papers from my files. And the longer tranche with an 11-year weighted average life priced at 95 over.
And were you the person who certified that those yields were the lowest possible cost?
At the time of issuance, yes.
How did you determine they were the lowest possible cost?
So it's a extended process. First, it's about confirming that we've gone out to the broadest possible market. So that's ABS investors, corporate investors, and municipal bond investors. It's a combination of looking at subscription levels in the bonds. So how many orders do we get in? What feedback are we getting as part of those orders or that bidding process from the market? Understanding how that book is kind of composed and come together. Certain investors may have minimum yield targets or have indicated that they have minimum spread requirements as part of their order. Their order sizes may change and fluctuate depending on what the ultimate pricing level is. We then also compare the pricing levels to other types of securities. None are perfect, but it is everything from from municipal bonds to corporate bonds to ABS securities, and we also then look at secondary market trading levels. And as you look at all of that, so how the process was run, as well as how the transaction has come together in the context of the market, we're able to make the certification.
And I think you may have done it, but I just want to confirm. You mentioned that you get market feedback. Did you explain what market feedback you were referring to in your answer?
So market feedback will come in with orders from investors. That feedback may be something like, my order is good at 90 basis points over the reference treasury rate. I drop out at 85. Sometimes we get that kind of feedback. Sometimes we do not. Investors may share different amounts of information. It's a little bit like you putting an offer in to buy a house, right? It is a competitive process, and depending on how competitive it is, they may share different information to try to be helpful or assure that they get allocations of the bonds.
Does Goldman Sachs intend to provide its certification letter in this case as confidential in its entirety?
Yes, that would be the market standard.
Why is everything in such a letter confidential?
So as I explained before, the letter is written for the benefit of Ameren, who is the client of the underwriters. The information that is provided in there includes, in certain cases, trade secrets around process, how we run our process, what we look at as sort of comparative investment opportunities, and if all of that information were to be made public, other banks who are peers and competitors of mine would be able to say, I've reviewed all of the certifications and I understand how these deals work, and so therefore I should be a part of the next transaction. Additionally, the information needs to be reviewed in its entirety to really understand how the deal came together. And so redacting is challenging because, I think as you have to get the full picture of the complexity of the transaction and the market at the time of issuance. And then third, by making this public, you're exposing your underwriters to additional potential liability. And in general, there would need to be compensation in some way through additional indemnifications, or additional payment for that additional liability, which would, theoretically drive up the price of the transaction. And then additionally, you're deviating from market standards, so certain banks, their legal departments may not even allow them to participate if the certification were to be made public.
Couldn't those portions of the certification letter that are considered to be trade secret or otherwise disclosing process information, I guess, be redacted and the remainder of the letter made public?
I think reviewing the letter without understanding the entire process is not useful, right? You need to understand the entirety of the process that was undertaken. And then again, you are asking the underwriters to be exposed to additional liability, which would deviate from what I am aware to be market standard. And usually there are costs with deviations from market standard.
So a letter that just showed that Goldman Sachs had done a certification letter on the Rush Island transaction bond issuances would be such a deviation it would cause problems, even if the confidential or trade secret, I'll call it, information was redacted.
As you think about providing the letter, in general, one of the facets of, or one of the pillars that we rely on is you've adhered to market standards and you're attempting to achieve the lowest cost by running a process in the most efficient way, right? Adding additional or changing from 25 plus years of market standards for providing these certifications would likely incur additional legal costs as you have to have additional review. It may, as I mentioned, put certain underwriters in a position where they are unable to participate, and in general, it would be a deviation from the market standard.
Who sets a market standard?
25 years of history.
And how long has Goldman Sachs been involved in creating that market standard?
I have been involved in all of the transactions Goldman has been a part of for the last 19 years. I joined the firm in September of 2005. Prior to that, I would have to go back and check, but I believe Goldman's first participation was in the late 90s with the California transactions in the market.
So pretty much back to the beginning of the market?
Yes. I am not aware of any deal that has deviated from this standard.
No further questions at this time, thank you.
Are there any commission questions?
Thank you, Judge. Thank you, Mr. Niehaus, Mrs. Niehaus. Earlier, I'd ask a question of Mr. Lansford, and I think you might be the more appropriate person to ask. Can you talk about the benefits of offering either multiple series or multiple tranches? It looks like you had perhaps suggested a single series with 2 tranches. Can you talk about why, the rationale behind that?
Sure. So for these transactions, the idea is that you want to create classes or tranches of debt that are most attractive to the market and are going to result into the lowest cost for ratepayers, depending upon the shape of the yield curve, investor sentiment in different investor types, so banks versus insurance companies versus asset managers. You want to cut up the cash flows so that you're able to produce bonds that are most relevant based on the market conditions at the time of issuance. So we do know that as part of the financing order, you will set what the last payment date is, and we will know what the shape of the bond cash flows need to be, where we cut the bonds, and whether we do a shorter class and a longer class, one longer class, 3 sort of medium, three medium-sized classes. That will all be dependent on market demand at the time and where we think we're going to be able to get the most traction with investors and reach the broadest type of investors. So for example, at the moment, corporate-style bond investors prefer longer duration or longer maturity bonds, and so we have suggested a longer class that would appeal to those corporate-style investors. If something were to change in the market and corporate investors were not to be as interested in these types of securities, we may choose to do a single class, or we may choose some other structure. That is, sort of, and I'm saying we may, but, sort of the underwriters may. That is sort of the regular process for how these bonds are issued. Whether it's a single class or multiple classes, it would not change the timeline for the bonds to be issued.
That's really helpful, thank you. Does that multiple series or multiple tranches, does that impact the cost to the company for issuance, or is it a flat fee? How does that general structure work?
So in general, underwriters are paid, it is generally 40 basis points on the total size of the transaction. So whether it is one class or three classes or four classes, underwriters are not paid in a different or compensated any differently.
That's very helpful, thank you.
Are there any other commission questions? I hear none. I've got a few questions, and I'm going to bounce around a bit, so
I'll do my best to follow you.
thank you. I'm going to start with what's most forefront in my head in regards to Mr. Williams' cross-examination. Would it be fair to say that, that based upon your answers, that changing from what is market standard for the certification letter will either or both narrow the pool of available underwriters and increase the costs of underwriting?
I think that is a fair statement. At the very least, it would require, in my experience, significant legal review, which requires significant lawyer costs, sorry to the lawyers in the room, as they bill by the hour and you're doing something that deviates from the market standard. And you are also asking underwriters to take additional liability. That will require a reevaluation by underwriters as to whether that is liability they are willing to take, and that may result in underwriters falling out of a competitive process.
Now, as you indicated, you've been involved in both so far the Asbury securitization as well as now the Rush Island securitization case. What do you see as the major differences in securitization between these two retirements?
So I think size of transaction is probably the most notable. This will be a slightly larger transaction, which may allow us to have more flexibility on a single class versus multiple classes for the issuance, as we look to create bonds with liquidity in each class that make the most sense for investors. And I think that is really the big difference. The nice thing about this transaction is the investor universe will be used to seeing Missouri transactions. They will understand the Missouri Commission and their process, and they will understand the strength of the legislative process in Missouri. And so, to some extent, that makes the marketing of the second or third transaction a little bit easier because you're not breaking new ground.
What are the impacts of multiple series on the upfront costs outside of the underwriter's fees?
There should be no impact. Aside from achieving the lowest cost by creating bonds that are most favorable from an investor's perspective.
Now, you had an opportunity to listen to Ameren's mini opening, correct?
Mm-hmm. Yes, sir.
And in that, there was some talk about the right to review and staff finance team participation, and I know that you have nothing to do with any of that. However, certainly it is of concern, given that we've done a few of these now, and the paces have varied. And certainly it's a concern that if staff and their finance team cannot be involved until an order is final and unappealable, a lot of that is in the control of that puts a lot of control of how much involvement the finance team has in the hands of the utility, depending on how proactively the utility engages with the SEC. So in other words, one difference that I noted between the Evergy and the Empire securitizations is when the SF1 was filed. And whereas it appears that Liberty waited a while to file the FS1 until they had a better idea what was going to happen in the order, it looked like Evergy went out and almost immediately when the order was issued, filed the SF1. Do you have an inkling of if the commission were to approve securitization, when Ameren would start engaging with the SEC in this?
I haven't discussed that with Ameren.
How are current market conditions different from when Liberty securitized Asbury?
Up until last week, I would say the market felt very strong for the last few weeks, and market had felt better than at the point in time that Liberty brought their deal. We have obviously had some relatively significant geopolitical noise over the weekend, and we are heading into an election cycle. So whether the strength of the market that we saw last week and the week before continues on, that will be a little bit dependent upon how things resolve themselves on a global level and sort of noise around the U.S. election and many other factors that are outside of all of our control.
So would it be correct to say you don't know?
If I knew, I wouldn't be sitting here. I'd be on the beach in Hawaii somewhere.
Now, you heard me ask, I'm assuming you heard me ask about ask Mr. Lansford, what if it closes after October 15th, correct? Is it unusual for securitized utility tariff bonds, and you may not know the answer or it may just have not come up, is it unusual for a plant to not close prior to the issuance of securitized bonds, or is it a requirement that it does?
The use of proceeds from securitization is vast and really covers a wide range of needs for a utility and the ratepayers in their service territory. There are deals where financings are done before the money is spent, and there are deals where only after the money is spent or amounts are final is the securitization done. It really varies depending upon the will of the particular commission and the situation at hand.
Have you been involved in a securitization where bonds were issued prior to the closure of a facility?
Not that I can recall with regards to closing a plant, but I have been involved in securitization where the securitization is issued before the money, before the project that has been identified is fully complete, or money may be used for expenses in the future around storm hardening, or in Hawaii there was a green bank effectively that was set up for renewable energy projects that had not been undertaken yet. So it really can vary depending upon the specifics and the jurisdiction.
Thank you, Ms. Niehaus. I have no further questions. Mr. Williams, you were leaning in?
I do have one.
I've got a couple, Judge, and I think Mr. Williams probably should go last.
You're right.
Does that matter? You okay?
Go ahead, staff.
Ms. Niehaus, Chair Hahn was asking you about multiple series and tranches. And first of all, can you tell me what's the difference between a series and a tranche?
They are often used interchangeably.
Okay.
We also sometimes call them classes.
With the series, you call it class?
A class, a series, a tranche.
A tranche.
There's various names for a particular grouping of cash flows.
Okay. Is Ameren, in this particular instance, requesting authority for a specific number of issues, a specific number of series or a specific number of tranches, or is Ameren requesting authority for, say, one or more, multiple series or multiple tranches or one or more series? What exactly is the request?
I am not positioned to speak to what Ameren is requesting, but in general, the way this works is there is an approval to issue under one or more class or tranche. And the number of classes or tranches will be determined at the time of issuance based on market demand to achieve the lowest charge possible for customers.
So whether they wind up going with one or more is generally part of the structuring or decision-making process?
That is correct.
Okay. Judge Clark was asking you some questions about the finance team, and I believe he said you had nothing to do with the finance, or he thought you had nothing to do with the finance team. I remember sitting in some finance team meetings in which you were attended, so I mean, you do have some participation in the finance team process, do you not?
To the extent you're hired as underwriter, you are generally a part of the process with your utility client. And so a bank would work with their client to converse with the members of the finance team around transaction structure, process, market dynamics, et cetera.
And when you say a member of the bank or a bank, when you say bank, you mean underwriter?
Underwriter, yes.
Right. Nothing further. Thank you, Judge.
I have one quick question in there that you made me think of, and then Mr. Williams, I'll let you. It might. Would multiple tranches, series, classes require multiple issuance advice letters?
No, it's a single issuance advice letter that encompasses the transaction as a whole.
Thank you. Mr. Keeble, does that?
No, that sprung no questions from me.
Go ahead, Mr. Williams.
Thank you. When you were testifying in response to questions from Judge Clark, you reiterated that certification letter disclosure would add liability for underwriters. I'd like to explore that just a little bit. If protected information such as trade secrets were not disclosed in the certification letter that was made publicly available, would it still add underwriter liability?
Well, I'm not a lawyer, so we probably should be speaking to a lawyer about the specifics of underwriter liability. But in general, my point of view is that by redacting information, the issuance advice or the certification may be misleading without reviewing it in its totality, and so it doesn't really add much or give, it would be highly unusual, and it is potentially even misleading if you're providing it in part and not in whole.
No further questions, thank you.
MECG, I didn't ask you if you had any recross. Any redirect from Ameren?
Yes, thank you. Ms. Niehaus, you were asked a couple questions, some from the judge, about if you were involved in any cases where bonds were being issued for a plant that hadn't yet closed. Do you remember those conversations, those questions? Do you know if Missouri statute allows for bonds if the plant is not yet retired?
I believe it does, but I would have to go back and review.
Okay, fair enough. In your opinion, the fact that Rush Island hadn't actually closed, does that complicate or cause problems with your marketing with the bonds? And if so, what would that be?
I don't expect it would cause any problems. We have the legislation, which is final, and the financing order that is irrevocable and non-bypassable, non-appealable, and those two components together being finalized are really what investors rely on. And so, whether the plant has closed or is about to close, as long as the issuance amount cannot change and there is no ability to revoke or adjust the charge, it should be okay.
And are you familiar with the utility bond process that happened in Michigan?
I am. Oh,
And-
well, I guess which one? I have been involved in one of them and not involved in the more recent one.
Have you been involved in the one where the plant was not yet closed?
I think that was the more recent CMS deal, is that correct? I was not.
Are you familiar with it?
Generally, yes, but I was not a part of the process, so I wouldn't have details on marketing.
Okay, thank you. I have no further questions.
Thank you, Ms. Niehaus. You may step down.
Well, I assume she is excused since she's done testifying.
Are there any
She'll-
objections to excusing Ms. Niehaus? Hearing no objection, Ms. Niehaus, you're excused. Thank you for your time today.
And thank you to my colleagues for letting her go, and I know we extended lunch. Thank you.
Well, it is now 12:47. I would like to take about a 30-minute lunch break. So if we can all be back here right around 1:17, that would be great.
Your Honor, on behalf of MECG, this is Tim Opitz back here. I'd ask to be excused for the remainder of today's hearing, if that's okay with Your Honor.
I will grant that request.
Thank you.
Thank you, Mr. Opitz. We will go off the record. record. And when we left off, we had just finished with Ameren witness Niehaus. At that time, Mr. Keevil had indicated off the record that he was going to be making a motion on the record.
Yes, Judge, it's nothing controversial, but my consultants are in from out of state and have a 7 o'clock flight out of St. Louis. So I didn't know if we need to take them out of order or if, the cross on Mr. Sagal is going to be so short, that's not a problem or whatever, but I'd like to make sure that my consultants are able to make a 7 o'clock St. Louis flight.
Okay, are there any objections to deviating? Right now, the way I have it, I have Segal up next, followed by Murray, Majors, and then finally Davis. And we're talking about Davis, correct?
Correct.
No other witnesses other than Davis?
Correct.
Okay. And Davis is only necessary for issues 1 and 2, correct?
Correct.
So it'd be very similar to Niehaus. We'd just be taking staff's financial advisor out of order for those issues.
Yes.
Is there any opposition to going ahead and doing that?
None, Your Honor.
Okay, I've heard, I hear no objections, so we'll do that. At this time, staff, would you like to call?
Yes, Your Honor. Mr. Davis, we call Mark Davis to the witness stand. If he's here. Those 30-minute lunches don't give the out-of-town consultants much time to find a place to eat lunch.
I apologize, and I wish we didn't have to do that, but we are on a very, very packed schedule. So I already anticipate that we're probably going to be here past 5:30 tonight. So, Mr. Davis, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
Yes.
Okay. Staff, your witness.
Thank you, Your Honor. Would you please state your name and spell it for the record, sir?
Mark S.A. Davis, M-A-R-K, S.A. Davis, D-A-V-I-S.
Are you the same Mark Davis who's caused to be filed in this case, the rebuttal testimony of Mark Davis?
Yes.
By whom where do you work, sir?
Ducera Partners.
And what's your position at Ducera?
I'm a partner.
I don't know if you're aware, you probably, I haven't told you, so you probably don't know this. Your pre-filed testimony has been marked as exhibit, here it is, exhibit 112. And did you have both public and confidential versions of your testimony?
Yes.
Okay. And so they've been marked 112 and 112C. Do you have any additions or corrections you need to make to those pieces of testimony?
No.
If I were to ask you the questions contained in Exhibits 112 and 112C, would your answers be the same today as they are contained in that testimony?
Yes.
And are those answers true and correct to the best of your information, knowledge, and belief?
Yes.
Judge, with that, I would, since this is Mr. Davis's only day here, I would offer Exhibits 112 and 112C.
Any objection to admitting Exhibit 112 onto the hearing record? I hear and see no objections. Exhibit 112, the surrebuttal testimony of Mark Davis, public and confidential, is admitted onto the hearing record.
Thank you, Your Honor. With that, I would tender Mr. Davis for cross-examination on issues 1 and 2 on the issues list.
Okay. Of the parties we have remaining here, I guess by default it is public counsels. Cross-examination.
Thank you, Judge. Good afternoon, Mr. Davis.
Good afternoon.
Are you responsible for filing a certification letter after the bonds are priced if the commission authorize Ameren, Missouri to securitize Rush Island energy transition costs, and Ameren, Missouri goes forward?
No.
Are you required to file a certification letter in conjunction with Ameren, Missouri issuing securitized bonds for Rush Island if it goes forward with doing that?
No.
Are you required to confirm that the structuring, marketing, and pricing of any securitized utility tariff bond that it issues as a result of this case is consistent with market conditions?
Maybe to cut through it, the contract that Ducera has with staff has a option in there for staff to request a letter from Ducera related to obtaining the lowest cost issuance based on market conditions at that point in time, and I believe that's what you're trying to get at.
So it's optional, it's only if staff requests it?
I believe that's correct.
If you were to issue such a letter, or do such a letter in response to a staff request to do so, would that be your independent opinion?
Yes.
And would that be a qualified or unqualified opinion?
So the letter would contain various assumptions and information relied upon, such as facts provided by the utility, the underwriters, and other parties as part of it. So certain assumptions would go into ultimately delivering the statements required under the contract. The conclusion of those statements would not be materially qualified.
So in rendering your opinion, then you're permitted to rely on third-party information without verifying that information, is that not correct?
That's my understanding, and I'm not a lawyer, but certain information that goes into providing that letter or information provided by the utility would need to be relied upon to practically deliver any type of letter on the time frame that's contemplated within the contract.
What do you do? Let's say you go forward and do the certification about the pricing of the securitized utility tariff bond is the lowest charge consistent with market conditions. What would you look at for purposes of rendering that opinion?
So it'd be pretty involved. I would say to start, the process is incredibly important, making sure that the issuer has gone through a thorough and complete process prior to issuing the bonds. So going through from the start, the underwriter selection process, and making sure that it received views of all of Wall Street on the best way to structure, market, and price the bonds. Making sure that the overall marketing process is sufficient in terms of obtaining AAA credit ratings from an appropriate number of rating agencies, making sure that the investor presentations are complete, that are put together for investors, making sure that the marketing process involves adequate time for investors to do their work and submit orders, making sure that the pricing and structure are analyzed in a way that obtains what's anticipated to result in the lowest all-in cost and attract the broadest universe of low-cost investors, and then making sure the pricing process itself, as the underwriters market the bonds and tighten pricing as much as possible based on the circumstances at that point in time.
You were involved in the Liberty securitization and the Evergy West securitization in Missouri, correct?
That's correct.
Was there information in conjunction with those securitizations that you did not independently verify but relied upon?
I'm sure there was. I couldn't tell you offhand what the particular items are, but I'm sure that would be an important element of being able to deliver the letter that was requested.
Can you identify the nature of the information?
I think it was information provided by the company and underwriters, probably amongst others. I'm sure some written, some verbal.
Did you review information that was in the issuance advice letters in those cases?
Yes.
Did you review anything in the issuance advice letter other than the bond pricing?
Yes, I reviewed the issuance advice letter in its entirety.
Did you review the calculations of the quantifiable net present value benefits of securitization as identified in the issuance advice letters?
Yes, we received the issuance advice letter, including the NPV calculations, and reviewed those with staff.
Did you find any errors in those calculations?
I don't recall.
In those cases, did Ducera file its certification letters as confidential in their entirety?
I'm going to object to that. Ducera didn't file anything in that case as far as I remember. Staff filed things. Ducera didn't file things.
Ducera is staff's witness.
All the same, if they didn't file anything, it negates the question. Is there a way you can ask the question differently?
Did Ducera request that its certification letter in those cases be treated as confidential in its entirety?
Yes, I believe we did.
Why?
A lot of the information contained in those letters, as I think you recently heard from the Underwriters Council, underwriters, very similar to what you heard from them. A lot of the information contained in those letters are proprietary trade secret information. It's I think it is effectively the secret sauce of the process that we go through, and something that others could seek to replicate if they were to work through that type of process. In terms of the degree of information that was included in those letters and the confidential nature of all of the information within those letters, I do think it's important that information not be taken out of context when reviewing the letter.
I'm picking up a little feedback. If you're participating via WebEx, would you please mute yourself? I'm picking up what sounds like some road noise.
What's your understanding of the purpose of the Ducera certification letters?
My understanding of HB 734 was it was to provide specific information to staff, to the staff designated rep, or effectively to our clients, and to provide them work product that they could then use as part of their review, and the obligation that staff had to provide a direct letter from staff to the commission, providing transparency through the process.
And can you, if you can you tell the nature of the secret sauce that would be revealed in that letter without disclosing what the secret sauce is?
I think that's a difficult question. The process, everything that we go through as part of the issuance review process with staff, the items that we look at and review as part of that process could form a roadmap, effectively for competitors to come in and try and replicate the process that we work through. So it could provide a path for other parties to show up and replicate what our business.
I think your answer is that you're saying that you cannot.
I intended to provide what I could get at, if it was helpful at all for you.
Do you know what the bond yields were for the Evergy securitization bonds?
Not the exact yield offhand,
Do you know approximately what they were?
approximately 5%.
And did Ducera certify that that approximately 5%, whatever it actually is, was the lowest possible cost?
I believe our certification, you're getting into confidential information related to another proceeding. I don't know if that's what's public in that regard.
I'm just asking whether you certified in that case that the yields that were in those bonds were lowest possible cost or not.
I believe the letter that we provided was filed confidentially.
Okay. Can you tell me why it would be confidential as to whether or not Ducera certified that the actual bond yields were the lowest possible cost?
Offhand, I'm not certain what information is confidential, what information needs to be in camera, and what information can be disclosed with another utility. And so given the nature of that, I'm reluctant to directly share that unless I hear otherwise from counsel.
Judge, would you direct him to respond? I don't believe he's going to be disclosing any confidential information. I'm just asking him whether or not he did that certification in those cases or not.
I understand. Let me inquire of staff a little bit, because this is, I don't want to cross any bounds, and staff technically is the client, and my understanding is you owe a fiduciary duty to the client. Is that correct?
That's correct.
So it would be staff's determination, in my thought, as to whether they could release that, although I do believe that is a job of, I do believe that's kind of the purpose for which they're retained.
I don't, first of all, Judge, I don't think what Mr. Davis' firm provides to staff is a certification. I believe it's an opinion letter or some sort of would be classified as an opinion. I do know under the statute, his firm is not required to file anything with the commission. It's you, in fact, were the judge on both of those that ordered staff to turn around and order, or not order, but to request Mr. Davis and his firm allow staff to file that letter confidentially. So, yeah, I mean, that's the whole, personally, I don't see the point of Public Counsel's entire issue 2 here, where they want they don't like the way staff and Ducera interact, or they want to be part of that interaction without being statutorily authorized to be part of that action, or directed to be part of that action, or interaction, I should say. Yeah, everything that Ducera provides to us, I consider to be like a attorney-client sort of communication between staff and us and Ducera. And so then when you got into the process of ordering us to then turn that over to the commission, that caused a little bit of heartburn itself. But since it was the commission by whom I am employed, I decided to go ahead. Better part of valor would be to go ahead and file the thing. But in order to do that, I had to get permit. There are contractual provisions running back and forth between us and Ducera, and frankly between the commission and Ducera, because I think technically the contract was with the commission, but with Ducera. And part of the letter even is, and I think it's in the contract, that only the client of Ducera, which in this case would be staff, would be authorized to rely upon in any manner or form to rely upon that letter. So, yeah, I mean, I consider Mr. Davis's letter to be like an attorney-client communication between his firm and us, as me, as whatever you want to call it. So, yeah, I have a problem with this entire, I don't think these are valid issues. I don't think they should even be on the, if you've paid attention to Mr. Williams' cross-examination, he's been crossing on the Liberty case and the Evergy case, hasn't asked a stinking question yet about the Ameren case. That's what we're here for. We're not here for them to air their angry laundry about the previous cases that are now done. So, yeah, I mean, this entire issue is problematic for us.
And what specific issue are you referring to? Issue 2 in its entirety?
Yes.
Because I certainly think, it appeared to me when I was looking through this that at least part of, if not the thrust of public counsels, was to ascertain essentially, since costs, including the costs of Mr. Davis, are costs that are going to be included in the securitization, that he was going to be asking questions that were in relation to that cost. Is that what we're talking about?
No.
What are we talking about?
We're talking about the advice that staff receives from their consultant regarding their professional expert analysis of the utilities and their utilities underwriters' actions in structuring, marketing, placing, selling the bonds, and whether those actions, in the expert opinion of Mr. Davis and his firm, whether those actions by the other parties meet certain industry standards, and whether by virtue of all of that, then the bonds or meet the applicable standard.
Okay. Where are you going with this?
Staff has used Mr. Davis in the past, which establishes some of what he has done, and we're anticipating he's going to do something similar in this case, which is not, we haven't reached that stage in this proceeding. So that's the purpose of asking some of the background information. And we're not asserting anything's been done improperly, but we're looking to see what has been done for understanding what to anticipate will be done and the cost that's associated with that.
Well, and that's fine, and I'm going to let you ask questions, but at least in regard to where you are now and asking about this letter, I believe you've hit a wall, and I'm going to, there's, Mr. Keevil, I'm assuming you're objecting to him answering?
Yes, I'm objecting to this entire line of questioning, in fact.
Well, dealing with this specific question in regard to the letter, I'm going to sustain the objection.
Thank you. How will Ducera analyze the reasonableness of, let me back up. Assuming staff requests Ducera to do it, how will Ducera establish that Ameren, Missouri's securitization transaction will achieve the lowest possible cost?
Judge, again, I'm going to object, and this one's a little different. As Mr. Davis mentioned, the entire process that these financial analysts from Wall Street and beyond go through involves certain information that they consider proprietary. That's what he's just asking. He says, what are you going to do proprietary to be able to turn around and tell your client's staff what your analysis is? So, he can't, like he can, he just did, but he should not be allowed to be delving into proprietary, confidential procedures of Ducera's period. I mean, it's irrelevant. And I mean, what they're really asking about is the contract process that was initiated and gone through back whenever Ducera was retained by staff for this case. I mean, they don't like the process. They don't like the contract, apparently, that came out of the process. You know, if they want their own advisor, they're free to get their own advisor, but they can't now. We're bound by the contract that was arrived at between staff and the commission and Ducera, and he should OPC should not be allowed to basically try to divulge or get into the things of a proprietary nature like this.
Mr. Williams, would you like to respond to the objection?
I think public counsel's entitled to explore what the financial analyst for staff is doing, that staff relies upon for making recommendations and providing information to the commission. And if it's proprietary and we need to go in camera, we can do that. I don't intend to delve too much deeper into this topic.
Why is it relevant?
Basically, to some assurance, quality assurance that the staff and the public are getting value for what they're paying for the financial analyst services.
Again, I don't think this is the proper place.
Hold on, Mr. Keeble. Let me think for a moment. I'm going to sustain the objection. I think staff is perfectly capable of protecting their own interests. And while you've mentioned the general public, I believe that the stuff you're asking about is part of what the consultant has agreed to do for staff. So I'm going to sustain that objection.
If I may
Yeah.
offer something, of course, ultimately the public will be paying, well, the public who's served by Ameren, Missouri will be paying for Ducera services,
Okay.
one way or another.
Thank you. Do you have further questions for this witness?
Sure. At what rate are you compensated for your services?
I don't know if that's confident. I mean, that can be answered, I believe, but I'm not sure
I
if it can
think
be answered
that's-
in public.
I'm sorry?
I'm not sure if it's public, or that's my only question.
If we need to go in camera for that, I'm fine going in camera for that, but I do believe that that's a question that he should be able to answer.
And I believe it is public if you go out on the state's website about contracts.
Staff, is that correct?
I don't know.
Is this
I don't
information that's
spend- I don't-
publicly available?
I don't know.
And
I believe it's already pre-filed as an attachment to one of Mr. Murray's testimonies. It's his Surrey Pedal testimony, DM-S-8.
and that's a non-confidential schedule? Or
Correct.
is that correct, Mr. Davis?
I'll take their word for it.
Do you want to take a look at it?
No, I know the rate.
Okay, then you may go ahead and answer the question.
It's a monthly rate of $225,000 per month.
And when did that, when was the contract executed for that rate?
I believe the contract was executed at the early part of this year, beginning of the year.
Would late January sound correct?
I'd accept that subject to check.
You don't know, but that time frame at least?
That time frame.
And when did payments start becoming due? Or when did amounts due accrue start accruing under the contract?
I'd need to confirm. I don't know offhand.
Well, is it what triggers amounts due accruing under the contract? Is it execution? Is it something else?
I don't know the trigger. I would need to confirm.
What I really want to know is it a monthly amount that initiates on execution of the contract, or do Sarah have to do something in each month in which it accrues the $225,000?
I would need to check. I don't know.
Judge,
I'd have to check with counsel.
according to Mr. Williams, the contract is a schedule attached to an exhibit. So all of those things that Mr. Williams just asked are already there if he'd only read the contract. And if he wants to put it in the record when the proper time comes, if such a time comes, then, it's in the record. Otherwise, we're spinning our wheels here.
Is that an objection?
Yes.
Would you care to rephrase it as an objection?
Well, irrelevancy.
Would you like to respond, Mr. Williams?
I think it's highly irrelevant what customers are paying for the services they receive.
I don't disagree with you there, but at least the way you were starting to head down it, it seemed to be asking him about what it was he does for the contract, which again seems to be getting into exactly the objection that I sustained earlier. So if the contract is publicly...
Well, when I read the contract, I was unable to discern whether or not it started on execution or if some service had to be provided in each month for which an amount accrued. It wasn't clear to me exactly how the parties to the contract are operating under it, so that was the purpose of my questioning, and in fact, I didn't intend to go any farther with it.
Well, he's answered the question.
Mr. Keeble,
Judge.
give me a second. Sorry.
Sorry.
Keep doing this, but I just need... The hamster can only run so fast.
Well, he's already answered.
Yeah,
He
he's
doesn't
answered
know.
that he doesn't know, so...
I'm done.
Well, by your own admission then. Do you have any further questions for this witness?
Not at this time, thank you.
Okay, Mr. Kaufman, you have joined us again. Do you have any cross-examination that you would like to add, or that you would like to do for this witness? You would have been first on the list, I believe.
No, Your Honor.
Thank you. That is AARP and Consumer Council of Missouri. Ameren, Missouri?
Yes, thank you. I'm going to be asking you questions about the statute and also the staff's proposed financing order. Do you have those with you?
I do.
Okay. Great. So I want to start by talking about, well, first in your rebuttal, I presume you have a copy with you, on page 8, line 12. Let me know when you're there.
Okay, I'm there.
And do you see, at that point, it uses the phrase lowest cost standard? I think it's in the header right there.
Yes.
And then again on page 12, line 11. You testify about the goal of obtaining the lowest possible cost for customers. Do you see that language?
Yes.
And then I'll only go one more. On page, that is not right. Hang on, sorry. Still page 12, line 14. You have the phrase mandate to achieve the lowest possible cost. You see that?
Yes.
And you use that phrase lowest cost or lowest cost standard in other areas of our testimony, but I won't go through that, but you would concede that is true, right?
Yes.
Is lowest cost language from the statute?
I think it's shorthand for the language from the statute.
Okay, let's talk about the statute. If you have that with you.
Yes.
393.1700.23cc, I think is where you find that language. Tell me when you're there.
Do you have a page number by chance?
I do not, just a statutory reference, sorry.
Could you give that reference again, Ms. Tatro?
393.23cc.
Yeah, I got the 393.17.
23cc.
23cc.
The C is in parens and then the next C is not.
Yes, I'm with you.
Okay. And that, the language that's actually used in the statute is that lowest securitized utility tariff charges consistent with market conditions at the time. And when it says at the time, it's talking about when the bonds are placed, right?
Yes, that's my understanding.
So when you use the phrase lowest cost, that's actually what you mean.
Yes.
Because technically it's slightly different meaning, don't you think?
And I believe the distinction you're making is looking at market conditions at that point in time and agree that it should be measured based on the market conditions in effect at that point in time.
It's not the lowest possible cost at any time. It's given the conditions that exist.
Right. It's based on that point in time. That's right.
Okay, perfect, thank you. So now if you go back to your testimony and turn to page 15. At lines 2 to 4, you use the phrase finance team, and you define that, but that's not a phrase used in the statute, is it?
No, the term finance team, I don't believe appears in the statute.
Okay, so just to make sure I'm clear, you're using that term to mean the individuals set forth in the statute that have a role in providing advice to the commission. Would you agree with that?
I believe that's what you've described is the basis for formation of a finance team, and in reference here to the finance team comes from the draft financing orders that more explicitly call out what the finance team would be.
Okay. The statute lets the commission hire a financial advisor, which is you, correct?
Commission or commission staff, that's right.
And you're a member of the finance team?
We're advisor to the finance team.
You're advisor to the staff representative that ultimately will provide their opinion to the commission, is that correct?
And maybe to take a step back, I don't believe the finance team has been formed at this point in time, so I think that would be determined ultimately through what goes into the financing order.
Fair enough. Would you expect there to be a staff representative on the financing team?
Yes.
Okay. Let's turn back a page to page 14, line 19. You're talking about Ameren, Missouri's proposed financing order. Let me know when you're there.
I'm there.
So it says the commission has authority to designate a representative or representatives from the staff to collaborate with Ameren, Missouri. That's in the statute, right?
Sorry, I want to make sure you're on page 14, line 19?
Yes, line 9.
Line 9, okay.
Thank you,
Yep.
Nathan.
I'm with you now.
All right, and that comes from the statute? Yes?
I'm reviewing the language here.
Okay.
Give me 1 second.
Sure.
So this actually comes from the Ameren proposed financing order rather than from the statute. I think the question is addressing what Ameren proposed as part of the financing order.
Okay, exactly. Let's do that again. So Ameren's proposed financing says the commission has the authority to designate a representative, and you agree that that is from the statute. It's consistent with the statute.
Consistent with the statute, I think, better said, yes.
Fair. Next, Ameren's proposed financing order says that neither the designated representative from staff nor financial advisors, have the authority to direct how the bonds are placed to market, and that is also consistent with the statute.
Correct.
Okay. Then it says the Ameren, Missouri proposed financing order says that the staff representatives and the financial advisors can attend all meetings convened by the utility to address placement of the bonds to market. Would you agree that's consistent with the statute?
Yes.
Okay. Then on page 15, you list 3 concerns with Ameren, Missouri's proposed post-financing order process. So if you would turn to page 15, please.
I'm there.
So in the paragraph starting on line 2, you take issue with the word review not being included in the finance order. Now, you agree with me, the statute says that the it doesn't say finance team. It says the staff representative has the right to provide input and the right to collaborate with the utility. Provide input to the utility and collaborate with the utility. Is that accurate?
Yes, I believe the statute outlines certain items and also provides flexibility for the commission to determine other items that it deems appropriate that aren't inconsistent with the financing order as part of the pre-issuance review process.
Okay, where do you find that flexibility for me? Can you give me a statutory citation?
I believe it's 39323C O.
Include other conditions the commission considers appropriate?
Yes.
So how do you interpret the word conditions?
And I'm not a lawyer. I'm not probably qualified to interpret what the statute says.
Okay, can you give me your understanding, because you just told me that that portion is what you rely upon in order to add additional language, so I just want to make sure I understand what you think it means.
I believe what the statute is getting at is providing flexibility for the commission to determine what it deems appropriate as part of the review process that's undertaken prior to issuance of the bonds.
You have a statute in front of you?
Yes.
Can you look at the portion that you just cited to me? Do you have that?
Yes.
So the condition right before it says an outside date which shall not be earlier than a year after the date the financing order is no longer subject to appeal, when authority to issue securitized utility tariff bonds granted in such financing orders shall expire, right? That's a condition, yes?
Yes.
And the paragraph before that talks about treatment of ADIT, correct?
Yes.
And the paragraph before that talks about the procedure that allows the electric corporation to earn a return at the cost of capital authorized from time to time. Right? It's talking about how things work, correct?
Yes.
Conditions that have to be met.
I believe that particular item covers conditions that have to be met. That's right.
So how does the language in O modify CC? In your opinion, as you understand it.
I'm not a lawyer to interpret that language. CC indicates that there's findings that need to be made. O provides the ability of the commission to impose other conditions that aren't inconsistent with the section of the financing order.
Okay.
So they appear to be related, but again, coming from a non-lawyer.
Okay, fair enough. Let's talk about your use of the word review in your testimony. So I think page 15, paragraph 2, you take issue of the word review not being included in the finance order. Do you see that?
Yes.
How is review different than providing input to Ameren, Missouri, and the right to collaborate with Ameren, Missouri?
The items may be related. My understanding is past financing orders issued by this commission provided for the right to review as part of the process, receiving information, having some obligation of the utility to provide information for the avoidance of doubt of making sure that the finance team has the ability to fulfill its responsibilities of providing input and collaborating would, in a lot of ways, require information to be provided directly to the finance team. I believe that's something that the commission's ordered in past instances. So I think removing that information could be perceived as taking away a right that otherwise, may exist, or at least historically was expected to exist. So including that language in this instance, I think, is helpful to not create any type of expectation that there isn't a right to review information that may be necessary in order to provide input and collaborate.
So you think the statute is unclear?
I think the revision to what's proposed in the financing order creates unnecessary ambiguity.
Okay, but just to be clear, I can't decide if this is form over substance or whether you're trying to get something in addition to the right to have input and to collaborate. So you are just saying it's just clarification to make sure that that the staff representative who's on the financing team has the right to provide input and the right to collaborate with the utility. It's not intended as anything additional.
I would say it's also important to make sure that information is provided and made available to the staff representative to be able to interpret the information and fulfill its responsibilities. It'd be very difficult in order to provide input and collaborate without receiving information. But the fact pattern of changing an approach of something to something the commission's ordered in the past could be perceived as changing the responsibility of the utility. And for the avoidance of doubt, I don't see value in changing that past precedent.
So if the commission order says, we think you already have the right to access these documents through the statutory language, and so we're not changing the process, we're just sticking to statutory language, would that not solve the problem?
I think it's better to stick with what the commission's ordered in the past and not create ambiguity.
Okay. The third condition that you talk about is you want the finance team's responsibilities to commence when the financing order, excuse me, I don't know, I'm losing my voice, why the financing order is issued regardless of when it becomes non-appealable. Do you see that portion? It's probably the next page over.
Yes, I see it.
Okay. What work is there work that's required to be done during the time, let's assume for a moment that there's an appeal. Is there work that's required to be done while that appeal is pending and before you have a final and unappealable order?
Excuse me, Judge, I would check just for vagueness. When she says required, she's talking about required by the commission, required by the 393-1700, required by whom?
Ms. Tatro, would you clarify?
Sorry, required by the statute.
I think it depends when Ameren is looking to commence its process. If Ameren is looking to commence the SEC review process and draft SF1s and have those ready to go immediately upon the financing order becoming non-appealable, or if they're looking to commence the rating agency process or other long lead time items in advance of the financing order becoming non-appealable, those types of items are items that are important for the finance team to be involved in, and in the event that they develop without the finance team having the authority to review those items, it could create irrevocable activity that the finance team's not able to participate in. So those types of items, in the event that Ameren is looking to commence its post-financing order pre-issuance process before the order becomes non-appealable. Having the flexibility in order to do that could be valuable.
Okay. If Ameren, Missouri doesn't start any of that SEC work until after there's a final and unappealable order, are there any such irrevocable decisions that you would have a concern about?
I touched on the rating agency process. The underwriter RFP is oftentimes something that takes place relatively early in the process. So various items that, they're looking to commence, or if they're looking to enter into the rating agency engagement letters prior to engaging with them. Those types of items are important to make sure are reviewed as part of that post-financing order pre-issuance review process, to name a few.
Okay, so you are not, with this recommendation, seeking to force any type of regularly scheduled meeting. You are seeking, if Ameren starts work on any of those types of documents with the underwriters, you want the finance team to be able to be involved. Is that fair?
Yes, if Ameren's seeking to commence the process and commence items that typically would require the finance team's review, those items should be reviewed in advance of creating irrevocable action or taking
Okay.
irrevocable action.
Were you involved in the Evergy securitization?
Yes,
Do you know when the Evergy financing order became final and unappealable?
not offhand.
Does November of '23 sound right?
I'll take that subject to check.
Okay. Do you know when Evergy filed its initial registration statement?
Not offhand.
Do you know if it was before or after the order became non-appealable?
Not offhand.
Okay. Did you review the initial registration statement that Evergy filed before they filed it?
I believe I did and counsel did, but I'd need to confirm.
Okay. So do you believe that there was an opportunity to provide input and collaborate?
Yes, I believe there was the opportunity to do it, but it's unclear whether or not there was an explicit obligation of the utility to engage with the finance team, and so creating that explicit obligation could be beneficial.
Okay. So you're not alleging that Evergy kept the finance team out of any of these conversations, you just want to make it explicit in the order,
Correct.
and nothing further? You're not attempting to create some type of process?
Would you define what you mean by create some kind of process? Create what?
Let me just ask a different way. I guess the concern that I have as I look at this is I think the company is willing, and we said in our opening statement, the company was willing to share this information with you, and we didn't have an issue with changing it so that we work with the finance team for work that happens before the order is final and unappealable. What I'm trying to get from you is to ensure that we're also not looking for make work. So if Ameren hasn't started drafting the SEC registration statement, we don't need to have a meeting to say to you, we're not doing anything yet. Is that fair?
Right. The intent of this language was to ensure that the process, that irrevocable action does not take place, is at least, with respect to my testimony, what I was trying to get at, not to create incremental standing meetings when there's not a need for them.
Okay, thank you. I want to talk to you a little bit about the issuance advice letter. You're familiar with those?
Yes.
And you're familiar with the ones that have been issued here in Missouri for Evergy and Liberty?
Yes.
The Office of Public Counsel suggests that the issuance advice letter should include a comparable securities pricing analysis. Do you know what a comparable securities pricing analysis means?
I think it could be interpreted a lot of different ways, but oftentimes we'll look at comparative pricing when going through the issuance process, and I do think it's appropriate to look at comparative pricing when going through an issuance process.
Is it typically part of the issuance advice letter?
No, I haven't seen that before.
Would you say that you have not seen that before? Is that what you just said?
Outside of what was provided in public counsel's testimony, that's correct.
Okay. OPC's witness also recommends that the certification letter be made public, or at least partially public. Were you here when Ameren, Missouri witness Katrina Niehaus testified?
Yes.
Do you have any reason to disagree with any of the reasons she gave as to why that letter should not be made public or even partially public?
No, I agree with the statements that she made that there is risk, although there, it sounds appealing to provide this type of information publicly. There is risk that it could deter participation of underwriters in the process, could, be additive to the overall cost of the process, and detrimental to the ultimate issuance and price that's received through the issuance process. So I don't disagree with the statements that she made.
Thank you. So now I'd like to talk about staff's proposed financing order, which you said you also have a copy of. Were you involved in the drafting of this document?
I reviewed and provided comments on the materials, or
Okay.
on the financing order.
Okay. Would you turn to page 8, please?
Okay.
Let me pull my copy, sorry. Paragraph 16.
Okay.
Would you agree with me that there will be incremental income taxes associated with the return? $16? It just talks about the WAC there.
Sorry, I don't follow your question.
Would you agree with me that there will be incremental income taxes associated with the return that Ameren, Missouri earns on this securitized bond?
So taxes are better addressed with a different staff witness.
Okay. Now all right, let's go to page 10. By the way, do you know what staff witness would be the person to talk to about that?
I believe it's staff witness Majors.
Page 10, paragraph 23.
Okay.
It has a restriction about the administrative fees not exceeding $50,000. You see that?
Yes.
Do you know if that's per tranche or if that's for the overall financing?
I believe that's for the overall financing.
Okay. Page 27.
Okay.
Paragraph 14.
I'm there.
Can you give me an example of when a non-standard true-up provision would be needed?
I'm going to object, Judge. Mr. Davis has already testified. He did not draft this. I have already explained that in the event that there is a conflict between staff's evidence and testimony or on this issue, with the provisions in this proposed order, that the evidence that's been previously presented shall control. I don't understand why she feels it's necessary. This is like if I was to inquire with Mr. Sagal as to, Ms. Tatro's motion to do something or another. She's inquiring of a financial witness regarding a legal document that was. It's not even a document. It's a proposed document. It's not even a document. And there's a provision in there, like I said, that to the extent that there's something in here conflicting, because it's whatever it is, 72 pages long. There could be a conflict in here between something that some other witness testifies to and what's in here. And now she's,
Mr. Keeble,
yes.
I believe that it's pretty clear that this is not the commission's financing order. And I believe that it's fairly clear that this is staff's proposed financing order. I believe the caveats you've laid down about differences between it and potential testimony are clear. On the other hand, I also remember having some confusion about what exactly a non-standard true-up provision was in a previous proceeding. I'm going to continue to let Ms. Tatro ask questions about general concepts in there and maybe how those concepts are represented there. But I am aware that this is not the commission's order and that this is just a proposed order that's,
Judge, there's the true-ups will be covered in a tariff, I assume. So I believe that if a party were to have tariff-related questions, such as true-up, such questions should be directed to staff's tariff witness,
Well,
which is not Mr. Davis.
hold on, Ms. Tatro, what do you want to know about non-standard true-up provisions?
I will let non-standard true-up provisions go if that bothers Mr. Keeble. But what I would say is I find the statement that I have a footnote that says if I got any of this wrong, you have to go back to staff testimony is A, I can't believe we aren't trying to get the proposed order correct. And B, I think that only causes confusion in the future. And confusion makes the whole bond issuance process more problematic. So in general, I'm trying to gain some clarity around what was intended. Now, Mr. Davis may not have drafted this, but he said he read it and provided comments. He's familiar with it. So I think I have a right to seek as to what his understanding was when he gave advice back to staff. That's what I'm trying to do.
And I will let you probe into that to a degree.
Fair enough. Thank you. I'm going to move on to paragraph 60. I believe it's on page 29.
Okay. Now, that's an issue that Mr. Davis can address since it's dealing with finance teams.
Great. Thank you.
See the difference?
Okay, I'm perfectly agreeable if you all want to address me. But there's no reason for you to be addressing each other as attorneys in this room, not involving me.
Thank you, Your Honor. So, Mr. Davis, in paragraph 20, about 2/3 of the way down, it talks about, so the designated representatives from staff and the financial advisor are permitted to attend all meetings, participate in all calls, emails, and other communications relating to the structuring, marketing, pricing, and issuance of the securitized utility tariff bonds. Do you see that?
Yes.
What about meetings? So first of all, the statute has a limitation, does it not? The statute says it's meetings convened by the utility. Is that right?
I believe the statute explicitly calls out meetings convened by the utility, but doesn't, as we talked about earlier, constrain what the commission can order as part of its financing order.
What about conversations between Ameren attorneys and Ameren individuals who are dealing with this bond process that might be privileged? Do you think that the commission has the ability to force Ameren, Missouri to reveal privileged conversations?
The hypothetical is difficult. Could you give me an example of the type of communication you're referring to?
Legal advice about what the statute requires or what the financing order means?
I don't believe that would tie back to directly the structure and marketing and pricing of the issuance. I'm not sure that this would directly implicate that type of communication.
If there was a privileged conversation about structuring, marketing, or pricing, would you agree that the privilege should be protected?
I could see value, and I'd want to think about that more and discuss it more with counsel, but I could see value in
maintaining the ability of Ameren to have privileged communications.
Might you have privileged communications with the attorney advising the commission?
Yes.
Would you want to maintain that privilege?
Yes.
Might the underwriter, such as Ms. Niehaus, have a privileged conversation with a Goldman Sachs attorney?
Conceptually, I don't disagree with that.
Okay. And when you say you don't disagree, I assume that you mean you don't disagree that it should remain privileged?
Right.
Okay. Let's talk a little bit about the marketing, which is one of the items listed there at the end of the sentence. Are you familiar with the marketing process that the underwriters use with these bonds?
Yes.
Does the underwriter group take calls from potential investors who ask questions about the bond issuance?
Yes.
Is it your understanding that the finance team should be looped into all of those calls?
I think there's certain instances where it may not be practical to involve the finance team in any of those types of inbound calls to a broad sales force across a syndicate of underwriters. However, I've seen in past instances finance teams be able to work effectively and come up with reasonable protocols on how to receive information that's coming out of those types of discussions to make sure that the finance team can adequately and appropriately take on its responsibilities without hampering or slowing down the all-in process to the extent it's not feasible to be on each of those individual calls.
Okay, great. I like that practical answer. So there was a process, I believe, in the Liberty and Evergy orders where if something like that happened, it was reported back to the finance team. If there was a conversation that happened because someone called in and gave some type of information, was that part of the process?
I don't know that I'm able to comment on past processes, but recommending or proposing something like that in this instance doesn't sound inappropriate.
Okay. I think the problem here is with the word all, right? You think there could be a better descriptor that we could use to ensure that things that are informational and would be helpful to the finance teams are provided to them. But if Daryl Segel sends an email, does that mean every email has to copy everyone on the finance team?
I could see it being appropriate to, early on in the finance team process, establish protocols on the way that the utility and underwriters engage with various parties and follow those protocols throughout the process. But I do think that it's important that the commission authorizes the finance team and gives the finance team the ability to participate in a way that allows it to garner the information that it needs out of the marketing process and make sure that information makes its way back to the finance team throughout the process.
Okay, great. Same page, paragraph 61.
Okay.
So this paragraph talks about, it says that Ameren, Missouri and the lead underwriter provide a written certificate to the commission, and it's supposed to certify 4 different things. Do you see those?
Yes.
The first is that the bonds comply with the financing order. The second is that the bonds comply with other legal requirements. The third is that issuance of the bonds provides quantifiable net present value benefits. And the fourth is that the bonds result in lowest securitized utility tariff charges consistent with market conditions at the time. You see that?
Yes.
Is it typical in your experience that underwriters certify legal questions?
The underwriter scope in my experience typically informs the amount of information that they certify to. So the scope of their involvement informs what makes its way into the certifications.
And if the underwriters have to certify legal questions, then inherently they're going to involve their own attorneys to make that decision, correct?
Yes.
Do you think that impacts the cost? And I mean cost of the underwriter, of course.
In isolation, it would certainly impact the legal cost.
In the Evergy or Liberty cases, did the underwriter certify that there was compliance with all legal obligations?
I don't recall offhand.
Okay. What about the net present value calculation? Is the underwriter the appropriate party, individual, to be certifying that the net present value calculation is correct?
I think the underwriter's work will inform what the issuer puts in their certification related to the NPV savings. So the information that they're able to provide on the overall cost of the financing and securitization elements of the financing itself.
But the language in the statute requires them to certify the NPV calculation itself, doesn't it?
Again, Mr. Davis has said he's not a lawyer. The statute speaks for itself. We can all look it up after we get out of here.
This has nothing to do with the statute. This is
You
what
said
this
the
paragraph.
statute says, does it not?
Mr. Keeble, I've asked you to engage with me, not her.
I'm said, she said.
All right.
Perhaps
What's your, hold on, everybody stop. Mr. Keeble, what's your objection?
That the statute speaks for itself.
Ms. Tatro, would you re-inform me of what your question was?
Yes, my question was, is it appropriate for the underwriter to certify that the quantifiable net present values benefit?
Mr. Davis, are you an underwriter?
No.
Do you ever act as an underwriter?
No.
Is that a question you can answer?
No.
May I rephrase the question?
Yes, you may.
In your experience, have you seen an underwriter certify the quantifiable net present value benefit?
I'd have to go back and look at certifications that we've received. I don't know offhand.
Okay. I have no further questions. Thank you.
Are there any questions from the commission? Okay, I've just got a few for you, Mr. Davis. Now, you've been involved in 2 Missouri Commission securitization cases, correct?
That's right.
Were there any differences in the timing of staff's involvement in those 2 cases? Or shall I say the finance team's involvement?
I believe it was very similar in both instances. My recollection is at least one of the processes kicked off before the financing order became non-appealable prior to appeals coming in. But outside of that, I think it was very similar in terms of the involvement of staff.
Did as you said, little differences between those 2 impact the finance team's ability to contribute and provide input?
No, I think there was sufficient engagement from the utilities and at least enough, given the nature of the utilities in those instances, enough specification in the financing order and willingness to work collaboratively together that the finance team was able to fulfill its obligations through the process with those slight differences.
Bear with me, Mom, just a moment. What is different between these two statements as outlined in issue 1D? The size, selection process, participants, allocations, and economics of the underwriter and any other member of the syndicate group compared to the selection process for the underwriters, including with respect to allocation and economics.
Bear with me 1 second, I'm just flipping to the issue list. Okay, so the difference between the two is the inclusion of the word size and the word participants that I believe are missing from the proposed financing order that was put out by Ameren relative to the prior financing orders. Size I would think of as the number of underwriters that are participating in the process. So whether or not you have a single lead underwriter or multiple lead underwriters, effectively the number of underwriters that are involved in the process is important. Oftentimes we'll go through and look at relative comps, and we'll ask underwriters as part of the RFP process, as everybody's trying to win this business, how big of a team do you need in order to get the best execution and achieve the lowest cost on this? So having information or having the ability to inform the process based on the appropriate number of underwriters to be involved in the issuance process is helpful and not explicitly outlined in here, and a notable change from the prior two financing orders this commission has approved. The participants would be the individual participants themselves, right? Who participates in the process, who the utility goes out to receive proposals. So are they going out to a narrow universe of potential banks to get feedback? Or are they going out, very broad to Wall Street? And we've found in many processes that we've been part of, going out to a broad portion of the market and asking for feedback around how do we best achieve the structured marketing and pricing of this issuance? What are the different things that you recommend? While each of these banks are competing to win the business, getting that information from a broad universe of underwriters is helpful, because we can then take that back as part of the finance team review process and recommendations that are made by the selected underwriters and compare it. Here's what all of Wall Street thought we should do for this particular issue. Here's what's recommended by the lead underwriters for this particular issue. And so having the benefit of making sure, we've got a broad group, we've got the right group, and we've gone out to the right institutions that are active in this market, and not just institutions where there's a relationship or otherwise where the utility is engaged in the past, but going out broadly to the folks that are most active in this market is helpful in garnering information that we can then use through the finance team review process. So that those two differences, the number of underwriters and the particular underwriters that participate is what we're trying to get out with that language.
Okay, so you believe that difference is significant?
Yes, I think it's very important to make sure that the finance team has the ability to be involved in those aspects of the process. It's unclear if Ameren was intending to remove those items, but it's notably different than past financing orders, and I believe it's important that those same protections are in place in this financing order.
Okay, thank you. Now, you remember right before me, Ameren's attorney, Ms. Tatro, was asking you questions, right?
Yes.
And during one of those questions, when she asked you to answer, you said, "I'm still reviewing," correct?
Yes.
And what were you doing then?
Reading the language that I believe you were referring to when I was referencing, I believe, my testimony, looking for the language that she was looking for.
Do you believe that you could have answered her question without reviewing that document?
I don't know. I was looking for context of what she was asking before answering. So I typically like to have the benefit of the context.
Do you believe that you could collaborate in the post-financing order process if you did not review all documentation that was not privileged?
Oh, sorry, Judge. I thought you were referring to something totally different when she asked me to find language within my testimony. So the review process itself, in terms of making sure that the finance team receives information that it can review as part of the finance team review, is incredibly important. I don't think that without receiving information that can be reviewed, the finance team can be fully effective through the process and provide the input and collaboration that is necessary in order to fulfill the role of the finance team. So receiving information that can be reviewed is important to the overall process.
Okay, do you believe you could collaborate as part of the finance team if you didn't review documentation?
I think it would be difficult and ineffective.
It's been implied that review is inconsistent with the statutory language of 393-1700. Do you believe that reviewing is inconsistent with collaborating?
No, I think it's entirely consistent with it as a concept. In order to collaborate, it's important to have all the information, right? Receive information, have all the information that all parties are looking at, being able to review and digest that information, prepare questions, and be prepared to engage on any particular topic. So I think that the two concepts go very closely hand in hand. I think it's helpful to have it spelt out in the finance team process in the finance order that in the finding of facts that the finance team has the ability to do that, to review information, to make sure that it engages appropriately with the utility and has the necessary authority to engage with the utility and receive information, because I think it'll make the process more effective. But I think you could provide input and collaborate better with more information.
Do you believe that using the term review provides any additional rights, such as the right to approve or to veto anything?
I'm sorry, Judge, could you repeat that question?
Do you believe that the word review infers any right to do anything such as approve or veto something?
No, I don't believe having the right to review something implies that veto right.
Any recross based upon commission questions? Or in this case, bench questions?
No, Your Honor.
Any redirect?
Very quickly, staying on this topic of finance team, and are you asking the commission in your testimony to order anything in regard to the creation or duties or operation of the finance team, which the commission did not order in the previous two Missouri financing cases with which you've been involved?
The only difference from what the commission authorized in the past to what's proposed in the current draft of the financing order is providing clarity over the finance team's role, being able to commence prior to the order becoming non-appealable. Other than that, the right to appeal and the underwriter selection process are both identical as proposed here to what was authorized by the commission in the prior financing orders.
Okay, if I could briefly turn your attention to the Office of Public Counsel witness Murray's proposed post-financing order process, Mr. Murray, as I understand it, wants virtually everything filed publicly. Is that your understanding? I did say virtually, so I'm kind of, or what, let me ask you this, what is your understanding of Mr. Murray's recommendations regarding the post-financing order process?
My understanding is he's suggesting including incremental information on pricing of certain other issuances in the issuance advice letter. And he's seeking certifications and letters delivered from staff's financial advisor to staff and from the underwriters to the issuer to be public or filed in some redacted form rather than confidential.
Do you have a contract that covers items such as those with staff or the commission?
Yes.
And did you have certain, based on previous experience with Missouri finance cases, did you have certain expectations regarding the confidentiality and privilege of communications pursuant to the contract?
Yes.
Do you believe that in midstream, or actually rather far down the stream at this point, we should be altering the confidentiality and privilege nature of those negotiated for expectations?
No.
If the commission was to agree theoretically with some of what Mr. Murray has proposed, do you believe that should be done in a current proceeding or done in future proceedings? In other words, I mean, after we have a contract, we have expectations, we have a track record. If you want to change, if Mr. Murray and if the commission agrees with Mr. Murray, wants to change the way things are done, change the way the commission's regulation on confidentiality is interpreted and applied, make changes regarding the contract, the regulations, I mean, is that something that you would expect to see done after the fact? I mean, you've already contracted to do this. Is now the time to do it, or is do it in the future?
Right. I believe any type of, I don't recommend or propose any type of change, and I think it could be detrimental to the process and ultimately the cost of the process. But two, if the commission were to, and commission staff were to change the approach on this, I think it's something that should take place in advance rather than, entering into, contracts and being as far along in the process as we are.
Thank you. No further questions.
Thank you. I've got one real quick. I don't think it will trigger any recross or redirect, but I will still keep those options open for people. Does your firm typically track the documents it's reviewed during the structuring and marketing and pricing phase?
I'm digesting the word track, but we certainly keep a close eye on the documents that we receive. We review the documents that we receive. Some information is received in written form. A lot of information is received in verbal form as well. Those could be discussions with the underwriters, discussions with the traders, investor presentations, small group presentations, various engagement with the investor community that, we don't know, it wouldn't be practical, right, during the pricing process to track the detail of those discussions. but we typically monitor the various work streams that we work through the process to ensure that we're completing an adequate review.
Thank you. Any recross based upon that question?
I think a question or two.
Go ahead, Mr. Williams.
Judge Clark just asked you about tracking, I believe, information that you receive in various forms. Do you create any kind of an auditable trail?
So I want to be careful in terms of the confidential nature of letters that we would provide in certain instances. But in the event that we were providing a letter, one of the things we would include in those letters would likely be, the type of work streams that we completed as part of the process.
Well, I think the point of the tracking would somebody be able to come back, including perhaps you after the fact, and look at what had been reviewed. Is that something that can or cannot be done?
I'd need to come back to you on that. Typically we'll receive various documents. We'll go through a process, make sure that the various items that are spelled out for us within the financing order are completed as part of the review process. But in terms of individual documents, different drafts of documents, which versions of drafts we had been through, if we had received replacement drafts, that type of information, there's not a tracker, if you will, that goes through and says, for each individual document, here's the review that took place of those. Going through the process, we'll go through, step by step, each element of the process, and so items will get reviewed as part of our overall review process. But in terms of, a specific tracker or document that tracks those, that's not something that we could provide.
Let me try again. When you say you couldn't provide it, it's not something you could create after the fact? Is that what you're saying?
Sorry, it's not something that exists in the type of form that I believe you're referring to.
Well, all I'm getting at is whether or not you have information that somebody could look at what it was that you reviewed in order to render your opinions, do your work after you've done the work. However that's accomplished. I believe that's what the judge was after.
Yeah, and maybe this is responsive, and redirect me if it's not, but information that we rely on as part of our work, information that we receive that informs our overall process and letter that we would deliver to staff is something that we would enumerate. In terms of there's probably subcategories to that, right? In terms of different drafts of call it an indenture, right? If you received 5 different drafts, did you just review the final version? Did you review iteration 2 and 3? Those types of items I don't have a particular tracker for, if you will.
Thank you.
Thank you. Any further recross? Any redirect?
Excuse me, Mr. Davis, if you were to be ordered to do that which Mr. Williams and Judge Clark just queried you about, going back, recreating lists of things and tracking what you've previously reviewed, would that have any impact on your costs?
I don't know that it would impact the overall cost outside of, to the extent we needed legal review or other third-party review of that type of work product. I don't know otherwise that it would be additive to the overall cost.
In this, in the industry in which you work, is there a lot of free time between when you review things and when decisions on them must be made?
No, the market, and a very good question. The market moves extremely quickly within our space, especially as part of the most dynamic element of this process. Going through the pricing process moves extremely quickly. Information and decisions are made with very short periods of time, very short window to digest information. So preparation is important to it, but also you receive a lot of information, from the underwriters, from the traders, from information coming out of feedback from investors that need to be reacted to in a very short period of time to make sure that reactions occur while investors are still engaged and that there isn't, some unnecessary delay during the pricing process that could adversely impact investor demand and could cause people to lose interest or start to focus on other transactions that may be coming to market at the same time or may be in market. So engaging, quickly is certainly an important element of our process, especially as part of the pricing process.
So you wouldn't have time to sit down and make a list of everything you just discussed on the phone with somebody, so you could send that to Mr. Williams later on, make sure he got all the information he needs.
That's right. It would be incredibly impractical. I think it would create a ton of frustration for the underwriters going through the issuance process as well, and the investors. And I think in doing that, if we slowed down the process to transcribe each of these discussions that we had with various traders, underwriters, parties involved in the process, it could be disruptive to the overall pricing. And anything that does that slows down the process and risks a worse result for customers to log the information. I wouldn't recommend as part of a pre-issuance post-financing order process.
Thank you. No further questions.
May this witness be excused? Are there any objections? Hearing none, thank you for your testimony, Mr. Davis,
Thank you.
and you're excused. Okay, we have now, in the course of this case, have taken 3 witnesses out of order. So let's see if we can get back onto our original plan and move forward. So I believe next witness is Ameren's witness, Segel. If you would like to call your witness.
Call Daryl Segel to the stand.
Mr. Segel, when your hands are empty, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do, yes.
Thank you. Please be seated. Ameren?
And Mr. Segel had testimony on the DOE loan issue, which we're now not taking up for hearing, so I'm go ahead and move that into the record. Is that appropriate?
Are there any objections? I don't... No, we've got Mr. Segel up here, and we have done enough out of order. I don't see that this is going to be a problem either. So, are there any objections to taking Mr. Segel's testimony onto the record as an exhibit? And do you have an exhibit number for that?
I believe it's 21. He does not. He does not have testimony on this finance process. We're making him available for commission questions, or I guess your questions. Right. We did not have a specific witness on that issue, so we said we would make him available so that there was a company witness that could answer those questions.
I'm a little confused, just for the moment. I'm going to back up for just a second.
Yep.
When you said to answer commission questions, I don't believe the commission has had any questions yet. These are witnesses that you're putting on for your issues. So this is an issue Are you saying there's no testimony on the issue?
He does not have pre-filed testimony on the issue, on the question that
Okay.
we're here.
Is he going to be
today.
offering live direct testimony on that?
He is not. We are putting him up to be able to answer questions because we had Ms. Niehaus.
Okay,
but
so
we
he's
did
up
not
for
have-
cross and
Yeah.
up for,
Absolutely.
that's all I wanted to clarify. Thank you.
Trying to be helpful and maybe it was not. I apologize.
No, you are being fine, Ms. Tatro. You just, so when I don't understand something, I will ask about it.
Perfect.
Oh, let's get back to my original question, which is in regard to, and it is Exhibit 5, is that what we're looking at?
I thought it was 21. Oh, it's 5. Yes. I don't know. 5. It's right. Sorry.
Okay. Exhibit 5 is the surrebuttal testimony of Daryl Segal. Are there any objections to admitting Ameren's Exhibit 5 onto the hearing record?
I just want to make sure that Exhibit 5 has to do with the DOE loan issue only.
That is correct.
No objection.
Mr. Kaufman? Hearing no objection, Exhibit 5, Daryl Segal's surrebuttal testimony is admitted onto the hearing record. And go ahead, Ms. Tatro.
Well, Mr. Segal is available for cross on issue 1.
You've already been for the commission. We have, the parties apparently have no questions for me.
Well, we're going to find out. All right. Any questions from AARP? And I assume that's the same for Consumer Counsel, correct? Any cross-examination questions from the commission's staff? Any cross-examination from the Office of the Public Counsel?
Not at this time.
Any commission questions?
Yes, thank you, Judge. Good afternoon. Earlier today, I incorrectly asked Mr. Lansford a question, but I think you might be the most appropriate person, given his response. In Mr. Murray's surrebuttal testimony, he suggested a 4.05% interest rate for traditional rate making for the net present value calculation, which he stated was Ameren, Missouri's embedded cost of debt as of December 2023. Do you know what is the oldest and most recent debt issuance included in this embedded cost of debt? You know, when were they issued? For example, I'm trying to establish the range of interest rates.
Yes. Unfortunately, I don't know the oldest issuance, but that would go back decades, because typically we issue Ameren, Missouri debt, up to 30 years in tenor. I believe there's roughly 20 securities within that embedded cost of debt portfolio. The most recent issuance was in March of 2023. That was done at a coupon rate of 5.45%. I would mention, this is just additional information, but since the time that that embedded cost of debt calculation was performed, Ameren, Missouri has priced 2 additional securities in 2024. One in January of 2024, a $350 million 30-year first mortgage bonds at 5.25% coupon. And in March, a $500 million of 10-year first mortgage bonds at 5.20%. Those are not included in the embedded cost of debt calculations that you referenced. But it gives you an indication of where current markets are relative to our historical embedded cost of debt. Sure.
Are there any other commission questions? I hear none. I have no questions for this witness. Is there any recross based upon commission questions? Any redirect?
No redirect, thank you.
Is there any reason not to excuse this witness? Mr. Segel, thank you for your time. You may step down. Next witness I see is public counsels. Public counsel, you may call your witness.
Public counsel calls David Murray.
Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Please be seated. Go ahead, public counsel.
Please state your name.
My name is David Murray, last name spelled M-U-R-R-A-Y.
By whom are you employed and in what capacity?
The Missouri Office of Public Counsel as a utility regulatory manager.
Mr. Murray, did you prepare testimony that's rebuttal testimony that's been pre-filed in this case and marked or will be Exhibit 201?
Yes.
And is there a schedule to that testimony, DM-R-1?
Yes.
Did you also prepare and cause to be pre-filed rebuttal testimony?
Yes.
And that's been marked for identification, well, that will be marked for identification as Exhibit 202. Are there schedules to that rebuttal testimony?
Yes.
Are those schedules DM-S-1 to DM-S-3, corrected schedules DM-S-4 to corrected schedule DM-S-7, and schedules DM-S-8 and 9?
Yes.
And as a result of those corrections to your schedules to your rebuttal testimony, have you prepared errata to your rebuttal testimony?
Yes, I have.
That's been circulated to the parties in the commission, and it will be Exhibit 203.
I'm sorry, can you say that again, please?
There's an errata sheet that has been circulated to the parties in the commission that would be, it should be Exhibit 203. So there'll be Exhibit 201, which is David Murray's rebuttal testimony, 202, which is his rebuttal that includes some corrected schedules, and his errata to his rebuttal, which will be Exhibit 203. Mr. Murray, would you have any further corrections to what are Exhibits 201, 202, and 203 for them to be your testimony here today?
No, the errata sheet covers everything.
And you'll be up on other issues later in this hearing, will you not?
Yes.
So I'll forego offering his exhibits at this time. And with that, I'll tender Mr. Murray for examination.
Mr. Kaufman, is there any cross-examination from AARP or Consumer Council of Missouri?
No questions, Your Honor.
Thank you. Any cross-examination from the commission staff?
Yes, yes, didn't realize I was up already.
Well, there were a lot of parties here, but most of them have very isolated interests, and so a vast majority of them were excused.
Since Mr. Williams correctly didn't offer Mr. Williams, excuse me, I said that backwards. Since Mr. Williams correctly didn't offer Mr. Murray's testimony into the record, I didn't get a chance to do this, but I would like to voice an objection to Mr. Murray's rebuttal testimony. And when the time comes for you to rule on that, I may not be the one that's here, so I wanted to put it on, wanted to raise the objection now, and so it can be ruled upon later. would object to, from pages 12 through the end of the testimony, the section on issuance advice letter and post-financing order issues, believe are, number one, irrelevant to this case, as they deal primarily with the Empire case and the Evergy case. And they're also constitute improper surrebuttal because they contained therein are new recommendations of Mr. Murray for this case, which is he could have and should have raised earlier in the case. And related to those pages of the testimony would be exhibits, or whatever he's calling them, DMS 8 and DMS 9. All right.
Now, you had said the issuance advice, page 12 till the end of his testimony concerning the issuance advice letter, and what else?
Well, I'm not saying they actually deal with this. I mean, he has that section of testimony titled Issuance Advice Letter and Post-Financing Order Issues. I just think that entire section should be stricken.
And
along with
that is separate and apart from Ameren's motion to strike portions.
Right, right.
And this is, you're objecting to the admission of it, or you're moving to strike those portions?
Either one. Give me either one, I'll take it.
Okay, I'm not going to rule on that now, obviously, since it's not time for him to come in.
I'm unclear as to the basis of the objection.
Well, he's saying that the objection is, he's basically listed two reasons for the objection. One is he says the information is irrelevant, and
To this case, yes.
to this case. And it appears that his other objection is that it introduces new analysis that is not responsive to matters previously testified to. Is that correct?
I would add in rebuttal to what you just said.
In rebuttal.
Yes.
I've made a note, and I'll see if I have a highlighter. I've made a note and have highlighted it, and hopefully that will be enough to remind me in the future when it comes time for, when somebody offers it for admission.
Thank you.
All right, go ahead, Mr. Williams. Oh,
Me.
you had,
I'm sorry, me.
Go ahead, Mr. Keevil.
Mr. Murray, I have just a few questions. If traditional rate making was intended to be not providing recovery or financing at the historic cost of Ameren debt, Ameren, Missouri debt, sorry, would securitization ever yield a net present value benefit for customers?
Can you please repeat the question, please?
Sure. If traditional rate making was intended to not provide recovery or financing at the historic cost of Ameren debt, would securitization ever yield a net present value benefit for customers?
If I can summarize what you just said and make sure we're on the same page.
Okay.
Are you asking if traditional rate-making recovery was based on the historical cost of debt and it was compared to securitization, would it ever result in net present value savings? Was that your question?
Well, let's go with that one, yeah.
Okay, it depends on, I mean, I think Mr. Lansford brought this up in his testimony. Yeah, it depends on the interest rate environment, the current interest rate environment compared to, you know, what's the historical cost of debt that's on the books. I mean, I can, just like in the Evergy, Missouri West case, I think in the traditional rate-making scenario, the staff had recommended a 5.06% cost of debt, and at the time, the securitization rate was about 5%. So they used a different point in time that caused that embedded cost of debt to be a bit higher, but that that made it pretty close as to whether or not there would have been a net present value savings based on what was decided in the Energy Missouri West order. Now, in this situation with Ameren, Missouri, basically, they're almost at the trough. I don't know if they've ever been at, I think 3.9% was their lowest embedded cost of debt based on experience of doing the rate cases. Yeah, obviously, they just had an A-rated bond issue, Mr. Sagal discussed of about 5.2%. Hopefully the securitization cost would be lower than that if it's a AAA rated bond. I mean, that's one of the reasons why, I think this process is important to understand. But yeah, as it is right now, no. I mean, based on the current market conditions, it would not be, I'm not gonna use the term never, but at this point, it would not result in net present value benefits.
You say, you almost used the term never, and then you changed your mind, if I understood you there, and said, I'm not gonna use the term never, but it would not result. So you think it could result in some?
I'm objecting to Mr. Keeble commenting on the evidence.
Okay.
No. Me.
Okay, go ahead. I'm sorry, Judge.
Okay, what is your question?
I was trying to understand his answer.
Okay. What I heard it going along was that you said, you almost said never, but then you indicated what was objectionable.
He's just repeating, he's testifying essentially, he's repeating what, or at least his interpretation of what Mr. Murray said. I'm just saying he needs to ask the question, so commenting on the evidence.
Okay. Is there a question in there?
Well, I didn't get to the question because of Mr. Williams, but there will be.
Okay, I'm going to let you go on and ask it.
Okay.
So, at least for now, the objection's overruled.
Mr. Murray, what caused you to change your mind there that say not, you won't say never?
It wouldn't be never, because like I said, as Mr. Lansford pointed
How
out,
long would it be?
if, I was gonna finish, but if interest rates start to decline and say we should have interest rates below, and hopefully like a AAA cost that's below 4%, you would have net present value savings because that cost is lower than the embedded cost of debt. So if you could get a securitized bond rate that is below 4%, if for whatever reason we hit a severe recession and we have to go back down to 0% interest rates, we may have bond costs that were at the extreme low levels that we had in 2020 and 2021. So the answer cannot be never, because we don't know what the market's going to do.
Do you see any secondary impacts occurring if Ameren was ordered to 100% debt finance its material costs?
I believe that's what they're doing with securitization, is they're going to be financing it with 100% debt.
That wasn't the question. Do you
Mr.
see-
Keeble, can you lean into your mic a little more? I'm getting a note.
That
you're-
wasn't the question, Mr. Murray. The question was, do you see any secondary impacts? Let me rephrase that. In your opinion, does the overall amount of debt at the utility impact its cost of impact more than just its cost of financing the items that it is financing at the time, or does that impact its entire capital structure?
I'm sorry, that was multiple questions. You're going to have to break that down for me, please.
Does the overall amount of debt at the utility impact only its cost of financing those items that it is financing, or does that impact its entire capital structure?
I mean, yeah, you're constantly managing your capital structure. So if you issue, as Mr. Sagal pointed out, you issued $350 million, $500 million bond issuance, there would be even though I don't agree with that, Ameren, Missouri's capital structure is truly independent, but let's just say that they felt like they had to maintain a 50% common equity ratio, they would need to balance that. If they wanted to maintain, or if they maintain that they were, focusing on just Ameren, Missouri, which I don't agree with and have never truly agreed with.
What potential impacts would a securitization, such as we're here for today, have on Ameren's cost of equity?
I think it reduces the risk profile of Ameren, Missouri.
So what impact would that have on the cost of equity, in your opinion?
It would reduce the cost of equity.
How would a shift to 100% debt financing impact Ameren's operational capabilities?
They would still be able to raise capital. I mean, there may be a debate on how much the cost is, but they would be able to raise capital. So to the extent they need the capital for their operational capabilities, they could still go to market. We could have a debate as to whether or not there's an impact on cost.
So you might debate that?
Well, we're always debating it in rate of return, aren't we?
If we shifted to 100% debt financing, there would be no equity.
Well, but you're talking about on Rush Island, that's only one part of the 10 billion, 11 billion rate base of Ameren, Missouri. I mean, it's a small percentage in the whole realm of things. So 100% debt financing, I agree with you, for the special purpose entity, that's going to be about 100% debt financing for securitization, but it's not 100% debt financing for Ameren, Missouri.
No, but what if you look at Ameren, Missouri, not just limited to the special purpose entity?
I'm not recommending 100% debt financing, so I don't understand why that's relevant.
Doesn't really matter. What impact would that have?
It would not have a large impact because it's only for 500 million.
We're not talking about Rush Island. We're talking about Ameren, Missouri.
Ameren, Missouri,
100%
capitalizing 100% debt of its rate base.
100% debt.
Okay.
All right, don't talk over each other. Take some time, answer the question, and let him answer the question.
First of all, I don't think that would ever happen, but under that hypothetical scenario, of course, the only way it would happen is securitization, but under that hypothetical scenario, they wouldn't be able to raise capital at any reasonable cost.
If Ameren, Missouri, Ameren, Missouri's credit rating were to decline, what would be the immediate and long-term effects on its borrowing costs and investment capacity?
If the rating declines, sometimes it's, as I've observed between Ameren, Missouri and Ameren, Illinois, even though they have different credit ratings, sometimes their cost of debt is quite similar. So the market, considers the credit ratings. If the market agrees with the rating agencies that implies a higher risk profile, then that should cause for a higher cost of debt. Now, as far as its ability to raise capital, you're still going to be able to raise capital. It's just whether or not it's going to be at a different price.
Could you elaborate on the potential long-term impacts of altering Ameren's debt-to-equity ratio through increased debt financing?
Considering that Ameren Corp. Consolidated has about a 40% to 45% common equity ratio, I don't think that treating Rush Island as 100% debt is going to have a significant impairment on Ameren, Missouri's credit quality.
Okay, again, I'm not limiting this to just Rush Island. If you alter Ameren's debt-to-equity ratio through increased debt financing, what's the long-term impact of that going to be?
I would appreciate more specifics because you're just saying, an increase. An increase can be, 5% more debt to capital in the capital structure. It could be 10% more debt to capital in the capital structure. What I'm indicating is Ameren itself, which is the parent company of Ameren, Missouri and Ameren, Illinois, and Ameren Transmission Company, already has a 40 to 45% common equity ratio. So what I'm saying is with Ameren, Missouri having a debt ratio of 48%, if it went into the same range that Ameren's in, it has a stronger business risk profile. So its credit rating would, if it's rated on a standalone basis, it should not be any lower than what Ameren's is right now.
Other than what has already been shared publicly, what feedback, if any, have you received from consumer advocacy groups regarding the securitization approach in this case?
Oh, I just got back from SERFA, which is a Society Utility Regulatory Financial Analyst, and I was there. I was in Richmond, Virginia on Thursday and Friday, and I talked to a gentleman with, I think, Drexel Hamilton. He's not a consumer advocate, but he does securitizations. I've talked to some other folks that with staffs and consumer advocates that are involved in securitization, have securitization in their cases. Virginia, Florida, Texas. I'm not sure if I talked to anybody from Louisiana or Oklahoma. I'm not sure that they were there. Other consumer advocates in North Carolina. North Carolina recently had a consumer advocate that hired a financial advisor, which, by the way, they filed their certificate letters redacted in that proceeding. So I'm not sure that that can be classified as an industry standard. They pushed for that in North Carolina.
Who is that financial advisor?
In North Carolina, I think they had a municipal bond underwriter, because in some of these states.
I didn't ask for the underwriter. I asked for the financial advisor. You said
that is the financial advisor. That was the financial advisor.
Okay, who filed the issuance advice letter on behalf? Was it filed by an underwriter?
They didn't act as the underwriter in that case. They acted as the financial advisor. A lot of times these financial advisors have roles as underwriters as well. That's why you have investment banks that, actually Ms. Niehaus, who was here earlier, she's financial advisor right now, and then she'll become, she hopes to become the underwriter if they get the business. So you can serve in multiple roles. But in North Carolina, that consumer advocate in North Carolina pushed for those certification letters and opinion letters to be filed public and redacted.
So you have been in contact with people other than those working within the Missouri Office of Public Counsel regarding your recommendations in this case?
I don't know specifically about my recommendations in this case, but obviously talking to them about their, the securitization process to make, get myself, better informed about, what's going on in other states and what the best practices. I mean, obviously you saw I attached to Kentucky, something from the proposed Kentucky order that has a market pricing comparison sheet. So yeah.
What have you told these people about this case?
What if I told them this is the third securitization case in Missouri, and it has to do with closing of a coal plant, and actually I talked about consumer discount rates, not just with not with just Steve Keim in Wisconsin, very, very intelligent person that has publishes a lot of work about various regulatory issues, but specifically has addressed consumer discount rates. Yeah, lots. I don't remember everybody.
Well, I'm not really asking about the people you've talked with. I was more interested in what you've disclosed to them regarding this case.
I didn't disclose anything confidential, if that's what you're trying to. I just to discuss the issues of securitization.
You've got a lot of testimony about what happened or what was filed in the previous two cases, do you not?
Yes, that's the experience we've gathered in
Okay,
Missouri.
yes is the, that's
Yes,
sufficient.
yes.
Then what did you tell these outside consultants about your experiences in those previous cases?
I don't think I discussed anything about those previous cases.
Didn't discuss it?
I mean,
Okay.
They can look in EFIS.
Can you provide detailed insights into the structuring of securitized utility tariff bonds?
No, that's not my area of expertise.
Okay. So do you know, and if you don't, just say you don't, how do the terms and conditions compare to those terms and conditions of traditional bonds issued by Ameren or Ameren, Missouri?
Well, yeah, that's definitely, we just had recent Ameren, Missouri first mortgage bond issuances at, 5.2%, 10-year bond. I think the weighted average life is going to be right around that in this securitization case. So, if AAA bonds are going to result in lower costs as the securitization process is, hopes to achieve, then hopefully that the bond price should be a little bit lower than the 5.2% of Ameren, Missouri's current bonds.
What are the safeguards in place to protect Ameren and its customers in the event of market volatility or unexpected financial downturn?
I have no idea what context you're talking about. I don't know.
Okay. That's all I think I have, Judge.
Ameren, Missouri?
Your Honor, I just want to clarify, we are only on we've bounced around so much. We're only on issue 1 here, correct?
That is correct.
I have no questions, thank you.
Any questions from the commission? Go ahead, Chair Hahn.
It's actually on issue 2, but we're blending them together, it seems like. No question, thank you, Judge.
Thank you. I've got a few questions. Well, let me ask, are there any other commission questions? And I apologize, I think the chair has some questions on issue 2, which I just indicated to Ms. Tatro we're not taking up at this point. Now, in your SIR rebuttal, you suggested a 4.05% interest rate for traditional rate making for the net present value calculation. Is that correct?
Yes.
And you also mentioned that Ameren, Missouri's embedded cost of debt as of December 2023 was also 4.05%. Is that correct?
Yes, and can I clarify that that is the rate that I suggest or recommend that would be used as the allowed return for the 15 years of amortization. That is not the discount rate I'm recommending for purpose of discounting those cash flows.
Do you know, I mean, we just heard a little bit of discussion of what's involved in, do you know what loans are included in the embedded debt?
Yeah, there's quite a few bond issuances. I think, yes, Mr. Sagal probably accurately summarized that it could, usually the longest bond maturities you have are 30 years, so it could go back as, the late 90s. Sorry.
No, I interrupted you. Please go ahead.
So it could be anywhere from the late 90s to, the past decade. I mean, excuse me, I recall during the financial crisis that Ameren, Missouri issued a bond at 8.45%. That just kind of, that one has always been burned in my mind because it was a very unfortunate situation to have to issue a bond at that high of a cost at the time. So, but anyway, so there are other bonds, yes, that have various costs. And so it's basically a portfolio of bonds.
So it's a fairly wide range.
Yes.
Okay. Do you think it's appropriate to compare the long-term debt rate that includes loans that were issued during times when there was a much lower interest rate with the proposed 5.6 bond rate?
Oh,
That is based on a higher interest rate period?
That wasn't my intent. My intent was to, recognize the capital that is currently on Ameren, Missouri's balance sheet. So I wasn't trying to compare it to the securitized bond rate. I was just looking at the cost of capital components that would go into traditional rate making. Obviously, there is the opinion that it should be the full common equity and long-term debt, a weighted average cost of capital. I prefer to call it a weighted average rate of return because I believe the cost of equity is lower than what's authorized. But anyway, bottom line is that's the debt that is on the books that finances the assets that's on Ameren, Missouri's balance sheet. You can't use a current interest rate. It would have no until if securitization is approved. Then it has a relation to those assets.
If Ameren went out for long-term debt at the same time as the securitization bonds, do you think Ameren would get a lower or a higher interest rate than a AAA bond securitization?
The estimated rate that Mr. Davis put in his, and he provided the most updated information on an estimate, was 5.33% for a securitized bond rate. So Ameren, Missouri, at the end of March, just issued bonds at 5.2%. So this is something that hasn't been discussed in, I don't think anybody's testimony or in detail, but there are some issues that I'll call, systemic within the securitized bond issuance space, I guess is what the Wall Street folks like to call it. Space is Bloomberg had reclassified the utility ratepayer-backed bonds to asset-backed securities for purposes of indexing. They did that in August of 2022, and ever since that occurred, the spreads over treasuries and spreads over actually secondary AAA bond yields, Microsoft and Johnson & Johnson, the spreads over those those types of bonds have increased, have widened since this occurred, and so it's not a problem specific to Missouri. It's a problem with the financial players, and Bloomberg, I believe, and other indexing services are not necessarily regulated by the SEC as to how it has to be done. But so that before 2020, the spreads to treasuries and the spreads to other AAAs much tighter. And so that's a problem that seems to be, I said that's not something that I consider to be an issue that's specific to any problems in Missouri. It's an industry issue.
Thank you. Would you explain why you believe that no carrying costs would be permitted by the commission if Rush Island's retirements were instead of securitized, were amortized in a rate case?
I am relying on past commission and established law that says if it's not used and useful, a return's not allowed. I mean, that's, I think, like I said, I used the order from Liberty, where that was discussed to some extent, and my awareness of other situations where when a plant is reclassified or rebooked as a regulatory asset, a lot of times those assets are just amortized with no allowed return, whether it's debt or equity.
Were the ongoing annual financing costs for Empire, or Liberty, however you want to say it, higher in part due to both the fact that you had two cases in one, both a plant retirement and the Winter Storm Uri being securitized?
I don't know, no, I don't know if it was due to that. I mean, I do know that obviously the ongoing financing costs were about $2 million higher because income taxes were included in the financing cost for Empire and Liberty, or excuse me, for Liberty.
Is it, and I think you're getting to the core of my question. Is that why you think those were higher?
Oh, there's no doubt that's why the effective cost, when I say not the bond yield, not the coupon, the effective cost. So what I did is I did a determination of what the payments would be for based on the bond amortization and the ongoing financing costs, which included the I'm approximating 2.1 million of income taxes that were included in the ongoing financing charge, and that increased the effective cost of that bond to 7%. But that's not it was around 5%, I believe, for the yield on the bonds, the straight yield.
Those are all the questions I have. Any recross based upon Commissioner Bench questions? Staff? Ameren?
I just have one question. You mentioned in reference to Judge Clark's question, you started talking about Bloomberg.
Yes.
And their kind of reclassification they went through, and you said spreads, you noticed spreads were widening after. Do you remember that conversation?
Yes.
Do you know what spreads were doing prior to that Bloomberg decision?
They were narrower during the 2020, I think, 2020 timeframe. I mean, I think 2022 there was a little bit of volatility, obviously, with the markets. Yeah, that's one thing about trying to isolate things when it comes to financing. There might be some market volatility as well, but in 2020, I believe they were tighter.
So through 2020 they were tighter, but what about, when was this Bloomberg decision?
I believe it was August 1st, 2022.
Okay. What was it in 21? What was happening with the spreads in 21?
I don't have the information specifically in front of me right now.
Well, you seem to imply that the widening of the spreads was because of the Bloomberg decision. What's your basis for that belief, if you don't know what it was doing immediately beforehand?
I read an article from an asset manager periodical.
So it was that person's opinion?
It was an asset, yeah, it was a financial
Okay.
article.
Thank you.
Any redirect from public counsel?
Yes, just a little bit. Do you recall, in response to a question about the impact on cost of equity of securitization, and you said that it would decrease the cost of equity?
Yes.
Do you know if there's any limitation on what the commission can do with that decrease in cost of equity in a general rate case?
No.
And who is it that owns Ameren, Missouri stock?
Ameren and Corp. Ameren Corp.
100%?
100%, yes.
What does that allow Ameren Corporation to do with Ameren, Missouri stock, or capital structure?
They have affiliate, whether it's dividends or capital contributions or tax allocation agreements, et cetera. There are all sorts of things that that can be done to to adjust the capital that goes in and out of the company.
And then I'm going to go to some questions. Presiding Officer Clark asked you about the 4.05% traditional embedded cost.
Yes.
Does the commission use that when it's setting general rates, embedded cost?
Yes, that's included in the overall rate of return.
And what does that mean for purposes of securitization versus not securitizing?
it's, the 4.05% was what I thought was consistent with the commission's analysis of scenarios in Evergy, Missouri West, and Liberty, as to if it was to allow a lower return instead of making investors completely whole for a plant that is no longer used and useful, to use the lower embedded cost of debt that basically finances, the aggregate assets on Ameren, Missouri's books.
No further questions, thank you.
Thank you, Mr. Murray. You may step down.
On item 2?
Hmm?
Okay. I didn't know if there was still more on item 2, I'm sorry.
There are items, they're on item 2, but we're not on item 2 yet. We
Okay,
took
I'm
two
sorry.
witnesses out of sequence, and that's the reason that they were allowed to go over both, so.
I'm sorry, I was confused.
But I wouldn't venture too far. I imagine you'll be up here quite quick.
Okay, good deal, thank you.
Your Honor, can I inquire about the possibility of a very short break?
I am glad you did, because I almost forgot, and I think everybody could use one. So it is now 3:47. Why don't we all come back at 4 o'clock? All right. We just concluded Public Counsel witness David Murray for issue number 1. I believe that only leaves staff's witness remaining. Is that correct?
I think so, Judge.
Okay, if you want to go ahead and call your witness.
Yeah, I would call Mr. Keith Majors to the stand.
Okay, and I will revise my prediction that we will be done with issue 2 by 5. Mr. Majors, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Please be seated. Staff, go ahead.
Yes, thank you. Could you state your name for the record, please, sir?
Keith Majors,
By whom are you employed and in what capacity?
the staff of the Missouri Public Service Commission, as a utility regulatory audit unit supervisor.
Are you the same Keith Majors who has caused to be prepared in this case rebuttal testimony, which you may not know this, but it has been pre-marked Exhibit 110, and was there also an HC on that? No, yes, there was. There was a 110 and a 110C rebuttal.
Yes,
And with that rebuttal, was there also, I believe, 4 schedules which were filed along with the rebuttal, but were filed separately due to the length of the schedules?
yes, that's correct.
Okay. Do you have any additions or corrections you need to make to any of the 110 documents?
No, I do not.
Okay. Did you also cause to be prepared and filed surrebuttal testimony, which has been pre-marked as Exhibit 111?
Yes,
Do you have any additions or corrections to that?
no, I do not.
If I were to ask you the same questions contained in Exhibits 110, 110C and 110, and then 111, would your answers be the same as contained therein?
Yes,
And are those answers true and correct to the best of your information, knowledge, and belief?
yes,
Judge, Mr. Majors has a multitude of issues that he's appearing on, so I don't know that it would be proper to answer or to offer the testimony at this stage. So, with that, I would just tender the witness for cross-examination and make note of the fact that the exhibits have been marked, but they haven't been received. If that's okay with you.
Yes, so noted. Thank you. I think that's what we all agreed to, so.
Yeah, and with that, I tender Mr. Majors for cross-examination on this issue.
All right. Any cross-examination from public counsel?
Briefly.
Go right ahead.
Good afternoon, Mr. Majors. How are you doing?
good afternoon, Mr. Williams. I'm fine, thank you.
That's good to hear. Let's assume that Rush Island has a net plant balance of $475 million as of a date that it's going to be included either in securitization or in general rates. Okay with that?
Okay,
How would that net plant balance be treated in traditional rate making, in your view?
well, I think the assumption is, well, can I ask, is the assumption that it's no longer, it's retired, it's offline?
Yes, yes. Assuming it's permanently shut down, retired, abandoned, whatever word you want to use, it's no longer used and useful. So how would
Right.
it be treated if the commission were to allow recovery for that plant?
I think recovery separately, you would assume some sort of amortization over a period of time. In this case, it's the assumption is 15 years, and that correlates to the original retirement date of the unit of 2039, which would be 15 years in the future. Whether or not the commission would include that in rate base, the unamortized balance, is unknown. I think you would probably look at past examples on, just if you're doing an analysis on assuming whether or not the commission would include that amount in rate base.
Have you ever, are you aware of any instance where the commission has included a net book balance for a retired generating plant that was retired 10 or more years in advance of its depreciation life, where it's done that amortization? I mean rate base, I'm sorry.
I'm sorry, I'm confused now as to what the question is.
Let me try again. Are you aware of any instance where the commission, for a plant that's retired more than 10 years or more prematurely, where the commission has allowed it to continue to get rate-based treatment?
There are no examples that I recall offhand. There are very few examples of plants that I can recall that have actually been retired. I can come up with a list, but there are only two that I can think of that received some kind of treatment, special regulatory treatment in the form of an amortization. That would be Merrimack. It was an Ameren plant, and then Sibley 3, which was a Evergy West, also known as GMO plant. Those are the two examples of special treatment that come to mind.
And how much, well, what was the retirement date of Merrimack versus its anticipated life for depreciation purposes for rate making?
That's a good question. My recollection was Merrimack was an older unit, and so that would have been closer to the retirement date. It would have been closer to its projected retirement date. Its actual retirement date would have been closer to its projected. On Sibley 3, I'm going to say less than a decade, but I would really have to go back. It was closer than 15. I think that's what your question is.
I think you've anticipated some questions, but I'm fine with the information you've given. Whenever those amortizations were set up, how was ADIT treated? Accumulated deferred income taxes associated with the plant.
I would really have to go back and research that. It hasn't really been that long ago, but I just don't recall.
And of course, I'm asking about Sibley and Merrimack.
Right. Yeah,
You just don't know right now?
I'm sure I know somewhere, but I don't recall sitting right here on how those were treated.
No further questions, thank you.
Ameren, Missouri.
Thank you, Your Honor. Are you familiar with the retirement of the Montrose plant for Evergy, who is now Evergy?
Yes, I am.
And do you know how that was handled at how rate base was handled at retirement?
So that would be the other non-securitization method of retiring a large rate base unit or a large coal-fired unit, not necessarily coal-fired, a large piece of a large amount of plant. So you would have journal entries taken in a like amount out of plant and reserve, and so that would have hit the reserve as a debit and reduced overall reserve. And so there was no special treatment for any of the Montrose units, no amortization or something like that.
Was there any unrecovered balance?
Yes.
And did that receive rate-based treatment?
I think it would receive rate-based treatment in the context that you're eating up the depreciation reserve, but it did not get a separate amortization and inclusion through inclusion in rate base of the unamortized balance. It wasn't anything special. It was more of a retirement like I don't know, pole, substation, other pieces of plant that are subject to whatever retirement entries are appropriate.
Was the debit to reserve included in rate base?
Yes.
I have no further questions. Thank you.
Any commission questions? I've got a few for you, Mr. Majors. I'll start with what's immediately in front of me, which is we were just talking about Merrimack and Sibley 3. You don't perchance remember those case numbers, do you?
Merrimack, the actual retirement would have been in the context of ER-2021-0258, I believe. I had testimony in ER-2022-0337 would be the last Ameren rate case. And so my testimony that I don't have in front of me, that dealt with the amortization of the regulatory asset, which I believe was 5 years, and we recommended no rate base inclusion of the unamortized balance. And I believe you asked about Sibley 3.
Correct.
That would have been in the last Evergy, Missouri West general rate case, which was occurred at the same time as the last Evergy Metro general rate case. Those case numbers were ER-2022-0129 for Evergy Metro and ER-2022-0130 for Evergy West. And in those cases, I would have had direct testimony, rebuttal testimony, and surrebuttal testimony addressing the Sibley deferral and the amortization of the net book value.
Thank you. On Murray's rebuttal on page 3, he makes statements based on your response to DR 0036 from Public Counsel, which is attached as scheduled DM-S-1. Now, your response says that the net book value would reduce the accumulated depreciation reserve. Now, is that according to the Uniform System of Accounts, or USOA?
I can pull up the response if you'd like, but I think from what I recall, just a normal retirement would reduce, the net book value would reduce the reserve. So you would be implicitly earning a return on the net book value if you just do a normal retirement. And so, for example, your rank and file wood poles or service trucks, when those are retired and they have a net book value, that net book value would reduce the reserve. But you also have other items of plant that don't have a net book value in their own right, that last longer than other items of plant in that category, so it all somewhat evens out.
Okay. Would the USOA require an entry as a credit to remove the original cost of the plant retired?
Without writing it down, I think you would credit plant and debit reserve for the like amount.
Now, would you post the debit as to the accumulated depreciation reserve account?
Yes.
If the plant's actual useful life corresponded to the anticipated depreciation useful life at the end of the plant's useful life, would the accumulated depreciation reserve amount equal the original cost of the plant?
Generally speaking, that's correct, yes.
According to the USOA, if plant were retired before its estimated useful life, would the accumulated depreciation reserve have a credit or a debit balance?
I think it would have a net debit balance, all other things being equal, because you would have ate up more reserve than had been accumulated over the life. of the plant because the retirement was premature.
Okay, so it would be a debit.
Yes.
Now, that same Public Counsel DR 0036 that I just referred to, you indicated in your response to that your accounting treatment described is not representative of the treatment if Rush Island were retired. Is that correct? Or, I'm sorry. If it's not retired with securitization or a regulatory asset or amortization.
Right, I think that's, and I'd have to go look at I don't think we've asked Ameren for the I guess, journal entries, but it wouldn't be appropriate to reflect any kind of net book value or any kind of residual amount as a debit balance to the reserve, because then you would be double collecting you would be double collecting both the securitized net book value and the debit balance in accumulated reserve. So it's one or the other. So for example, it would be inappropriate to go back and securitize Montrose because you've already recognized the journal entries to retire the unit. And so it would be one or the other. You wouldn't want to do both.
And I hate to say this, but I'm going to admit it. I do not understand the question I just asked. And as much as you tried to explain it to me with an example, it still kind of flew over my head. Can you?
Okay. If I could write down a few figures, just for my own edification.
Please, go ahead.
Joking, Judge, I suppose this would not be a good time for an asked and answered objection.
All right, you get a point for that.
Okay, so let's assume, and this is a bit on the fly, so bear with me. If you assume that you had a $100 wood pole and it's halfway through its useful life, so it would have 50 buried in the reserve, or not buried, but in an accumulated reserve. And if you retired the wood pole, you would debit the reserve for $100 and credit plant for $100. So your original balance of plant was a debit amount that wipes out the $100, so you're even there. But when you take $100 out of the depreciation reserve, that would be 50 over what was already accumulated. So that 50 of reserve would eat up other amounts of accumulated reserve. So, but when you securitize the whatever you're securitizing, in this case Rush Island, you're getting an amount of money, $500 million for that net book value. So you wouldn't want to retire the unit according to normal accounting procedures and take $500 million out of reserve and get the $500 million in cash. And so it's one or the other. You would not want to do both.
Okay, thank you. That makes a lot more sense to me. Does the USOA provide instructions for the accounting of extraordinary property losses and the amortization of those losses?
It does. I would have to have my copy of the USOA in front of me. I believe it's a public document. It's a codification of the Federal Energy Regulatory Commission Uniform System of Accounts. So I can certainly go back and get the exact section of the USOA that deals with extraordinary property losses for you at a later time. Not right now. I don't have that document in front of me.
Yes, I would like that. Those are all the questions I have. Any recross based upon bench questions?
Yes.
Go ahead.
Mr. Majors, you recall when Judge Clark was asking you about net book value and depreciation reserve, and you used the term normal retirement?
Yes.
What is a normal retirement?
Probably there's a zone of reasonableness when it comes to rank and file like poles, transformers, things like that, where you would have premature retirements of those assets and then retirements that occurred after their the end of their useful life. And so I would assume there's some kind of bandwidth there. But since as a whole, Rush Island was retired 15 years prior to its projected retirement date, I think you would have to call it an extraordinary retirement, or at least an abnormal retirement.
Well, you've anticipated one of the plans I wanted to ask you about. What about Montrose and Sibley, 3 and Merrimack?
So the Montrose units, really testing my memory, were vintage 1958, 1961, and maybe 1962. Their retirements took place in approximately, one unit was first, I think, in 2018. The remaining 2 were maybe 1 or 2 years after. So I guess the experience, the total life would have been approximately almost 60 years. And so I guess, oh, that was your question. What were the, how old were they at retirement?
Well, let's just take them one at a time.
Okay.
Was Montrose a normal retirement?
I would call that a normal retirement. The boilers had a very high heat, well, not a very high heat rate in comparison to other coal-fired units. They were relatively small units at approximately 175 megawatts per piece. It was not economic to make the kind of improvements that would extend their useful lives any longer than at approximately the date they were retired.
Was Merrimack a normal retirement?
My recollection was generally speaking, the facts were similar. It was an older unit and substantially smaller than, say, Rush Island or the Sioux units or Labadie. And so I would say those were similar circumstances.
And was Sibley 3 a normal retirement?
That was a bit of a different example there. So the Sibley 3 had been scheduled to retire, forgive me, I can't remember the date, but sometime in this decade, there was a turbine event that caused the unit to be non-operational. There was a substantial amount of money to fix the turbine. Given the economics specifically of that unit, it was determined that it would not be economic to fix the unit. And so that was probably somewhat of an abnormal retirement, not to the effect you're retiring Rush Island 15 years prior to its projected retirement, not to that extent, but it certainly wasn't older, like the older coal-fired units, Merrimack and Montrose. It wasn't quite that. It wasn't the same example. So, because Sibley 3 was slated to run at least for, my recollection would be several more years after the turbine event, to my recollection.
Well, how often do utilities come in for rate cases?
That's a good question. It depends on the utility. So Ameren seems to run, if you go back to the last decade, about every 18 months. I think Ms. Tatro could probably elucidate that better than I could. depending on, it just depends on what a utility's earnings are and actual financial results would depend on how often they would come in for a rate case. And it also depends on the timing with the requirements to maintain the fuel clause.
The fuel clause is every 4 years, is it not?
Yes, that's my understanding. From my recollection is approximately 4 years, yes.
And you testified that Merrimack and Montrose were both, you consider those to be normal retirements, but that the rate-making treatment was different. Do you have an explanation for why?
I think my recollection is Merrimack was a bit larger and more substantial in the Ameren system than was Montrose. I think there were probably various other reasons. I could go back and review testimony. But I don't recall anything more substantial, other substantial differences than that.
Was the treatment of Merrimack and rates after it was retired a contested matter?
There was some dispute on whether you or not you would include the unamortized balance in rate base, yes.
For Sibley 3, was that a contested matter before the commission?
Yes.
And for Montrose, was that a contested matter for the recovery?
No, not to my recollection. Was there any kind of dispute over the regulatory treatment of Montrose?
Was it on an issues list in front of the commission then?
No, it was not.
No further questions, thank you.
Any cross-examination from Ameren?
Thank you. So the judge at one point tested your memory and asked you for some case numbers. And do you remember that conversation?
I do.
And I think the Ameren case number that you meant to say was ER 2021-0240. Does that sound right?
Well, I think, and I've got a lot of case numbers.
I'm impressed you remembered any of them.
Thank you. I think 2011 was 0258, ER 2011-0258. I think ER 2021-0240, you're correct. That's the correct case number.
Okay. As part of that conversation, he had you go through staff's positions in those cases and talk about the various rate-making treatments. Do you remember that?
Yes.
Are you familiar with Lisa Ferguson's testimony in Ameren, Missouri's 21 rate case?
I'm sure I read it. I don't have it in front of me, but yes.
May I approach?
Yes.
On a computer screen, because I didn't expect to. Yeah, this is 21. We're talking about Merrimack.
Okay, thank you.
I'll let you read this to yourself first.
Yes.
Read this page.
Okay.
Sorry.
No, that's fine.
Starting here. Lisa Ferguson's rebuttal. Starting on page 4. So read this entire page and then the end of that sentence right there. Just
Okay.
to yourself.
Yeah. If you could give me one moment, please. Oh, okay. I remember this now. If you'll give me one moment.
Yeah,
And you want me to end at regarding carrying costs?
that'd be fine.
Okay, I read it.
Okay. So in Ms. Ferguson's rebuttal testimony, did she say that she did not oppose Ameren, Missouri receiving carrying costs on the Merrimack remaining costs?
Yes, that's correct.
Okay. Is it fair to say, in general, that the commission has to consider a multitude of facts when it's deciding any rate review?
Oh, absolutely. Yes.
And so is it fair to say there could be reasons that are specific to each case as to why the commission rules the way that they do on any particular topic?
Yes.
That's all. Thank you.
Any redirect from staff?
Not on this issue, Judge, thank you.
Okay, Mr. Majors, thank you. You may step down.
Thank you.
I'm going to move on to issue 2, what we have left of it. Is there a mini opening that any party wanted to make in regard to that? I hear none and see none. All right, the next the next witness I have in regard to that would be Mr. Murray again. And Mr. Murray, I'm going to remind you, you're still under oath.
Thank you. Yes, I understand.
Public counsel?
Tender the witness for examination. His exhibits have already been marked, so.
Thank you. Any cross-examination from the commission staff?
Judge, I hate to admit it, but when Mr. Murray was up here previously, I thought he was up on both 1 and 2, so I asked everything I had done last night, so, yeah.
All right. Ameren, Missouri.
I do have a few questions. Thank you.
Go right ahead.
Mr. Murray, do you have a copy of the statute with you, the securitization statute?
Let me see. Yeah, that's a thick document in here. Yes, I do.
Great. Is it safe for me to assume that you've read that statute?
I have read over, most of the statute. I can't say that when it gets towards the end with some of the other details that I don't think are areas that I am directly involved in, I probably skimmed over those parts.
Okay. You consider yourself familiar with the statute and the portions that deal with the commission appointing a staff representative to be part of the team that that advises the commission?
Yes.
Okay. So tell me what the statute says about the Office of Public Counsel's role in providing input and collaborating with the utility.
I think the statute excludes the Office of Public Counsel from having any role in the securitization process.
What does the statute say about OPC's role in the bond issuance process? Same answer?
I do not recall seeing anything that says the Office of Public Counsel will be involved in the post-issuance process. I guess the only chance we have to comment maybe is when the issuance advice letter is filed.
Because the statute specifically entrusts those portions of the process to the staff, the commission-appointed staff representative, and the financial advisors, right?
I don't know about the term and trust, but the statute definitely anticipates it will be the staff's designated representative and through a financial advisor and a team. I mean, I don't think the term team is used, but yes.
All right. Would you accept the word delineates or names, names those individuals
Yes.
as the ones who are supposed to look at this? And if the bond issuance terms are inappropriate, who has the ability to prevent the bonds from being issued,
The commission?
right? And that's because the process under the statute is that the representative of the staff provides an opinion to the commission on the reasonableness of the pricing terms and conditions, right?
The staff, the underwriters, the company, yes.
And the staff representative is advised by a financial advisor, yes?
That is correct.
So the complaint here is that OPC doesn't get to play a role?
The complaint here is when I reviewed the issuance of ICE letter in the Liberty case, I found mistakes, and yes, I would like to entrust for that process to work properly, but, I found that the Liberty issuance of ICE letter did not follow the commission's order as far as the terms. So, anyway,
Well, that was in your opinion, correct?
that was correct.
The
They
commission's.
were factually incorrect.
the-
They revised the issuance of ICE letter.
Okay. So the final issuance of ICE letter
Was corrected
was corrected, all right?
after
You
public
were,
council filed.
you were able to play that role,
Within a day, yes.
okay? Regardless of whether or not you were part of, I'm going to use the term finance team, although I recognize it's not a statutory term,
Yes,
even though you weren't part of that role, right?
yes.
Okay. Have you participated, other than the two securitizations in whatever role the commission has approved in whatever role you were able to play in those, have you participated in any type of bond offering?
No,
Any type of securities?
no.
Do you have any special knowledge about bonds that staff does not have?
Staff's financial advisor is obviously involved in the capital markets. I'm not involved in the capital markets. I would say that the other staff members, I have, a CFA designation, which goes into detail about capital market issues.
Do you have
So
any?
so I would say I have better knowledge of capital market specifics than general staff, in-house staff.
What about the staff representative that the commission chooses?
The financial advisor has specific capital market experience.
Okay. How many issuance advice letters have you reviewed?
Um, 20?
Okay. So in your SOAR rebuttal, beginning on page 17, I think it's about line 15, you talk about including comparable pricing analysis that you suggest be done for the issuance advice letter.
I'm sorry, what page and line number? I'm
I
sorry.
believe it is page 17.
Okay, I'm there.
You see where you reference comparable pricing analysis?
That's line 5 through 14, yes.
Okay. How often do securitized utility bond issuances include comparable pricing analysis? Of the 20 you reviewed,
Can you repeat the question, please?
how many securitized utility bond issuances, the advice letter, how many of them include comparable pricing analysis?
Okay, because, the advice letter, that's a.
Yeah, sorry, I missed that.
That's very key.
Yes,
'cause
it is.
most of them, all of them should include a comparable price analysis. But I can think of two that I.
Two out of the 20?
2 out of the 20, yes.
Okay. Have you seen Katrina Niehouse's, well, never mind. Of the two, are any of them in the last 5 years?
Yes, I attached the one, well, that's not completed yet, but in Kentucky.
In Kentucky?
That's a that's a currently pending proceeding, and that was the draft issuance advice letter that had a comparable pricing analysis. I think there was one in 2016, that might have been Duke Energy, Florida. Yeah, I don't recall. I mean, I said I looked at quite a few issuance advice letters, but
Right. It's not a common thing to be included as per your review demonstrated, right? You said 2 out of 20.
yeah, common doesn't mean inappropriate, though, but yes.
And I didn't know. I asked if it was common.
Okay,
And the answer is no. Is that right?
that is correct.
Thank you. You talk about AAA rate bonds rated bonds, right? Can you explain what that is to the commission?
It's the highest quality of corporate securities. There's only two companies in the United States, Johnson & Johnson and Microsoft, that are rated AAA at this point in time.
Do you think utility securitized bonds are comparable to AAA?
They are usually assigned AAA. I don't know that the costs are always consistent with other AAAs.
Okay, let's talk about that a little bit. Would you agree with me that the underlying credit requirements and obligations are different between a AAA bond and securitized utility tariff bonds?
Securitized bonds are structured bonds. I mean, it's a structured security, so it's claimed to a very specific, in this case, a financial sum of financial cash flows from utility customers, where a AAA bond from Microsoft or Johnson & Johnson, typically general corporate bonds.
Okay. Would you agree that utility securitization bonds are amortized?
Yes.
And by that, it means that you're paying down principal interest at the same time,
It's generally referred to as a sinking fund. That's correct.
okay? Would you agree that AAA rated bonds are not amortized?
In general corporate, in most corporate bond issuance, they're issued as what's called a bullet bond, maturity at the end of the term, which is what Ameren, Missouri does as well, for the most part.
Right, so just to make sure we're clear, a bullet bond, because I'm not the expert here, a bullet bond, you pay the interest every 6 months or whatever it is, and then the principal is all due at the end of the term.
That's correct.
Is that right?
That's
Okay.
correct.
Let's talk about the liquidity profile of utility securitization bonds and the AAA rate bonds. Can you explain how they compare? Well, first of all, do you know what I mean when I say liquidity?
I know what you mean by liquidity.
Okay.
I don't, be honest with you, as far as when it comes to securitized bonds, I don't know if they are actively traded. That may be a function of the investors that like to, the target investors that want to buy and hold.
But these AAA corporate bullet style bonds, they retain their principal value, right? Because it's not paid until the end.
Well, I think the company hopes they'll retain their principal value. If something happens financially to the company, their risk profile increases, then their principal value, the value of the bond decreases.
Can bullet bonds be resold?
Well, any bond can be resold and over the counter if it's if it's registered with the Security Exchange Commission.
Would you agree that bullet bonds are more attractive to investors to be resold because they still have the principal value that is paid at the end?
That would generally be the case, yes.
Okay, thank you. I have no further questions.
Are there any commission questions? I hear none. I haven't got many for you, Mr. Murray, but I do have a few. How do you respond to staff's position that including comparable securities, pricing analysis, and the issuance advice letter could have an adverse impact on the marketing and pricing of the bonds?
Personally, don't understand that because the marketing and the pricing has already occurred. So if you put it in the issuance advice letter, that process is completed. So I don't understand how that would impact any further interaction with the investors because they've already went out and received the pricing.
Okay. What about never mind. Sorry, I'm trying to see if I can simplify my question. Okay, issue 2D, which I guess involves, should the commission order Ameren, Missouri to provide the issuance advice letter and supporting work papers to other interested parties at the same time it provides the information to staff's finance team. Is OPC intending for this information to be shared with just the parties to the case?
Just the parties to the case.
And are you intending for that to be shared with the parties to the case when the draft issuance advice letter is shared with the with staff prior to the official submission? Or are you talking about at the end?
When the draft, I think it's 2 weeks before the anticipated issuance of, pricing of the bonds. And, like I said, this is just from experience. We had to, you had asked, the commission, commission had asked for comments on the issuance of ice letter in the Liberty case. And I'll tell you, I had to drop everything to try to see if I agreed with the net present value calculations, and we did not. And so that was just, we were just attempting to improve and make corrections and changes. And so, yeah, I really don't understand, the pushback on that. I think that's just something to give us more time to see if we agree or disagree, and then we can reach out to staff and the company and ask them questions and make sure that, we don't have a disagreement. And, obviously it's ultimately their responsibility if they want to move forward with something that we don't think is correct, and, that is what it is. But at least give us the opportunity to collaborate.
Okay. And I understand, obviously, a longer period makes for better review and certainly makes reviewing easier. And so what you're talking about is a potential 2-week review period. I know it was done differently between Liberty and Evergy. I know that, as you said, in Liberty you got just a very short amount of time, and I don't know if you received any in Evergy except for certainly not an invitation to comment, but just a time period. How important to OPC is it that, or how important to public counsel is it that it be allowed to comment on the issuance advice letter?
We represent the ratepayers, and there's supposed to be, some confidence in this process that this is going to result in a net present value savings to customers, and they're footing the bill. So I think it's very important to the Office of Public Counsel as representation for the retail, the retail ratepayers.
All right, thank you.
Thank you.
Any recross based upon bench questions? Hold on just a second. I need to, after each time, check my order. Any recross from the commission staff?
No. Thank you.
Ameren, Missouri?
Yes, thank you. So, Mr. Murray, the judge asked you, I think the very first question the judge asked you was, did you remember the earlier conversations about the adverse impact on the price of bonds that making the advice letter public or partially public might cause? And your answer was not sure why that would happen because the work would already be done. Do you remember that conversation?
Yes.
You're requesting that the commission in this case put in the financing order that the issuance advice letter will be made partially public, partially redacted, right? You're asking that to be in the financing order, is that correct?
I think those are the certification letters that I was referring to.
You're right, certification letters. Okay, but you're requesting that be put in the financing order.
I don't think I recommended the certification letters to be part of the financing order.
Are you requesting that the certification letters be made public?
Judge, I'm going to object at this point. Certification letters were not the subject of commission questions.
Well, that's what I'm trying to clarify. Perhaps I misunderstood his answer. I thought his answer was talking about those letters. Did it not? Okay.
No,
Well, then
I was talking about
I'm done. Thank you.
Okay, thank you. Any redirect?
Just a few, hopefully. You remember being questioned about comparable pricing as being part of the, my notes are not that great. Do you remember the exchanges about comparable pricing to be
Yes.
included? Should they be included?
Yes.
Object included what?
Mr. Williams?
Oh, well, let me try again. Do you remember the questions you got about how often comparable pricing was included in, can't remember if it was, I think, let's try issuance advice letters.
Yes, that's exactly what she asked me about.
And you responded that or 2 out of 20 is what you'd seen, correct?
Ballpark.
And I think you acknowledged that it wasn't common then, correct? Based on what you've seen.
Yes.
Should it be common?
Yes.
Why?
Because a yield, looking at a yield by itself doesn't tell you anything about the pricing of the bond as compared to other, other securities being issued at the same time, with maybe the same, amount of issuance, same ratings, same weighted average lives. A yield on its own doesn't tell you anything. You need benchmarks, and as they've acknowledged that, I say they, the financial advisor and the underwriters, or the Goldman Sachs and others that may be involved, that's a very important part of the process to make more or less in certifying that that they achieved the lowest cost for the securitized utility tariff bonds. But it's impossible to be able to make any conclusion or judgment specifically from the public by just looking at a yield. A yield of 5.1% doesn't mean anything unless you compare it to benchmarks.
Thank you. No further questions.
Actually, that brought one to mind for me. You said of those 20, you said one was still in process. Is that correct?
That's the
It's the
Kentucky.
draft. I believe you referred to it as the draft issuance advice letter.
That's a schedule attached to my testimony. It's the Kentucky issuance advice letter.
Okay, and the other one would have been one that was already issued. Is that correct?
Yes.
Do you know what it was rated at?
It should have been rated at AAA. I mean, almost all of these securitized bonds are rated at AAA. Now, the pricing spread varies, over treasuries and over AAAs. The spread varies based on, various factors.
Okay. Any questions based upon that question? Any redirect based on that question? All right, thank you, Mr. Murray. You may step
Thank you.
down.
Appreciate it.
We have one last witness for this. I believe it's Mr. Segal. Now, if I remember, Mr. Segal only had testimony as to the Doe issue.
Yes.
So is this another case where Mr. Segal is being put on for commission questions?
It is. If the commissioners don't have any questions, he doesn't need to take the stand.
Are there any, well, let me ask first, are there any cross-examination questions for Mr. Segal on issue 2 from the parties? Okay, I see no affirmative yeses. I'll ask for commissioners that are present, are there any commission questions for Mr. Segal on this issue number 2, which is the post-financing order process or procedure? I hear none. I have no questions for Mr. Segal. So, okay, so are we finished with issue 2?
2 down.
Okay. Why don't we take a short break at this time so that Mr. Keevil can make arrangements for his vehicle. Can we go off the record for a moment? And can we strike that last line of mine? Mr. Keevil, how long would you like to move your car for?
Honestly, I'm not handling the next issue, so I'm gonna, my car the entire night, but how about till, what is it, now, 4 till? 4 minutes till. Probably 15 minutes.
It's my intention, and like I said, I plan at this point, depending on the progress we make, on staying probably till about 6, because I do want to make some headway. I do think we have an incredible amount to pack into this hearing, and I want to be sure that, that we don't need to find extra days at the end, or for us all to be here on weekends. So, with that in mind, why don't we, this will be a slightly longer recess, why don't we take a recess till about, I'll take that 15 minutes, and we'll do, let's go ahead and do 5:15. We'll go off the record. Okay, we're about to start we are going to start issue 3, which is the prudence of the retirement. Looks like the first witness is Ameren, Missouri's. Ameren, you may go ahead and call your witness. Well, actually, let me ask this. I know we did a mini opening which encompassed part of Homestead's testimony on the 12th. Were you wanting to do a mini opening at this time?
I think we're only here on issue 3A this evening, and that mini opening's already been done. And 3B it's really kind of a distinct issue with some distinct witnesses, so we'll want to do a mini opening on 3B when we get to it.
Okay, well, let's talk about 3A. What witnesses are going to encompass that?
Burke, Whitworth, Homestead, Reed, Moore, UBEX, Majors, and Seaver.
Okay, so we're trying to get through 3A today.
Well, we're not gonna get through it today, I'm sure, but that's what we're starting today.
Okay.
As I understand it, Judge.
All right. Go ahead and call your witness.
Ameren, Missouri calls Mark Burke. Yes, I'm Nash Long. Nice to see you, for Ameren, Missouri.
All right, Mr. Burke, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
Yes, I do.
Thank you. Go ahead, Ameren.
Please state your name.
Mark Christopher Burke.
And are you the same Mark Christopher Burke who caused to be prepared for filing in this docket direct and surrebuttal testimony marked for identification as Exhibit 6 and 7?
Yes, I am.
Do you have any corrections to either Exhibit 6 or 7?
Just the correction on the timing of some of the projects.
Your Honor, we'd like to hand out an exhibit that notes the correction for the record, which will mark as Exhibit 21.
Okay, thank you. Why don't you give me 3? Thank you.
Did you give one to the witness? Okay.
And so you're calling this Exhibit 21, is that correct?
Yes, Your Honor.
And how would you like that titled?
Um,
Is this an errata?
It's correction to Schedule MCB-D2.
Can you give me that schedule number again?
MCB-D2.
Thank you.
All right, just looking at exhibit, which we've numbered 21, Mr. Burke, can you identify for us the corrections that you would like to make to this exhibit, MCB-D2?
Yes, the corrections I'd like to make are the ones that are handwritten on the document. And basically what they were is moves in the years that those projects were actually executed compared to what was in the original schedule.
Can you explain that to me again? So what are the corrections note?
The corrections are handwritten and with the circles. So when you look at for instance, the first one to the left, Rush Island 1, it says it was actually performed in 1995 and 1997. So it's actually shown under the year 2001. It was actually performed in 1995 and 1997. They just
Okay.
denote when they were actually performed, Judge.
Okay, that clarifies that for me. Thank you.
You're welcome.
Mr. Burke, with these corrections, which you have noted for the record on Exhibit 21, if I posed the same questions to you today reflected in your Exhibit 6 and 7, would your answers be the same?
Yes, they would.
Are those answers true and correct to the best of your knowledge and belief?
Yes, they are.
Your Honor, at this time, Ameren, Missouri will move Exhibit 6 and 7 into the record.
Judge, I believe Mr. Burke is testifying to other issues later, so
And that was the question I was getting ready to ask. I don't believe Mr. Long was here before. But because a lot of the testimony that the commission is taking some of the testimony that there have been motions to strike on. And so what we've done with all the testimony is because some of the witnesses are going to be testifying on multiple issues, we're not just accepting it into the record on the first issue, but we'll be taking it into the record pending objection the last time that witness testifies.
Judge, I'm handling that last issue, so I'll just move it into the record if that goes into the record at that time.
That sounds great, Mr. Lowry.
At this time, I would also then just move Exhibit 21 into the record.
Okay, are there any objections to admitting Exhibit 21, the corrections to Schedule MCB-D2?
It appears that exhibit's limited to the issue that's before the commission currently, so public counsel has no objection.
Thank you. Staff, do you have any objections? Is that a no? I'm sorry, you're just going to have to speak into the microphone. I apologize.
Sorry. Yes, we don't have any objections, and it's Nicole Mers, MERS.
Okay, thank you, Ms. Maris. Hearing no objections, Ameren Exhibit 21 is admitted onto the hearing record.
Your Honor, at this time, we would tender Mr. Burke for cross.
Okay, are there any questions, cross-examination for Mr. Burke from the staff of the commission?
No, Your Honor.
Any cross-examination for witness Burke from the Office of the Public Counsel?
Yes, thank you. Good afternoon, Mr. Burke.
Good afternoon.
Has Ameren, Missouri included anything in the pre-file testimony in this case regarding the new source review permitting and activities at Rush Island Units 1 and 2 in 2007 and 2010 that it did not present an evidence before the federal court?
I don't know all the evidence that was presented before the federal court, but I do believe that the proceeding that we're here today for is to really look at the prudence of the permitting decision.
No, I understand that. My question is whether you put evidence in this case that was not in, or have pre-filed evidence in this case that was not included in the record in front of the federal court. And if you don't know, that's fine.
I do not know. I do
All
not
right,
know.
thank you. No further questions.
Bear with me just a moment. Okay, are there any commission questions? Okay, I've got a couple questions for you, Mr. Burke. And I'm checking to see if I have any more. All right. Now, in your testimony, you phrased the prudence question as why Ameren, Missouri did not get those permits. Okay, in your testimony, you indicated that the appropriate question that you believe the commission is asking here is, why did Ameren, Missouri not get the permits, and was that decision reasonable at the time of the projects? Is that correct?
That is correct.
And why do you believe that that's the appropriate question?
I believe that's the appropriate question because what this commission should be deciding is around the prudence of not getting those permits. And the reason that we did not get those permits is because we were following the Missouri SIP, which was the law at the time, and the SIP indicated that basically that if potential emissions did not increase, and if the work was routine, that permits were not required. And so after analysis of these projects at Rush Island, we determined that the permits were not required. And in doing that, basically, we acted prudently, and I'm absolutely certain of that. We did the review like we had done on all previous projects, and that we had done at the various generating plants, and that is the question.
Are emissions calculations required in Missouri?
So, according to the Missouri SIP, are you talking about the SIP at the time, back in 2007?
Yes, that's correct.
Yeah, so the Missouri SIP at the time really required three things. And in that, you only had to show that one of those things was basically correct, and you didn't need the permit. So you either had to show that there wasn't any potential hourly emissions increases. You had to be able to show basically that the projects you were doing were routine, and then there was also a portion in that looked at the actual emissions. Again, the requirement was you just had to show that one of them was met and you didn't need the permit. And we believe that through our analysis that there were no potential emissions increases associated with the projects we were doing. We clearly believe that these were routine, not only in Ameren, but in the rest of the industry, that these type of boiler component replacements were being done across the industry at the time. And when we looked at the reason there was we believe no hourly potential increases, led us to also believe that there were no actual increases associated with implementation of these projects.
Now, I believe that the district court, according to your testimony, determined that you were wrong about the law, what the law was, but reasonable. Well, I don't think they made the determination. I guess what you're saying is that you're admitting that Ameren was wrong about the law, but was reasonable in their interpretation.
That's correct. We were wrong about the law, but we were reasonable in the way we implemented the Missouri SIP at the time. What the federal court found was, and this was years after the fact, they used a different interpretation of the Missouri SIP. So what they found was that we did not interpret it correctly, so we were wrong in the law. Now, we were interpreting it the way that other utilities in Missouri were also interpreting it. We were interpreting it the way the DNR was interpreting it. And we believe what we were doing was consistent with the industry, the way that the EPA had even discussed this issue. And as such, we believe that what we did was reasonable and it was prudent.
Do you believe there's a difference between reasonable and prudent?
I believe that if we show that it was reasonable, then the decisions we made were prudent. And I think at the time, because we were following the Missouri SIP, we were following the law at the time, and because these projects didn't increase emissions, potential hourly emissions, and basically they were routine, that we believe the permits were not needed. We believe we were reasonable in looking at that, and as such, we were prudent.
Is the converse true? If Ameren were unreasonable, would it also presumptively be imprudent?
I don't know that I would not say that in every case, no.
What would be the difference that would cause it not to work the other direction?
For instance, if, I'm trying to think of an example, Judge. I can't think of one right off the top.
I guess I'm just having a hard time digesting part of this, and and I understand the reliance on the SIP, but I have a hard time reconciling the court's determining that Ameren was wrong about the law, but that it's, and using your word, understanding, that it was reasonable of its understanding about the law. I don't understand how you can be wrong about something yet reasonable in your understanding of it.
Well, we were interpreting this for projects that we did 7 to 10 years earlier. So our interpretation of the Missouri SIP, which was the law at the time, was the reasonable interpretation that not only we were using, but other utilities and the DNR was using in Missouri at the time. What the court ultimately found years later was they basically said that we were wrong in the interpretation of the SIP, and that we were wrong in the law. And we're not denying that we were wrong in the law. We were wrong in the law. That is what the court has found. But we made reasonable judgments to follow the Missouri SIP, and you know, we were in our environmental group, and Steve Whitworth can talk more to this, but we were very in tune to what was going on in the industry and in Missouri, and we were following the Missouri SIP, and we believe that was reasonable.
And you asked me if I was referring to the SIP at the time. Has the SIP changed since?
The SIP has been modified over time. I'm not as conversed on it as Mr. Whitworth would be. That is his expertise, but it has changed over time.
Bear with me just a moment.
Okay.
Okay, I have no further questions for you at this point. Is there any recross based upon commission questions?
There is from public counsel.
Just very, very briefly. You just had your conversation with the judge about the judge in the district court coming to a different interpretation of the Missouri SIP. Do you recall?
Yes, I do.
So that judge's interpretation is also reasonable, wouldn't you agree?
That judge's interpretation is reasonable at the time, yes.
Nothing further. Thank you.
Public counsel?
Thank you. Mr. Burke, if I heard you correctly, you said that you were following the law at the time, and I believe you were referring to the 2007 2010 timeframe. Did you mean to say that you were following your understanding of the law at the time when you were following the Missouri SIP?
What I said was we were following the Missouri SIP, which was our understanding, was the Missouri DNR's understanding, and it was the way that the SIP was being implemented.
But that's not what Judge Sipple found that the SIP said, your understanding didn't comport with his decision, correct?
That is indeed what the court found, is that we were wrong in the law.
And he was saying that was the law at the time you made the decisions regarding IATAN 1 and 2, correct?
IATAN were not our units.
I'm sorry, Rush Island, wrong plant.
Okay.
Rush Island Units 1 and 2?
What was the
I
question
was
again?
very excited to see where that was going for a minute.
What was the question again?
Well, maybe Ameren has a new plant I didn't know about. Sorry about that slip up. What Judge Sipple found was what the law was at the time Ameren, Missouri was making the decisions regarding Rush Island Units 1 and 2, and that led to the major modifications in 2007 and 2010, correct?
No, I think what Judge Sipple, what the court did was they used a different interpretation of the SIP and a different test to determine whether we needed the permits or not. And again, what I've said is the court ultimately determined that we needed the permits. Again, they interpreted the SIP different than we did.
Well, the judge was saying that was, his interpretation was what the law was at the time you were making those decisions, which differed from yours, correct?
His interpretation differed from ours, correct?
But it was his interpretation is what he said applied at the time you were making those decisions, correct?
I don't know that he said it applied at the time we were making those decisions.
Well, how could it apply at some other time?
Well, I think he did the evaluation almost 10 years after we made those decisions, and things had changed through time. His interpretation was not our interpretation.
You keep focusing on your interpretation of the Missouri SIP as being consistent with the Missouri Department of Natural Resources and other utilities in Missouri. Was it consistent with the EPA's interpretation?
The EPA basically accepted the Missouri SIP, and that's how the EPA rules were implemented. They were implemented through the Missouri SIP.
Well, EPA brought an enforcement action against based on the major modifications at Rush Island Units 1 and Rush Island Unit 2 in 2007 and 2010, did it not?
It did.
Actually, it brought some counts for earlier modifications, did it not?
Yeah, the EPA actually changed course about 5 or 6 times on things that they brought counts against, and ultimately, if you look at my testimony, I think it talks about how they went back and forth, and then ultimately decided on the projects they decided on for Rush Island 1 and 2.
Well, then the court dismissed a couple of counts saying they were time barred.
I'm not. They may have done that.
No further questions at this time, thank you.
Mr. Burke, I can't remember right off, did your testimony include information concerning whether or not Ameren's decisions harmed customers? Was that a you issue?
That was not a me issue.
Whose issue was that? Is that Whitworth's?
I think it's Matt Michaels, is it not?
That's Matt Michaels, Your Honor.
Yes.
Thank you very much. Any redirect?
Just briefly, Your Honor. Mr. Burke, you were asked about the district court decision. To your knowledge, did the district court ever find that Ameren, Missouri's understanding of the law at the time that it made its permitting decisions was an unreasonable understanding?
No, they never found it was unreasonable.
Did the district court ever find that Ameren, Missouri was unreasonable in having the same interpretation of the Missouri State Implementation Plan that the Missouri Department of Natural Resources held?
No, they never found that was unreasonable.
No further questions.
Mr. Burke, you may step down. Ameren, you can call your next witness.
We're calling Mr. Stephen Whitworth.
Mr. Whitworth, if you'll come down to the stand and raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Please be seated. Ameren, go ahead.
Your Honor, if I may have one moment, we have another correction. I just need to pull it out of my box.
Please go ahead.
All right, this is going to be 22.
Yes, please. Thank you. And you said this was a correction?
Yes, Your Honor, this will be a correction to Mr. Whitworth's schedule SCW-D20. The original, which was filed, we've noticed, did not have all of its pages. This SCW, this version, which we'll call Exhibit 22, does have all of the pages to the document.
Okay, thank you. Go ahead.
Please state your name.
Stephen Whitworth.
And are you the same Stephen Whitworth who caused to be prepared for filing in this docket direct and surrebuttal testimony marked for identification as Exhibits 8 and 9?
I am.
And do you have any corrections?
I have the one correction with this Exhibit D20, as you mentioned.
And Exhibit 22, which you have before you, is that the full and complete version of your schedule SCW D20?
Yes, it is.
Now, with those corrections, if I pose the same questions to you today, will your answers be the same as which you've provided in Exhibits 8 and 9?
Yes, it will.
And are those answers true and correct to the best of your knowledge and belief?
They are.
Your Honor, at this point, we would tender the witness for cross.
Thank you. Sorry, again, bear with me just a moment. Any cross-examination from the commission staff?
Briefly. So turning to your Exhibit 22, am I correct in saying the date at the bottom is 5/31/2011?
It is.
And is it correct that the outages in which the Rush Island projects were installed, they were in 2007 and 2010?
Yes.
And presumably decision-making would have started at least in 2006?
Or earlier, yes.
Do you have any copy
of this guide that would refer to those points in time when the decisions were being made?
That was not a part of my testimony, no.
Okay, thank you.
Does staff have any further cross-examination? Okay, I'm sorry, I didn't hear that. Office of the Public Counsel?
Thank you. Good afternoon, Mr. Whitworth.
Good afternoon.
Are any of the schedules that you have to your testimony documents that were not also put in evidence before the Judge Sipple in the federal action?
I am not sure if those documents that were in my testimony were part of the case.
You didn't testify in that case?
I did.
Did Ameren, Missouri consider inquiring of the EPA as to whether its understanding of the Missouri state implementation plan was correct back in the 2005 to 2010 timeframe?
Well, as was stated in my testimony, Missouri is the permitting authority, the Missouri Department of Natural Resources.
I understand that, but my question is whether Ameren, Missouri even considered asking the EPA about its understanding of the Missouri SIP.
The Missouri SIP was approved by EPA, and Missouri DNR administered that in accordance with the approval that they gained from US EPA.
So you didn't make any other independent inquiry and you didn't consider doing so?
When we went through our process of evaluating projects, we had a host of information available to us. Primary was the Missouri SIP, potential to emissions. We also looked at actual emissions, and we also looked at routine. The projects were classified under the Missouri SIP as routine maintenance. Also, with our knowledge of other units that we had in our Illinois fleet as well as in the Missouri fleet, we knew that these types of projects were not the type of projects that would increase actual emissions, as well as they weren't the type of projects that increased potential to emit. So in the process as we go through, we also had information from the industry, from the lawyers that we had interpreting it through our UR group as well. So no, we did not see the need, or by process, the process was not to go over the head, if you will, of the Missouri DNR, who was our permitting authority.
Well, wouldn't it have foreclosed the EPA from pursuing enforcement actions against Ameren, Missouri for the modifications of Rush Island in 2007 and in 2010 had it gotten an opinion from the EPA that permitting was not required, NSR permitting was not required?
I can't project the answer to that hypothetical.
No further questions, thank you.
Thank you. Any commission questions? I hear none. I've got a few questions for you, Mr. Whitworth. Now, in Lansford's direct testimony, he stated that Ameren is contractually required to operate through September 1st, 2024. Is that correct?
I'm really not sure of that date.
Is the September 1st, 2024 operation date based on the terms of the SSR agreement with MISO, or do you know?
I do not know.
Are you aware of anything that would cause the Rush Island's operation to extend. Do you know what conditions under what conditions will the operation of Rush Island be extended through October 15th, 2024?
Judge, I'm really not involved in that part of the decision and cannot answer your question.
All right, fair enough. We've tried 3. I've gotten three strikes, so we're going to move off of that line of questioning. Now, at the time, I remember reading in Homestead's testimony that the EPA was losing a variety of enforcement actions. Are you aware of that part of his testimony?
Yes, I am.
Did that factor into Ameren's decision-making process?
Well, there was a host of information at that time when we were looking at these projects. The regulations were very dynamic. EPA's enforcement action that began in 1999 was very dynamic. So we took as part of our evaluation, a host of information that was provided to us from several sources, from inside our utility groups within Missouri and talking to other utilities, talking with DNR, talking with EPA, and also getting information from Utility Air Regulatory Group, which were a law firm and a group that was supporting the industry and helping us navigate across the board of all these numerous cases and dynamics associated with new source review. So I can tell you that there was a body of work that we were looking at with close attention. We did not, in environmental, analyze the court cases. We relied on the attorneys, both in-house and with UARG and other sources, to provide us with information about those cases as they went through their course. However, we were also looking at what our requirements were in the state of Missouri, as well as looking at what the other utilities were doing both in Missouri and then across the country with regard to looking at these routine maintenance projects that were being conducted to maintain the availability and the reliability of the Ameren, Missouri generating fleet.
I remember somewhere in your testimony reading something about some of these smaller replacements were being targeted and that ESD was aware of it. Do you remember that portion of your testimony?
Well, if I don't have my testimony in front of me, but what I said and what I think is in the testimony, I know is in the testimony, is that there was a list of projects provided by UARG to all the member companies that listed a host of projects that were very similar in nature to projects that we had been completing at Ameren, both on the Illinois fleet and the Missouri fleet, as well as the other utilities in Missouri. The list included projects that were conducted at the Rush Island units and also included other projects. So there was a general awareness across the industry about what projects were being looked at by EPA, and that was part of the considerations, making sure that we were aware of those projects and paying attention to them and making sure that they were fully evaluated.
Also in your testimony, I remember reading that that and I'm going to use quotes here, the obvious engineering conclusion was that there would be no increase in emissions. Do you remember that?
I don't have the testimony in front of me, Judge, but
that was one of the reasons given for not doing an emissions calculation, that it was obvious from the engineering and the engineers that it didn't need to be done. So I guess my question is, what happened?
okay. When you're talking about emissions calculation, can you clarify what you're directly referring to?
I've heard two reasons that emissions calculations were not done. One reason that I've come across in the case is that they were not done because they were not required in Missouri.
So we only have three
Somebody,
Yeah, I would just do,
if somebody could
and
mute,
then
I
make
am
sure
picking
that
up
they all get
somebody
filled out.
else's
yeah.
WebEx. Thank you. The other reason that was given, and the one that was mentioned in your testimony, was that there was no need to do emissions calculations because the engineers said from an engineering standpoint, it didn't need to be done. The emissions weren't going to be exceeded from an engineering angle, so why do an emissions calculations?
If I can, I would like to give a little more context. Your question, I apologize, but it's a little bit out of context. So our process was to look at potential emissions. So the unit operating at maximum capability, 87 and 60 hours a year, looking at those maximum emissions that were required to be looked at by the Missouri SIP. We also looked at actual emissions. We performed a qualitative type analysis. We had experience on our Illinois units because the Illinois law was a different implementation. Illinois had a delegated program, so the Missouri or the federal regulations were implemented directly. And so we had knowledge of similar projects where we had done those types of projects and looked at the application of the actual emissions test that was not yet implemented in the Missouri State Implementation Plan, as well as the fact that I had mentioned that these projects were routine in nature and met the qualifications of routine. In fact, there's an exemption in the Missouri State Implementation Plan for those types of projects as well. So we did perform both a potential to emit evaluation. We performed using engineering judgment, both from the engineering, project engineering and design folks, as well as from our knowledge of working day-to-day with all of the emissions data and knowing the operating characteristics of these units from an environmental air emission perspective, and then also with our experience looking at, because the rules in Illinois were different, but we had that knowledge base, we looked at actual emissions as well and knew that those types of projects were not the types of projects that would cause an increase in both actual emissions or potential emissions.
Thank you. Hold on just a moment. Okay, I have no further questions. Any redirect from, I'm sorry, any requests from the commission staff?
Briefly, do you recall having a conversation with the judge about the types of things that utilities were looking at to inform their interpretation of the Missouri SIP and how permitting would work?
Well, we did just have this discussion that's in the record, yes.
Okay. And do you recall using the word dynamic?
I think I used the word dynamic in terms of the evolving regulatory, both the Missouri, not the Missouri, the federal rules were changing, as well as EPA's interpretation and implementation of revised regulations. In that context, I mentioned dynamic.
Okay. And your statement just now, that implies that perhaps those laws and regulations and the interpretations of them were not as constant as and known as implied then, correct?
No, that's not correct.
So they were dynamic and changing, but static and known to be equally applied by all the utilities.
You're mischaracterizing what I said. The landscape was dynamic in that there was a lot of activity with EPA and the enforcement initiative. The process for changing rules in a state implementation plan state is for the state to either be asked by EPA or has an obligation to revise their regulations and a process for doing that and then implementing it into the program. That's then approved by EPA. So as those things were changing, EPA was proposing several different rules. We were tracking federal regulations as well. And so things might be proposed, and we would be reviewing them, evaluating them, maybe submitting comments on them. And in that sense, the actual Missouri regulation did not change. But what my intent to say was, or my meaning was, that the landscape was very dynamic because of the number of activities and other actions that were taking front, both on a litigation and then on EPA changing or proposing to change regulations.
So it sounds like the EPA, it's not surprising, wouldn't be surprising to anybody in the industry that they may change how they're looking at something, have a different interpretation, add a rule or a regulation?
Well, I think it's a consistent process. And for example, as the rules were evolving in 2003, EPA program staff had been proposing different regulations to help clarify some of the regulations, as well as change their position on the enforcement initiative and actually suspended that for a period of time. So as you look at that, during the time that we were evaluating these projects, EPA did have a view of definitions of what some of these things meant. However, the outstanding rules that were in place at the time that we had to abide by, even though we were tracking things on the federal landscape, we had to abide by the Missouri State Implementation Plan that, again, was approved by US EPA.
And would they have been evaluating that in 2003?
Excuse me, who be evaluating what?
Ameren.
I still don't quite understand the context for your question.
Would Ameren have been still evaluating in 2003 the changing or potential changing landscape and dynamics?
Well, the regulations, it was our job in environmental services to keep track of regulations and be abreast of what the requirements were, and then help advise the company on what things needed to be done to maintain compliance.
Do you recall in a conversation you had with the bench mentioning a list of projects that included Rush Island that it was implied that the EPA was maybe keeping a closer eye on or monitoring closer?
I mentioned a list that's a schedule to my direct testimony. I do not have that in front of me.
So if Ameren knew that it was on this list and that there was a little bit closer scrutiny, would it not then be prudent to reach out to MDNR and EPA?
Well, I did not say that the Rush Island projects were on that list. I said that projects that were similar in nature to the Rush Island projects were on the list, as I recall. And we had constant contact with MDNR on these issues as we move forward. It was standard practice in the industry for both. MDNR did a great job with outreach, and the industry took advantage of that and made sure that we were on the same page.
But did you seek a permit applicability determination from MDNR?
No, and there was no need to do so in this case.
You also had mentioned in your conversation with the judge that Ameren, Missouri did its own admission calculations. Do you recall that?
Yes.
Were those provided to the district court?
I really can't recall what information was provided directly at this point in time.
Okay, no further questions. Thank you.
Thank you.
Public counsel.
Thank you. You testified that the projects met the routine maintenance, repair, and replacement exception whenever, back in 2007 and 2010. Do you recall that?
Yes, they did.
Judge Sipple found they did not, did he not?
In his opinion, issued several years later, I think that was his opinion.
Yeah, but he was construing the Missouri State Implementation Plan as of the 2005 to 2010 timeframe, was he not?
Well,
I can't, I guess, understand or comment on his decision at the time, but I do know his decision was issued as written, and that's the decision that he made, in his opinion, in, 2017.
Wouldn't your answer be more accurate if you'd said that it comported with that based on Ameren, Missouri's, and you can add in Missouri DNR and other utilities if you like, but the projects in 2007 and 2010, in your view, were routine maintenance, repair, and replacement?
As I mentioned, our evaluation was based on initially, we had a three-pronged approach initially. We looked at the scope of the project, looked at potential emissions. We also looked at actual emissions, as well as the projects, when you look at them and look at the scope of the projects and the definitions in the Missouri SIP, as well as in the industry and EPA's interpretation at the time, were considered to be routine maintenance and repair type projects.
Well, what I'm trying to get at is whether you're saying that was the law at the time or that was Ameren, Missouri's understanding of the law at the time in terms of the routine maintenance, repair, and replacement exemption.
It was Ameren, Missouri's interpretation, as well as the utility industry's opinion, as well as advice that we've gotten from council at that time.
And when you say the utility industry's opinion, are you speaking beyond the bounds of the state of Missouri?
Yes, both in Missouri with Missouri DNR, as you will, as well as from information that we gleaned from the Utility Air Regulatory Group.
No further questions, thank you.
Any redirect from Ameren, Missouri?
Yes, Your Honor, thank you. Just to start with that last issue, Mr. Whitworth, that you discussed with Mr. Williams about the routine maintenance, repair, and replacement test that was applied by Judge Sipple in his 2017 decision. Do you know whether he was looking at that from the perspective of whether something was routine at the unit or routine in the industry or some other perspective?
Mr. Long, I can't answer that as I sit here today.
Okay, fair enough. Why did you at Ameren, Missouri, believe that these projects at Rush Island were routine?
There are three reasons why they were considered to be routine. There was the exemption in the Missouri State Construction Permitting Rule that included items like routine maintenance and boiler tubes explicitly. There was the routine nature of the projects that had been conducted in the Ameren fleet over the years with replacements of like-kind replacements, functionally equivalent replacements of tubes, for example, reheater economizers, as well as there was consistency with routine in the industry as other companies were being both advised by, their original equipment manufacturers, the boiler providers, as well as in the industry, these types of projects were routine in nature.
There was a discussion that you had with counsel for the staff about some list that you received through the Utility Air Regulatory Group. Do you recall that discussion a few minutes ago?
Yes.
And you didn't have that list in front of you at the time you had that discussion with the counsel for staff?
That's correct.
Your Honor, can I approach and show an exhibit, schedule SCW D6 to Mr. Whitworth?
Yes, you may.
Thank you.
And did you say this was Schedule SCW D6?
Yes, Your Honor, I did, and I will also note for the record, it's one that has been marked confidential, but I don't believe, for purposes of my question, that we need to move this in camera. Mr. Whitworth, you have in front of you Schedule SCW D6 to your direct testimony in this case?
Yes.
Was that the list that you were referring to in the discussion you had with the counsel for staff?
It is.
Okay. Does it have a table of contents somewhere in the first few pages?
Yes.
And is there any reference to Ameren, Missouri at all in any of the table of contents?
No, there is not.
Is there any reference, to your knowledge, to Ameren, Missouri or any of its plants anywhere in that Schedule D6?
Not that I am aware.
I'd like to go back to a topic that you had a discussion on with Judge Clark about emission calculations. I think his question was about something you had written in your testimony about the obvious engineering conclusion was that there was no increase in emissions. And you had a discussion then with Judge Clark about that. I think his question was about whether emissions calculations were required or part of that analysis. Is it your understanding when you were answering his questions whether you were talking about potential emissions under the SIP or an actual emissions calculation?
No, I didn't understand the context.
So let's just break this down and make sure that it's clear for the record. So in determining whether a potential emissions increase would occur for a project at an existing coal-fired unit, what were the things that you would look at the time that you were making these decisions?
Well, there were several parameters, and I did try to explain our process for the judge. However, looking at potential emissions, maximum capacity of operation at a steam electric generating unit, so we're looking at primary design capability of the unit, its rated heat input, its rated steam flow. Those types of things are fundamental, and the unit is certified and insured at those levels. So step one was really looking at, was anything going to change that design rate of the generating unit, which would impact emissions. For example, if the heat input capacity was increased, potential emissions could increase. So looking at those projects, these types of projects did not cause that type of a change. The unit maintained its current design, maximum design operating capabilities.
So what sort of change, in your experience, to a coal-fired unit on the Ameren system would cause an increase in the potential emissions?
I have an example, and it was included in my testimony. But in Illinois, another steam generating unit, the Duck Creek facility, a project was scoped to increase the maximum heat input capacity of the boiler, increase the coal burning capability, and increase the maximum heat input capability to take advantage of steam turbine when it was constructed had a higher capacity than the boiler could provide steam. So for environmental services, if there was going to be that change in design of the actual unit, changing its design capabilities, that was almost an automatic for us. So that first step, the potential emissions could increase. And as I mentioned, the rules in Illinois were different, but the analogy was looking at the maximum design capability of the permitted steam generating unit change was going to increase. So then the process began to evaluate the emissions, look at the requirements, and apply for a PSD permit in that case to cover that work that was being performed.
So you're talking about the increase in the maximum capability of the boiler?
Yes.
Or some other component?
No, the boiler, the permitted coal burning emitting unit, yes.
Okay, so is there any way to change that potential coal burning capability of the boiler if you don't increase the fuel feed rate?
Not that I'm aware of.
Was there anything like that at issue in the Rush Island projects that ESD evaluated?
No, that was step one in all of these evaluations, was looking at were the primary design, rated design parameters going to be changed as a result of the project that was being proposed. And in this case, they were not being changed.
And where did you get that information?
We got that information, Environmental Services got that information from engineering, from the project engineering staff.
Was there a need to do any kind of calculation to verify what you were learning about the parameters of the project and whether it would increase potential emissions?
No, these types of, a boiler is a association of a lot of different equipment that all works together, if you will. So looking at one piece, a tube that allows steam to go through it would not have the type of change that would increase the amount of emissions or change the design capability of the unit.
So I would like to go back to where we started, which is Exhibit 22. You were asked some questions about this document by the attorney from staff. And I think her question was based upon the date of this document, which is 2011. Do you see that?
Yes.
Okay. I think her question was whether this document was in existence at the time that the permitting decisions were made by the Environmental Services Department on the Rush Island projects. Do you remember that colloquy?
Yes, I do.
Okay. And in terms of how the state was applying its SIP and what it considered triggering projects for construction permitting review, did this Exhibit 22 change from what it had been at the time that you were evaluating the projects at Rush Island?
No.
It starts on Exhibit 22 with an inquiry into whether the potential emissions increase. Do you see that?
Yes.
Was that the way that the SIP was interpreted and applied at the time
Yes.
by you?
By me as well as Missouri DNR and the other utilities in the state.
Thank you. No further questions. Oh, Your Honor, I have been corrected by my co-counsel. Mr. Whitworth is not coming back again, and I've neglected to move Exhibits 8, 9, and 22 into the record. And so I would make that motion at this time.
Any objections to admitting Exhibit 8, C, 8P, 9C, and 9P, and Exhibit 22 onto the hearing record? Any objections?
No objection.
Okay. Exhibits 8, 9, and 22 will be admitted onto the hearing record. And Mr. Whitworth, you may step down. It is now 6:19. It seems like a good time to break for the evening at this point. So
Thank you.
with that, I will adjourn until tomorrow at 9 a.m.